Court, court officer. Court officer. Court officer. Court master. Court master.
ಸರ್ ಹೇಳಿ ಸರ್.
Madam, serial number 34.
ಹಾ ಸರ್.
ಅದು ಅರ್ಜೆಂಟ್ ಮೆನ್ಷನಿಂಗ್ ಮಾಡೋದಿದೆ.
ಇಂಟೀರಿಯಂ ಆರ್ಡರ್ ಬೇಕಾ?
ಇಂಟ್ರಿಮ್ ಆಲ್ರೆಡಿ ಇದೆ, ಎಕ್ಸ್ಟೆಂಡ್ ಮಾಡಬೇಕು. ಮಂಡೇ ಇಡಬೇಕು.
ಸಾಹೇಬ್ರು ಬಂದ್ಮೇಲೆ ಕೇಳಿ ಸರ್.
ಎಸ್ ಎಸ್. ಅದನ್ನ ಆಫ್ಟರ್ ಇದು ಮೆಮೊ ಮೂವ್ ಆದ ನಂತರ ಹೇಳ್ಬೇಕಾ?
ಹೌದು ಸರ್.
ಎಸ್ ಸರ್.
Which matter? 2010 da ಬರ್ಲಿ ಬಿಡಿ ಆಮೇಲೆ. ನೋ 2010 ಇಂದ ಅರ್ಜೆನ್ಸಿ ಇರಲಿಲ್ಲ, ಈಗ ಅರ್ಜೆನ್ಸಿನಾ? ಎಸ್ let it come March 3rd ಮೇಲೆ. ಎಸ್
MTP matter.
ಎಲೆಕ್ಷನ್ ಮ್ಯಾಟರ್ಸ್ ವೋಟಿಂಗ್ ರೈಟ್ಸ್ ಎಲ್ಲ ಕೊಟ್ಬಿಡಿ. 230 ಎಲೆಕ್ಷನ್ ಎಲ್ಲ 230 ಕೊಡಿ. ಸರ್ಫೇಸಿ ಎಲೆಕ್ಷನ್ 2 ಕೊಡಿ 230. ಅದ್ರಲ್ಲಿ ಏನು ಅರ್ಜೆನ್ಸಿ? ಡಾಕ್ಟರ್ wait on the VC, wait. When was it terminated? Last Monday kodi. Monday kodi.
My lords. Transfer, my lords. I requested 230.
Transfer at 230, give it. Yes.
Lord, one matter at 230, lordship. The election to the cooperative society is scheduled on.
Elections ಎಲ್ಲ 230 ಕೊಡಿ.
My lord, it is a covered matter, my lord. There is threat of disconnection. Covered matter.
My lord, 230, yes. Wait. Huh? B group. Move it after March, yes.
My lords,
ಏನ್ ಅರ್ಜೆನ್ಸಿ ಇರಲ್ಲ ಅದರಲ್ಲಿ.
my lord, 230 matter, batch of matters before register of chits, my lords. Petition has been filed, my lords, for arbitration with concealing the fact that the matter was already put to, the disputes were already put to end in NIAC proceedings 3 years ago. Now, after 7 years of delay, now the arbitration proceedings have been instituted on the same cause of action.
Monday ಬರ್ಬೋದಲ್ಲ.
My lord, the only urgency is, my lord, tomorrow it is posted for evidence of the complainant, my lords.
ಇಲ್ಲಿವರೆಗೆ ಏನ್ ಮಾಡ್ತಾ ಇದ್ದೀರಿ?
My lords, there were criminal petitions which were filed which came to be disposed of last week, my lords. Please, my lords.
230
Please.
Which one?
Service matter. Want of documents, the matter was adjourned.
Correct.
The document has given me liberty to move the court once the documents are filed. I filed them, matter. Maybe taken up there.
230.
Yes.
Monday, yes.
My lords,
Likely to take charge today, I think.
All right, give it 230.
my lords, one matter, my lords, on Monday or Tuesday, tax matter, vacating interim order, my lords. Investigation is stalled, my lords.
ಆಮೇಲೆ move it after March.
One
yes.
matter at 230, my lords. Other similarly placed persons had filed writ petition in interim orders granted. And I am also.
My lords, one matter at next week any date will, because it was adjourned, my lords, it was adjourned, it's covered by judgment, my lord, for regularization.
Regularization.
Yes.
ಆಯ್ತು ಕೊಡಿ.
In fresh matters, my lord.
ಓಯ್ ಎಲ್ಲ ನಿಮ್ಗೆ ಬೇಕಾದ್ರೆ
It's covered by, my lord.
ಕೊಡಿ. Yes.
Please.
Tuesday.
My lords, this matter, my lords, fresh matter, it will be taken at 230.
Why?
My lords, there is chances of replacing him, my lords. They are called for a fresh
Replacing
appointment.
whom? What are you?
My lords, I'm a bill collector, my lords. The Gram Panchayat, I'm bill
Oh,
collector.
bills are being.
Yeah, I'm working from last 12 years. Please.
Submission. Your Honor, on submission. Your Honor, one submission.
Yes, what is it?
Serial number 34, Your Honor.
Adjournment.
Yes, my lord.
Adjournment.
On Monday.
Mention when it is called. Yes.
Lordship's kind.
Adjournment ಎಲ್ಲ mention when it is called.
One submission. Serial number 145, Lordship. In fact, day before yesterday, I moved.
Adjournment.
ಇಲ್ಲ ಅದನ್ನ ಸ್ವಲ್ಪ immediately after fresh matters ಮ್ಯಾರಿ.
Urgency ತಗೊಳಕ್ಕೆ.
Obla.
First fresh matter ಮುಗಿಸೋಣ. Yes, call the case.
My matter, serial number 169, may be taken up 230, my lord.
Why?
Lord, he is helper in the case artist, my lord. Lord, he is dead. The legal aids came on record. Lord,
We'll see.
benefits, my lord, have to be
ಆಯ್ತು
considered.
ನೋಡೋಣ.
At 230.
ನೋಡೋಣ.
Serial number 104,
No adjournment in the yes.
I have some
Unless you want to withdraw. Yes. Mention when it is called.
Serial number 1, DB Karigar, Sharmila M. Patil.
For petition. The bank.
Online.
Interest.
Yes, regarding interest, I produce some documents. So,
Notice was served upon him ಅಂತ ಬೇಕಲ್ಲ.
please, sir.
Right.
Yes.
Notice served upon him.
The notice has been served upon him and I produced a document list of
Which is
documents.
that, madam?
Page number 4.
Take back the money, take back money is lying, take it back ಅಂತ ಎಲ್ಲಿ ಹೇಳಿದ್ದೀರಾ
Yes.
ಅಷ್ಟೇ.
He has been asked to collect the amount.
Where, which document have you produced?
A document is at page 5. Page 4 and 5.
That is 6/6/2019. Correct?
Yes, ma'am.
6/6/2019 is a dated,
ಅಲ್ಲ.
letter dated.
ಆಮೇಲೆ
ಆಮೇಲೆ check, banker's check has been issued on 18/4/2019.
ಹಾ ಆಮೇಲೆ
ಆಮೇಲೆ I have produced the consignment stating that
ಹಾ
wherein the notice has served on the
ಯಾಕೆ ಕಲೆಕ್ಟ್
petition.
ಮಾಡ್ಕೊಳ್ಳಿಲ್ಲ ನೀವು ಇದನ್ನ?
No, my lord, this one is a banker's check, my lord.
So what? So what?
That validity it up to 3 months. Even
ಯಾವತ್ತು
yes,
ಕೊಟ್ಟಿದ್ದೀರಿ?
admittedly within time, 2 times they issued notice. But
18/4/2019.
admittedly at that time, that banker's check is within the custody of the bank.
ಹಾ
Subsequently, they failed to renew it. And now, because that banker's check issued from the funds of the bank, after lapse of 3 months, automatically that amount merge with the bank's fund.
ಹ್ಮ್.
Hence, my submission is, it
No, but
carries
why you
interest.
did not go and collect this? ನಿಮಗೆ ಬಂದಿದ್ದು ಯಾವತ್ತು ನೋಟಿಸ್? 6/6/2019.
Yes, my lord.
Check is 18/4/2019.
Yes,
It was
my lord.
still valid.
Yes.
Why you did not collect it?
But they issued notice and submitted the file affidavit stated that they tried to.
ಒಂದು
they
ನಿಮಿಷ. ಈಗ
treat-
6/6/2019 ನಿಮಗೆ ಬಂದಿದೆಯಾ?
Yes,
ಕರೆಕ್ಟಾ? This
Haven't.
18/4/2019 is the check. It was
Yes.
valid. Why you did not take it?
but they issued
But
notice.
why you did not take it?
Instead of delivering that check,
ಮನೆಗೆ ಬಂದು
banker's check.
ಕೊಡ್ಬೇಕು. ಮನೆಗೆ ಬಂದು ಕೊಡ್ಬೇಕಾಗಿತ್ತಾ?
No, my lord. My submission is along with notice that through register post or speed post, whatever may be, instead of sending that banker's check, they issued notice. Subsequently, my
Withdraw the
request
case.
is,
Sale, you may withdraw the case and collect the banker's check in excess amount. Anything else, madam?
Yes, sir. And second notice also has been served.
Hmm.
That is on 7/7. Page 7, sir. 11/7/2019.
To collect the check after withdrawing the case, conditional.
It was just requested. He could have taken under protest also, sir.
No,
Sir, my submission is, now he has not collected the check. Repeated requests were made to him.
no
They have
repeated,
gone to the
only two
house
requests
also.
in the year 2019.
They have gone to their house also. And what will happen is, this amount will be lying in the idle account, sir. And this amount
Can't
cannot be
help,
used.
madam. You should have posted the check to his address.
So check the heavy amount ಇರೋದ್ರಿಂದ
In
they
transit
can't
ಅಲ್ಲಿ
take that
ಹೋಗ್ಬಿಡುತ್ತೆ. ಯಾರು
risk.
ಬೇರೆ ಯಾರು ತಗೊಳಕ್ಕಾಗತ್ತೆ?
They are not
ಅವ್ರೇ ತಾನೇ.
take that risk. They can't take that risk. So,
Anyway, it was lying with you.
and for
The
banker's
petitioner,
check,
this court, by an order dated so and so.
I may be,
Dispose the petition.
Uh,
ಯಾವತ್ತು ನೋಡಿ ಅದು? Dispose the petition by directing the amount that was lying in the bank, i.e. the sale proceeds, to be handed over to the petitioner. The handed over to the petitioner along with interest at the bank rates that they would charge on a loan. This, the learned counsel for the respondent bank had moved the matter for being spoken to on the ground that there were notices issued to the petitioner. Despite issuance of notice, he has not collected the amount. Therefore, no interest can be directed to be paid by the bank to the petitioner for the amount that is in the bank for the fault of the petitioner. Two notices are appended to the memo being spoken to, or the memo along with documents. Both the notices clearly indicate that he has to withdraw the case and collect the amount. Therefore, it was a conditional notice that was issued. The notice that was issued. The learned counsel defends the action on the score that it was a banker's check. Banker's check and could not have been delivered, could not have been sent by registered post or any other method, and the bank did not want to take the risk. Therefore, the amount is lying idle in the bank. The submissions would not change the order that is passed. The order would remain. No further orders of tweaking the order need be passed in the case at hand.
I mean,
Much-
Yes, next.
Serial number 2, R. H. Angadi.
Now the
Then election agidiyante.
counting is complete.
Complete.
Declare.
So the application will not survive.
The learned counsel for the petitioner submits that the counting itself is complete as on today, and the petition would not survive further consideration. The submission is placed on record. The petition it was already disposed of.
Yes, ma'am.
Already
Yes.
discussed.
The submission is placed on record and there is no further orders to be passed on the memo for being spoken to. Yes, next.
Number 3, Sunil S. Desai, Suresh N.
ಏನಪ್ಪ ಇದು?
Should appear.
Appearing for the implementing.
ಏನು ARCS ಮುಂದೆ ಹೋಗಲ್ವಾ?
ಇಲ್ಲ ಕೇಳ್ಬಿಡ್ತೀನಿ.
ಹಾ.
Shivraj has made a submission along with this objection that my objection with regarding delegation of a sixth respondent has been considered and there is an order.
They are not considered Allah on the exclusion of the name of the petitioners.
Yes.
Petitioners are already before the.
No, not exclusion of the petitioner.
ಯಾಕೆ ಹೋಗಿದ್ದೀರಾ?
2 ನಿಮಿಷ ಹೇಳ್ಬಿಡ್ತೀನಿ, ತೋರಿಸ್ಬಿಡ್ತೀನಿ ಅದು.
ಆಯ್ತು. Yes.
Yes. Your lordships kindly see the page number 44 annexure N. This is the provisional selection list, provisional list, voter eligible list. In this, first name, sixth respondent name has been notified. They have called for objection. I filed objection to this. There is no question of challenging this. I filed objection, they are required to consider it. Now, can you see the next page? This is the objection. 51, page number 51. The returning officer on 16/1/2025 has directed the ARCS and the MD to look into this aspect and submit a report. 16/1/2025. Now they are contending that on 13/1/2025 itself, ARCS MD has taken a decision and forwarded it to the DC.
Where is that contention?
That is what adne kottidare.
ಇಲ್ಲ,
adne kottidare.
ಆರ್ಡರ್ ನೋಡಿದ್ದೀರಾ?
Order ನೋಡಕ್ಕೆ
ನೋಡಿ, ಇನ್ನೂ ರಿಲೀಸ್ ಮಾಡಿಲ್ಲ. See this.
Yes.
See that, ಅದ್ರಲ್ಲಿ ಏನಾದ್ರು ಇದ್ರೆ ಹೇಳಿ. ಅದನ್ನೇನು ಬರ್ದಿಲ್ಲ. You are before the ARCS. Urge every contention
No,
there.
not, it has to be by the returning officer, my lord. My prayer may kindly be seen. My prayer is for limited extent.
In fact, my lords, the prayer would become infractious.
No, that is what, this itself is not, my lord, is my.
Wait, sir. And I must direct and respond to and consider the objections raised by include the name of the petitioner eligible voters list.
This-
1 minute. What proceedings have you gone before the ARCS?
That is with regarding the resolution which has been passed by us on 10/10/1/2025. Kindly this sentence, my lord, may I read from the order. My lord?
ಹೇಳಿ.
Even before filing of the petition,
ಹೌದು.
the learned counsel submits that objections were considered and the name has been excluded. This itself is prima facie incorrect. For the reason,
Objections are not considered.
not on the exclusion, it is only the list, my lord.
Objections consider ಮಾಡಿದಾರೋ ಇಲ್ವೋ?
Illa, finalization agilla. They have referred it to the returning officer. Returning officer till today has not taken a decision.
Where is your objection? Page.
My lord,
The order put in.
page number 26. Page number 26. And the returning officer excluded, can you see, at the issuance of a final eligible voter list, he has excluded the name of the
26
sixth
is
respondent.
ಅಮಾನತ್ ಆದೇಶ.
ಇದೊಂದು ಸ್ವಲ್ಪ ಅದು ಅಮಾನ ಇದು. His name is excluded in the final voter list.
Whose name?
The sixth respondent name. Because of the pendency, no decision has been taken. Question of challenging provisional seniority doesn't arise.
Seniority list.
Seniority list, eligible voter list.
It is not excluded.
ಅವರು ಸರ್ವಿಸ್ ಮಾಡಿ seniority.
Exclude ಮಾಡಿಲ್ಲ. The only endorsement is that writ is pending subject to outcome of writ
No,
petition. ಅಂತ
his
ಬರುತ್ತೆ.
name is not included.
Anyway, we'll
Now
hear it.
kindly see page number 48.
Kindly see the
We'll hear it. Yes.
Yes, my lord.
List the orders on being spoken.
kindly see the order, my lords. His objection, his prayer itself would become infractious.
Right?
No.
Monday we'll do that.
Please.
Tomorrow is the last date for nomination, my lord.
By this, my lord, he can't be permitted to nominate, file a nomination and contest. Admittedly, my lord, I have produced the document. A resolution has been forced to delegate him.
My lords may kindly
we'll
consider.
take it at 2:30.
Alla, my lords may
One
kindly.
more submission, lordship, so that my.
Sir,
ear
ನಿಮ್ದು
may be
ಆಮೇಲೆ
put
ನೀವು
up.
ಅಲ್ಲೇ ಮಾಡ್ಕೊಳ್ಳಿ ಎಲ್ಲ. ಇವ್ರಿಬ್ಬರನ್ನ ರಿಸಾಲ್ವ್ ಮಾಡೋಣ. You don't enter the war now. Yes.
No, I am the person, I have executed that. Because we
That
are the
will see.
members, they say that they have forged my
Yeah.
signature. That is the reason
All
I
your
came before the
disputes
court.
you resolve for the ARCS.
Yes, my lord.
All right.
Yes.
Whatever dispute is there, we will
Yes.
close this. You will direct the ARCS to decide it.
No, now in
one
pursuance
submission.
of this, the affidavit which I have submitted now, ARCS, my lord, in collusion with the sixth respondent, who is the presently a president of the secondary federation.
So what?
He has influence and now he has written a letter.
I for one will not stay in elections.
No, not staying of the
No,
election. No, I am not.
Make it subject to the result of the petition.
No,
whatever has happened.
we are not,
May make
my lord, for a
one
moment.
submission.
For a moment.
Nominations, elections, ella.
Allah, for a moment, can we see that, my lord?
May make
For a
one
moment, we are
submission.
not, Lord, we are not challenging the process of election itself. Only thing is that the delegation which is required to be from my society, that is the petitioner society, the person who has to be properly delegated is the consideration.
No problem.
If,
Ella agli will consider it.
my lord, if, pardon me?
We'll make it subject to the result of the petition.
No, my lord, he can't be permitted. Now his name is currently see finance voter list.
Hange irli. That
Hange,
will
yes,
go
my
on.
lord.
I am not ordering anything.
Yes, my lord.
We'll make everything subject to the result of the petition. That's
Yes,
all.
my lord, our both the cases may be kindly seen. Let them, whoever wins, my lord, will be considered. Let,
One-
my lord.
One
let there
submission,
be-
one submission. My lords may kindly see the order passed along with my preliminary objection. His prayer itself would become infractious. His prayer is seeking a direction to ARCS to consider his objection.
Not
That objections have been considered, my lords, and order has been passed.
Which,
So
where
the
is
thing-
that order?
My lords, along with my preliminary objection, my lords, based on that, my lords, your lordship so pleased to dispose of the petition.
One nimisham.
Kindly see this.
1 minute.
Yes, my lord.
Prayer is to issue a writ of mandamus directing respondent number. Please.
Yes, Sunil, come to your point. Issue a writ of mandamus directing so and so
Yes.
to consider the objection raised by the petitioner
Yes.
to include the name of petitioner number 2 in the eligible voters list.
Yes.
What has happened to this?
This, what happened.
What happened to this?
That is why I said, kindly see page.
What happened to the consider madidara ilva?
Illa, returning officer is directed to consider it.
Where is it? Where is
Yes, kindly see page numbers.
Preliminary
can you
objection jote page number 6, my lords.
13/1/2025 ಏನಿದು?
Please. This is the order considering his objection, rejecting his objection.
Kindly see whether I have participated in this.
Minutes, sir.
Yes, yes.
Second para, my lords.
ಕೆಳಗೆ ಸಹಿ ಮಾಡಿದರೆ ಖುದ್ದಾಗಿ ಸಹಾಯಕ ಸಮಿತಿ ಹಾಯರಿ
ಒಕ್ಕಟ್ಟು ವ್ಯವಸ್ಥಾಪಕ ನಿರ್ದೇಶಕರು ಸಮಕ್ಷಮ ಹಾಜರಾಗಿ
Last day sentence.
ಸಲ್ಲಿಕೆಯಾದ ದಾಖಲೆಗಳನ್ನು
ಲಾಸ್ಟ್ನೇ ಸೆಂಟೆನ್ಸ್ ಓದ್ಬಿಡಿ ಸಾಕು. ಚುನಾವಣೆ ಆಮೇಲೆ ಹೋಗನಿಗೆ ಮುಂದಿನ ಕ್ರಮಕ್ಕಾಗಿ ಮಂಡಳಿ ತೀರ್ಮಾನಿಸಲಾಯಿತು.
ಆಹ್ವಾನೆಗೆ ಹಾಗೂ ಮುಂದಿನ ಕ್ರಮಕ್ಕಾಗಿ
ಮುಂದಿನ ಕ್ರಮ, this is the returning officer. He has to take call. Can you see this has been
His
created
objection has been considered.
after my filing
Second
a
paragraph
petition.
second
Can you see
paragraph-
annexure Q? Annexure Q may kindly be seen.
ಸೆಕೆಂಡ್ ಪ್ಯಾರಾಗ್ರಾಫ್ ಮೇ ಕೈಂಡ್ಲಿ ಬಿಸಿ.
ಸುಮ್ಮನೆ ಇರ್ತೀರಾ?
ಆಯ್ತು.
ಇಂದು ದಿನಾಂಕ 13/1/25ರಂದು ಮಧ್ಯಾಹ್ನ 12:45ಕ್ಕೆ ಈ ಕೆಳಗೆ ಸಹಿ ಮಾಡಿದ ನಿರ್ದೇಶಕಗಳು ಖುದ್ದಾಗಿ ನನ್ನ ಸಹಾಯಕ ನಿಬಂಧಕರು ಹಾವೇರಿ ಮತ್ತು ಸವಣೂರು ಒಕ್ಕಟ್ಟು ವ್ಯವಸ್ಥಾಪಕ ನಿರ್ದೇಶಕರು ಸಮಕ್ಷಮ ಹಾಜರಾಗಿ ದ್ವಿತೀಯ ಬಾರಿಗೆ ಡೆಲಿಗೇಟ್ ನಿರ್ಣಯಿಸುವ ಸಮಯದಲ್ಲಿ ನಾವು ಸಭೆಗೆ ಹಾಜರಾಗಿರುವುದಿಲ್ಲ ಮತ್ತು ಅದರಲ್ಲಿ ಇರುವ ಸಹಿಗಳು ನಮ್ಮದು ಅಲ್ಲ ಅಂತ ಪ್ರಮಾಣೀಕರಿಸಿ ನೋಟರೀಕೃತ ಪ್ರಮಾಣ ಪತ್ರದೊಂದಿಗೆ ಹೇಳಿಕೆಯನ್ನು ಸಲ್ಲಿಸಿ ತಾವೆಲ್ಲರೂ ಸರ್ವಾನುಮತದಿಂದ ಕಾಟನಹಳ್ಳಿ ಹಾಲು ಉತ್ಪಾದಕ ಸಹಕಾರ ಸಂಘದ ಜಿಲ್ಲಾ ಹಾವೇರಿ ಈ ಸಂಘದ ವತಿಯಿಂದ ಹಾವೇರಿ ಜಿಲ್ಲಾ ಸಹಕಾರ ಹಾಲು ಒಕ್ಕಟ್ಟು ಆಡಳಿತ ಮಂಡಳಿ ನಿರ್ದೇಶಕರ ಚುನಾವಣೆಗೆ ಸಂಘದ ನಿರ್ದೇಶಕರಾದ ಬಸವರಾಜ್ ಸುವರ್ಣಶೋ ಇವರನ್ನು ಡೆಲಿಗೇಟ್ ಆಗಿ ನಿರ್ಣಯಿಸಿದ್ದು ಅದನ್ನು ಪರಿಗಣಿಸಿ ಒಕ್ಕಟ್ಟು ಚುನಾವಣೆಯನ್ನು ಮತದಾರ ಪಟ್ಟಿ ಸಿದ್ಧಪಡಿಸಲು ಕೋರಿರ್ತಾರೆ. ಹಾಗೂ ಶ್ರೀ ಸುವರ್ಣಶೋ ಇವರನ್ನು ಡೆಲಿಗೇಟ್ ಆಗಿ ಒಪ್ಪಿಕೊಂಡಿರುವ ಬಗ್ಗೆ ನಿರ್ದೇಶಕರುಗಳು ವಿಡಿಯೋ ಹೇಳಿಕೆಗಳನ್ನು ಮತ್ತು ಛಾಯಾಗ್ರಹಗಳನ್ನು ಈ ದಾಖಲೆಗಳನ್ನು ಸಹ ದಾಖಲು ಮಾಡಿಕೊಳ್ಳಲಾಯಿತು. ಸದರಿ ವಿಷಯಕ್ಕೆ ಸಂಬಂಧಿಸಿದಂತೆ ಒಕ್ಕಟ್ಟು ಸಲ್ಲಿಕೆಯಾಗಿರುವ ದಾಖಲಾತಿಗಳನ್ನು ಮತ್ತು ಇಂದು ಕಾಟೇನಹಳ್ಳಿ ಹಾಲು ಉತ್ಪಾದಕರ ಸಹಕಾರ ಸಂಘ ಕಾಟೇನಹಳ್ಳಿ ಇವರ ನಿರ್ದೇಶಕರುಗಳು ಸಲ್ಲಿಸಿರುವ ದಾಖಲಾತಿಗಳನ್ನು ಮಾನ್ಯ ಫೆಡರಲ್ ಸಹಕಾರ ಸಂಘಗಳ ಚುನಾವಣಾಧಿಕಾರಿಗಳು ಹಾಗೂ ಜಿಲ್ಲಾಧಿಕಾರಿಗಳು ಹಾವೇರಿರವರ ಆಹ್ವಾನನೆಗೆ ಹಾಗೂ ಮುಂದಿನ ಕ್ರಮಕ್ಕಾಗಿ ಮಂಡಿಸಲು ತೀರ್ಮಾನಿಸಲಾಯಿತು.
ರಿಜೆಕ್ಟ್
Returning.
ಮಾಡಿದ್ದಾರೆ. Where is the objection, his
Consider.
objections are not rejected nor accepted. He glosses it over and sends it to the, ಯಾರಿಗಿದು? ಜಿಲ್ಲಾಧಿಕಾರಿ.
He is the returning officer.
Who?
DC.
He
He has to take a call. That is what my prayer is. Now kindly see, my lord, page number 4.
ಎಲ್ಲ ನಿಮ್ದೇ
ಅಲ್ಲ, ಇದು
problem
ರಿಟರ್ನಿಂಗ್ ಆಫೀಸರ್ ಅಂತಾನೆ ಇದೆ.
Create all the problems.
Now
Shall I
kindly see,
intervene,
my lord,
Lordship?
page number 4.
Wait,
This
sir.
page number 4 of memo, my memo. For a moment, for a today I have given. His contention is by resolution dated 26/12/2024, he has been delegated. 2 members' signatures were there. They were not in the station at all.
Let the deputy commissioner consider this.
Yes, my lord, he has to consider.
ಸಾಯಂಕಾಲದೊಳಗೆ ನಾಳೆ ನಾಮಿನೇಷನ್ ಇದ್ರೆ ಸಾಯಂಕಾಲದೊಳಗೆ ಕನ್ಸಿಡರ್ ಮಾಡಿ should pass orders. Inform the DC and come. The petitioner, the subject petition was disposed by an order dated so and so. Before the order could be signed, the counsel Sunil Desai has moved the matter being spoken to on the score that on a wrong premise, the wrong premise submitted by the counsel for the respondent, the petition has been disposed. Therefore, the matter is heard. The learned counsel Sunil Desai takes this court through the objections filed by him before the to be placed before the returning officer. It is only communicated to the returning officer. The returning officer is the deputy commissioner. The deputy commissioner is yet to take a decision on the matter. The decision is not taken on the score that the writ petition is pending. Therefore, the deputy commissioner shall now pass an order on the objections filed by the petitioner. ಯಾವತ್ ನಾಳೆ ಇರೋದ ಇದು?
Last date for nomination is tomorrow.
By the evening of today. ಈಗಲೇ ಅಪ್ಲೋಡ್ ಮಾಡಿ. By the evening of today, after you ask your parties to be present or whatever, after hearing the parties.
Including the members, your lordship, who are the signatories, because they are the persons they are not disputing. We are not.
All the concerned, your lordship.
After hearing all the stakeholders.
Please.
Obliged.
This said,
ಈಗಲೇ ಅಪ್ಲೋಡ್ ಮಾಡ್ಬೇಕು. ಮೇಡಮ್ ಈಗಲೇ ಅಪ್ಲೋಡ್ ಮಾಡಿಸ್ತೀನಿ. ಟೈಪ್ ಮಾಡ್ಕೊಂಡ್ ಬಂದ್ಬಿಡಿ. ಹೋದ್ಮೇಲೆ.
Please.
please, please.
ಹನುಮಂತಪ್ಪ ಹೆಂಕಪ್ಪ ಇರಾಪು ಚುನಾ ಮಕ್ಕಳು
ನಿಮ್ದು ಆಗಿದೆ.
In the last occasion, your lordship has directed to seek instruction with regard to whether he has been appointed under Rule 32. He has been appointed under Rule 32. He has been
ನೀವಿದ್ದೀರಾ?
No,
Yes.
he was appointed under Rule 32 on a temporary basis, my lord. Since he was appointed on 5/9/1999, my lord, and subsequently there were some writ petitions which were pending, my lord. Though there was a vacant, so he has been appointed, and after that, my lord, he has been appointed as per the seniority list. He was not eligible at that time, my lord, on 1/7/2002, my lord. Subsequently, an order was issued and he was placed on independent charges, my lord, again on temporary basis itself, on 2/7/2002, my lord. And at that time, my lord, he was being paid as per the Rule 32 pay allowances. ಅಷ್ಟೇ allowances ಅಷ್ಟೇ. ಅದು as per like AOS ಅಂತ ಹಿಡಿದ್ಬಿಟ್ಟು ಅದು pay scale whatever is there for the assistant office superintendent, it was only 7.5. He was 7.5%.
Pay is not important.
Only that is
Rule
the
32 ಇಡಬೇಕಾದ್ರೆ he should be eligible for promotion.
my submission is that annexure which has not been challenged, taking into consideration of my submissions, my lord, your lordship may pass the orders because he has not challenged the order which has been passed.
Of which order?
8/1/2010, my lord.
ಏನ್
That is
8/1/2010 order?
ಅದು annexure E to page number 24, my lord. Or the pay scale prakar, page number 24, annexure E. At the time of he was retired as office superintendent, so he was being rearranged. May I read it, my lord? In pursuant to the above promotion dates,
This is
so and so.
office order after
Hereby,
his retirement.
This is required to be challenged. This has not been done. Only on the basis of this, on the representation, whatever the endorsement has issued, those endorsement has been challenged, my lord.
ಇದಾದ್ಮೇಲೆ ರೆಪ್ರೆಸೆಂಟೇಷನ್ ಕೊಟ್ಟಿದ್ರಲ್ಲ?
ಅವ್ರ ರಿಪ್ರೆಸೆಂಟೇಷನ್ ಕೊಟ್ಟಿದ್ರು, ಅದನ್ನ ಕನ್ಸಿಡರ್ ಮಾಡಿ ಎಂಡೋರ್ಸ್ಮೆಂಟ್ annexure A ಮತ್ತೆ B ಇಶ್ಯೂ ಮಾಡಿದ್ವಿ.
Why have you not challenged?
18 Jan 2011 and 18th May 2010, that those endorsement has been challenged before this court.
Subsequent representations were given. That is
Represent-
rejected.
Rejected.
Subsequent challenge, that nadite, but ಆಮೇಲೆ you retired in Rule 32, is it?
ಇಲ್ಲ ಇಲ್ಲ ಆಮೇಲೆ ಅವ್ರಿಗೆ as per seniority he has been appointed as office superintendent and subsequently he has been retired.
He retires in 31/5/2006. That is what this order says. Page 24 says.
31/5/2006 he retires, my lord.
Yes. ಅರ್ಹತೆ ರಾಷ್ಟ್ರ ಸಂಸ್ಥೆ ಖಾಲಿ ಇರುವುದೇನು?
He was promoted on as an office superintendent with effect from 4/3/2006.
27/2002 he was placed under independent charge in the cadre of office superintendent.
5/6/1999.
99 is it?
99.
Yes,
Since
5,
the
6, 9.
posts were vacant, for which they were placed as on a temporary basis.
Rule 32 is that. Yes.
My lord, petitioner is senior most employee on that time.
No, one factor is, madam, if you want to place anybody under Rule
9196.
32, he should be in the zone of consideration and all other traits should be available to that person, only then Rule 32. It is just one step below promotion.
9196 seniority list, annexure F. He is the senior
We
most
should
employee.
Permit his claim.
Sir.
We should permit his claim, I guess.
But taking into consideration of my submissions, my lord.
Of course, yes.
And my objections.
Definitely.
Please.
And we'll dispose, say it as disposed. I'll pass out.
My lord,
please.
Promotion pay and
I'll
pension
record all
books.
your submissions. Your objections are here. Elaborate objections are there.
Please.
Yes.
Sub-rule.
85th amendment ಬಗ್ಗೆ ಯಾಕೆ ಹೇಳಿದ್ದೀರಾ?
ಅದು
That changed it ಅಂತ. Yes. Anyway, disposed cost. We'll pass orders. Dispose. Allowed.
Bill number 5, Jay Shetty.
May I seek my lords on Monday, my lords? May I seek, AG is appearing in this case.
ಏನಿದು?
My lord, the question is, my lord, regarding 50% of basic pay in case of, my lord, the universities teachers. What I am
Why
saying
AG
that,
is
my lord,
AG?
AG is appearing. Monday.
the earlier
ಏನಾರು constitutional
covered by the
charge
decision
ಮಾಡಿದ್ರು?
of, my lord, UP Raghavendra Acharya case, my lord, in fact.
ಅದಕ್ಕ ಬರ್ಲಿ
Yes.
ಬಿಡಿ. Yes. We'll take
But
it
they
on
are saying that, my lord, now.
27th.
Please.
25th I'm not there. 27th will take. Yes.
6, Ravi Hegde, SC Booty.
There are artisan.
Artisan. The problem is, my lord, as I understand, 99, when his promotion was effected, that seniority, my lord, I could not lay my hand for that.
Kashta.
That is the only
Put
reason.
back the clock and say it's not correct, that's not correct. Kashta. You retire ಆಗಿದ್ದೀರಾ?
Retire again, 2017 ನಲ್ಲಿ retire.
ಇದರಿಂದ ಏನಾಗಲ್ಲ.
Or else, my lord,
Create further confusion ಅಷ್ಟೇ.
to my satisfaction, my lord,
Presentation consider ಮಾಡಕ್ಕೆ ಹೇಳಿ.
because of, my lord, I'm sorry, it
No,
was
that's all
filed
right.
in 2013. I did not have.
That's all right. See, idರಲ್ಲಿ if you have to really grant this man relief, you will have to look into all three, Jarnail Singh,
Yes.
Pavitra 2, Pavitra 1.
Yes.
And then interpret why the seniority was changed, why Sunkad was
Yes.
granted promotion.
For that, my lord, I must place on record
Seniority ಬೇಕಾ?
the first seniority as well as when the other person's promotion was effected. ಅದನ್ನೆಲ್ಲ ಹಾಕ್ಬೇಕಿತ್ತು.
Only direct consideration in accordance with law.
Accordance with law.
ಹೌದು.
In accordance with law.
Obvious. Consider it illegally ಅಂತ ಹೇಳಲ್ಲ. The petitioner is before this court seeking the following prayer. The heard so and so. Facts in brief germane are as follows. The petitioner is appointed as a helper B. Synopsis ಕೊಟ್ರಲ್ಲ. Helper B on 14/11/1981 and later was promoted as helper A on 14/11/1987. In pursuant to the same recruitment process, another person by name IB Sunkad was appointed as helper B on 13/11/1981, but IB Sunkad was promoted as helper A 2 years after the promotion of the petitioner. The petitioner was further promoted as assistant artisan on 24/10/1989, and 3 years later, IB Sunkad gets promotion to the post of assistant artisan on 20th March 1992. Till the said point, the petitioner had no grievance. On 10/1/1997, IB Sunkad is promoted as artisan and later to the post of head mechanic, which is the chief artisan, with effect from 4/3/2011. Here springs the problem. The petitioner retires from service as an assistant artisan, not getting promotion as an artisan. The petitioner then knocks at the doors of the respondent, contending that he is senior throughout the career and he could not have been ignored, and the said person IB Sunkad could not have been promoted, ignoring the claims of the petitioner. Therefore, sought the same promotion, same dates on which the promotion was granted to the petitioner, granted to IB Sunkad. The learned counsel, IB Sunkad, the said representation of the petitioner comes to be rejected, and the rejection of which is challenged in the case at hand. The learned counsel Ravi Hegde, appearing for the petitioner, would contend that the petitioner was senior throughout and his claim has been ignored till the date of his retirement, and therefore the matter requires reconsideration at the hands of the respondent. Per contra, the counsel Rajshekhar Butti, appearing for the petitioner, would submit that IB Sunkad was a candidate belonging to scheduled caste. On the pursuant to the 85th Amendment of grant of consequential seniority, the IB Sunkad was promoted on 10/1/1997 ahead of the petitioner, owing to the vacancy position then and the law that was prevalent at the relevant point in time. The petitioner did not challenge it. The petitioner chose not to challenge the promotion granted to IB Sunkad to the post of artisan or chief artisan at a later point in time, only on later point in time, but sought his promotion on par with IB Sunkad. That having been appropriately turned down, there is no warrant for interference is the submission of the counsel to the petitioner. The learned, therefore narrated facts are not in dispute. The dates, the link in the chain of events are as afore narrated. The petitioner has been senior throughout, but IB Sunkad appears to have stolen a march over the petitioner in the year 1997. That is on 10/1/1997 by grant of consequential seniority to the petitioner. Therefore, the seniority to the petitioner. Consequential seniority as a concept has been tweaked, has been diluted or watered down in subsequent judgments of the Apex Court. The consideration, subsequent judgments of the Apex Court, which are not available at the time when the representation of the petitioner was considered and rejected. Therefore, the case of the petitioner requires reconsideration in the light of the law rendered by the Apex Court in the aftermath of the rejection of the representation. Therefore, I deem it appropriate to quash the impugned endorsement and direct reconsideration of the case of the petitioner strictly in consonance with law, bearing in mind the observations made in the course of the order. For the aforesaid reasons, the following order: allowed, quashed, a matter is remitted back to the hands of the corporation to consider the case of the petitioner in accordance with law and pass necessary accordance with law within 3 months. Within 3 months from the date of receipt of the copy of the order.
So number 7, Amir Ahmad.
ಹೌದಾ? ಡಿಸ್ಕೌಂಟ್ ಹೌದಾ? ಡೇಂಜರ್ ನನಗೆ ಆಮೇಲೆ ಕರೆಕ್ಷನ್ ತುಂಬ ಆಗ್ಬಿಡುತ್ತೆ ನೋಡಿ. ಇವಾಗ ಇತ್ತ ಇಲ್ವಾ? ಈಗ ಡಿಕ್ಟೇಷನ್ಗೆ ಇರ್ಲಿಲ್ವಾ? ಹುಷಾರಪ್ಪ, ಕರೆಕ್ಷನ್ ತುಂಬ ಆಗ್ಬಿಡುತ್ತೆ. ನಾನು ಅದನ್ನ ನಂಬ್ಕೊಂಡು ಫಾಸ್ಟಾಗಿ ಬರೀ ಕೊಟ್ಟೆ. ಈಗ ಕನೆಕ್ಟ್ ಆಗಿದೆ ಈಗ ಮಾಡಿ ಫಸ್ಟ್. ಆಮೇಲೆ ವಾಪಸ್ ಹೋಗೋಕ್ಕಾಗಲ್ಲ, ಇಲ್ಲ ಕರೆಕ್ಷನ್ ಮಾಡ್ತಾ ಕೂತ್ಕೋ.
Passing of Kannada examination.
Yes.
Recruitment.
Please, Your Lordship. The petitioners are challenging annexure E, Your Lordship. That is, Your Lordship, with respect to the aided teachers, regular increment to the aided teachers, Your Lordship. Upon the.
So government teachers ಗೆ benefit
Government
ಇಲ್ವಾ?
teachers ಗೆ ಆಗಲ್ಲ ಒಂದು.
ಯಾಕಿಲ್ಲ?
Your Lordship, and if at all the government teachers are eligible for that, Your Lordship, they have to pass that examination within the time 1974 to 87, Your Lordship. Admittedly in the.
You have to get the judgments, madam.
And that is not the prayer in this petition,
Prayer
Your
ಬಿಡಿ
Lordship.
madam, don't worry. Yes. Not this. There are other cases where that period of 1984 to 87 is held to be directory. It can be considered later also. That you should get. Homework. Monday. ಇದು ನನಗೂ ಗೊತ್ತು. Yes. Next.
Bill number 8. A.S. Patil, NVRG.
For the petition.
ಎಲ್ಲಿ ನಾನೇ ಬರಲಿಲ್ಲ.
Total 2 ಅಲ್ಲಿದೆ.
ಪಾಸ್ವರ್ಡ್ ಮಾಡಲ
ಪ್ಲೀಸ್.
Bill number 9. VM Shilvan, CDMD.
My lords, produce the conditional letter of intent along with the additional statement of objections, my lord, filed on 18/2/2025, my lord. 4 documents are produced, my lords. Annexure R1 is the application form, my lord, whereunder he declares that he has got title and ownership to the site that is offered. That is one aspect, my lord.
ಯಾರ್ದು? ಇವ್ರದು?
Yes, my lord. Petitioner, my lord.
All right.
Now, my lord, however, the corporation considered it as a letter of offer and therefore issued a letter of intent, my lord. As per annexure R2, my lord, the equivalent document has been also produced by the petitioner. R2 at page number 12, my lords. My lords.
ಈಗ he is the only person.
Only, yes, yes, right. And here in this conditional letter of intent was issued at para number 1. It is made crystal clear, my lord. The third line, the particular plot of the land as indicated by you, either purchased by you or leased by you.
Page, which page?
12, my lords.
Huh?
Page number 12 of my statement of
I'm at
objections. In that, my lord, para number 1, third line.
Accordingly, you are requested, Ada.
Yes, my lords. Accordingly, you are requested to procure particular plot of land as indicated by you, either purchased by you or leased to you for a minimum period of 19 years, 11 months and make available.
Who does purchase, sir? It is family property.
No, it is in joint possession. Again, the application form itself states.
ಎಲ್ಲರೂ relinquishment deed ಬರ್ಕೊಟ್ಟಿದ್ದಾರೆ, ಇನ್ನೇನ್ ಬೇಕು?
That calls for, in fact, it's not the intention of the corporation not to give, but then, my lord, the next show cause notice was issued as per annexure R3.
ಯಾರ್ಯಾರಿದ್ದಕ್ಕೆಲ್ಲ affidavit ಕೊಡಿ ಇವ್ರಿಗೆ.
Please, I'll.
Family members ಎಲ್ಲ affidavit of undertaking ಕೊಡಿ.
My lord, the other submission, my lord, since the site abuts the state highway.
That PWD has already given saying that
that is with effect from 2017, my lord. Because there was certain bar created for establishment of liquor stores along the state highways. The state government came out with that notification. But as on the date of issuance of this,
an inspection to be conducted now.
Lord, it may be today, my lord. But as on the date of,
sir, it may be today. What is all this? ಒಂದು ತಗೊಂತಾರೆ ಅಂದ್ರೆ ಅದಕ್ಕೆ ಇಷ್ಟೊಂದು ಇಂಪೆಡಿಮೆಂಟ್. Don't.
Only thing
if he is played fraud or is told something that is not there in the record, very much. PWD gives it does not, but you don't accept that. You want your engineer to go and check up?
No, my lord, that is accepted, but the date of notification calling for application, it is 17/4/2012. In the newspaper notification, it is made crystal clear that it should not abut state highway or national highway. That is the impediment, because in all identical
Which is the
cases,
notification?
that is at page number 15, my lord, annexure R4. Notice it's not the intention of the corporation not to give, my lord. In all identical circumstances, corporation has rejected the candidature which have become final, my lord. If one is granted, my lord, again it will open Pandora's box.
Your first rejection is wrong. This we will not enter into the abutting the highway and other things.
That is page number 15.
That is public safety, that we will not do it.
Page number 21, my lord.
Now, today, is it abutting the highway?
Yes, my lord. It is, my lord. In fact, this is the state highway number 73 declared under section 3 of Karnataka Highways Act 1964, and the state government cannot denotify it at all. It was only just to augment
the question of denotification of that.
They just say
cause an inspection of it. The public works, the petitioner is before this court seeking the following prayer. The application is submitted by the petitioner for allotment of an Indian Oil Corporation outlet, a petrol pump outlet. Connect agide madam? Yaar karibekadu? Buffering aagta hai. Application for the outlet. The application comes to be rejected on two grounds. One, the fact that the petitioner has given or submitted the land necessary for setting up the petrol pump, which is a family property. And the other, that the property that the petitioner has shown to be his or the family's abuts the highway. Therefore,
state highway number 73.
State highway, SH
73.
SH 73. Therefore, the PWD shall now cause an inspection of the property and place a report before this court with regard to whether the property abuts SH 73 or not. Yes.
Also, as on 17/4/2012, when the notification was passed.
As on not today. That parvaila. Yes. List the matter on 3rd March. Please.
In this case, my lords, the KSFC, my lord, loan has been taken. Haldikeri, my lords, is requested for Monday, my lords, is not there.
3rd.
Some urgency for the, my lords.
Idರಲ್ಲಿ
ಏನಾಗಿದೆ, my lords, more than 8 crores are there, my lords.
Where will I pass orders now? List on 3rd. Yes.
I have filed memo for retirement, my lords.
Adella avate nodi. Yes.
Please.
List on 3rd in the fresh matters list. Yes.
Please.
My lord, appearing for the petitioner, this is the matter where, my lord, regularization has not taken place, and on that count, my lord, even the compassionate appointment has been rejected. My lord had heard the matter on the last day. The 4th respondent had said that they wanted to file their objections. My lord, their objections is identical to what the state has filed. I've had a look at it, and it admits that the worker, the late Badigerji, he was working there since 1995. That he gave an application, his application for regularization was not considered, and now on that score, my lord, this compassionate appointment is also rejected.
Oh, this is compassionate thing.
Yes, yes, my lord. Regularization and compassion.
Objections hakidira?
Please, my lord. Yesterday I filed objections.
They admit all the records, my lord. Gram Panchayati iddaga or idro, when it got updated to a town panchayat or idro, then it got updated to a town municipal council, he was continued, and then he died.
No, that's all right. Recommendation itta ant kelidna last time. A little difficult, yes. Because compassionate appointment itself is not a right. So regularize maadi, compassionate appointment kodi, regular appointment treat maadi anta ಸ್ವಲ್ಪ difficult.
My lord, the judgment of the Supreme Court, your lordship,
on identical terms.
It's around that, my lord. It's that Uttam Singh judgment. Where the High Court had, there is a case where, my lord, the father was not regularized, and so compassionate appointment was rejected. The High Court allows the petition. The
No, no.
Supreme Court, my lord, has
Married in-
dismissed the challenge to it.
Married in harness was a regular employee.
Para 4, my
Designated
lord.
as a part-time employee.
Para 4. The case of the appellants is that the father of the respondent had not been regularized and merely grant of equivalent benefits on the principle of equal pay would not make. Here, my lord, it's an identical case. They say that he is on equal pay for equal work. That is their stand, my lord.
How ಎಷ್ಟು ವರ್ಷ ಕೆಲಸ ಮಾಡಿದ್ದಾರೆ?
My lord, 1995 onwards. If my lord may please see just
Up to the when did he die?
He died, my lord, on 4/3/2012. My lord may please see the first document, Annexure B, which is the Panchayat's resolution. My lord had asked me to file a synopsis. I've also done that. It's easier to just go through the synopsis, my lord.
Ellide?
That sequence.
Synopsis ಎಲ್ಲಿ? Synopsis. ಕಟ್ ಮಾಡಿ ಸರ್. ಹಲೋ ಮೇಡಮ್.
Para 3, my lord. The fourth respondent, my lord, Bankapura, was initially a Gram Panchayat, where the late Ningappa Badiger was working, my lord. My lord, may please see that resolution at page 19, Annexure B.
ಕನೆಕ್ಟ್ ಆಗಿದೆಯಾ? ಕನೆಕ್ಟ್ ಆಗಿದೆಯಾ? Yes, sir.
Lords, kindly see my statement of objections filed yesterday, my lords. Here, my lords, he is not at all employed against the sanction post, my lords. He is not appointed. And he was appointed as a Jadumali. In that, my lords, Annexure C, I think Annexure C, dated 2010-2020, my lords. Here, my lords, there is no post is that Jadumali. If that is, my lords, a post is created. So 1 to 9, my lords. Here, Mukhya Adhikari, Prathama Darje, Dvitiya Darje, Kandaya.
Why did you continue him for
sorry?
17 years?
Sorry?
Why did you continue him for 17 years? In what post?
No, as a lords, the
As
daily
what?
wages. Daily wages.
Right, sorry.
Because this municipal is not appointed. Is on the basis of the lords, the Gram Panchayat, the resolution passed by the Gram Panchayat. And that basis, my lords, they has appointed and is continued as a daily wages. Not as a lords, is the, and he's only at the Jadumali, is not a regular post, my lords. And it is against sanction post.
ನೀವೇನ್ ಕೆಲಸ ಮಾಡಿಸ್ತೀರೋ ಮಾಡಿಸ್ಕೊಳ್ಳಿ.
Please.
ಏನ್ ಡೆಸಿಗ್ನೇಷನ್ ಕೊಡ್ತೀರೋ ಕೊಟ್ಕೊಳ್ಳಿ. ಡೈಲಿ ವೇಜ್ ಡೈಲಿ ವೇಜ್. ಆಮೇಲೆ
that is as per Annexure C, my lords, the Gram Panchayat, and later on, my lords, it has been upgraded to the Taluka Panchayat and municipalities. So that has continued. That is admitted fact. There is no issue, lords. But the only the issue is that lords, the Jadumali post is appointed as not as a
ಡೈಲಿ ವೇಜ್ಗೆ ಪೋಸ್ಟ್ ಬೇಕಾಗಿಲ್ಲ. ಯಾವ ಪೋಸ್ಟ್ ಮಾಡಿ? Yes.
filed objection statement.
Madam?
Your Lordship.
ಏನಿಲ್ವಾ?
Gram Panchayat, Your Lordship, the petitioner was initially appointed by the Gram Panchayat, Your Lordship. Later on, Your Lordship, it's upgraded into Town Panchayat, Your Lordship. At that time, Your Lordship, as my learned colleague say, Your Lordship, the Jadumali post was not created, Your Lordship, and he was not admitted to the sanctioned post, Your Lordship. When his regular employment is not regularized, Your Lordship, there is no question of compassionate appointment only, Your Lordship. And they have not taken any approval from the Director of Municipal Administration, Your Lordship, while upgrading into Town Panchayat, Your Lordship.
ಓ ಅಂದ್ರೆ
Please.
ಅದೇ ತಪ್ಪು. ಎಲ್ಲ ಎಂಪ್ಲಾಯೀಸ್ ಹೋದ್ರು ಈಗ.
These
ಗವರ್ಮೆಂಟ್ ಇಸ್ ಕಟಿಂಗ್ ಎಟ್ ದ ರೂಟ್ ಆಫ್ ದ ಮ್ಯಾಟರ್.
ಇವ್ರ ಜೊತೆಗಿದ್ದಿರೋರು ಎಲ್ಲರೂ
ತಪ್ಪು ಅಂತ ಸರಿ ಬಿಡಿ. ವಾಪಸ್ ವಿಲ್ ರಿವರ್ಟ್ ಇಟ್ ಬ್ಯಾಕ್ ಟು ಟೌನ್ ಪಂಚಾಯತ್. ಡೋಂಟ್ ವರಿ.
this post was not created, Your Lordship. As per Annexure C, Your Lordship, only 7 posts were created, Your Lordship. Those were the sanctioned posts. Jadumali was not sanctioned only.
ನಮ್ಮಲ್ಲಿ ಅಂತ ಅವ್ರು ಕೊಟ್ಟಿರೋದು ಮೇಡಮ್.
ಅಲ್ಲ, that post was not existing, Your Lordship. That's all.
ಅದು ಟೈಟಲ್ ಅವ್ರು ಕೊಟ್ಟಿರೋದು.
ಅಲ್ಲ, ಸ್ವೀಪರ್ ಅಂತನೂ ಇಲ್ಲ, ಯಾವುದು ಇಲ್ಲ.
He's a sweeper. Yes.
Please, my lord, Jadumali, may say this, that may not be the correct term also, my lord.
Colloquial term which should not have been used any
ಅಲ್ಲ, synonymous word
Under the Devaraj versus government, they passed a resolution in the 1970s that
That it
no
should
such
not be
terms would be used. Yes, Paura Karmika should be used out of respect for the workers. But
Exactly.
idರಲ್ಲಿ continue ಮಾಡ್ತಾರೆ.
That should not be used. Yes. Sweeper ಅಷ್ಟೇ, that's all.
And annexure C ಇದೆ ಅವರು.
That's how ಪೌರ ಕಾರ್ಮಿಕ ಸ್ಕೀಮ್.
Please.
ಏನೇನೋ ಕರಿತಾ ಇದ್ರಿ. ಇದೊಂದೇ ಅಲ್ಲ, ಬೇರೆದಕ್ಕೂ ಏನೇನೋ ಇತ್ತು. So all that was taken away then. Yes. The petitioner.
And one more submission, Your Lordship. The petitioner's father, Your Lordship, passed away in the year 2012 only, Your Lordship.
Correct.
And in the year 2021, they are seeking for compassionate.
When did
Your
you
Lordship.
reject it?
And
2020.
for 10 years, for 10 years they survived.
You kept the application pending
the
for 10 years.
compassionate appointment is given for the immediate. Please, Your Lordship. For 10 and 12 years, Your Lordship, they can survive without.
What does immediately? 10 ವರ್ಷ ಇಟ್ಕೊಂಡ್ರೆ you can't make their fate hang in balance.
It's not the right of the petitioner, Your Lordship, to claim the compassionate amount.
All that I'll answer.
Please.
The petitioner is before this court seeking the following prayer. The petitioner is the son of one Ningappa Badiger. Ningappa ಅಲ್ಲಿ ಹರ್ಡ್ ಸೊ ಫ್ಯಾಕ್ಟ್ ಶೆಡ್ ಎಂಬರೇಟೆಡ್ ಎಲ್ಲ ಮಾಡಿ. Ningappa Badiger is employed by the fourth respondent on daily wages as a sweeper or a paura karmika in the sweeper ಅಂತ ಹಾಕ್ಬೇಡಿ, as a paura karmika. Fourth respondent yaru? In the fourth respondent Bankapura Town Municipal Council. The appointment comes about on in the year 1995. The averment in the petition is that it was against a sanctioned post. On 2/1/1997, it transpires that the state government issues a circular observing that compassionate appointments to the heirs of daily wage workers who die when their regularization is under consideration should be considered on its merit. It transpires that the father of the petitioner, observation yavagayitu Clifton? It transpires that the father of the petitioner was further continued in Bankapur Town Panchayat with effect from 17/6/1999. Pursuant to a resolution of the Panchayat when the Panchayat was upgraded from a town municipal council to a town Panchayat in the year 1999. It transpires that Bankapur Town Panchayat later passes a resolution on 2010-2000 absorbing the employees of the erstwhile Bankapur Gram Panchayat, including the services of the father of the petitioner, to bring the employees under the minimum minimum wage of the post that they occupied. Therefore, he was granted equal pay for equal work. The fourth respondent Panchayat was upgraded to town municipal council, and the services of the father of the petitioner was again continued. The The father of the petitioner, on completion of 10 years of service as a Paura Karmika in the fourth respondent, submits a representation seeking regularization of the services on 30/11/2006. It transpires that on 6/9/2007, several of the employees who were absorbed and continued in Bankapur Gram Panchayat were regularized, but the petitioner was not. By then comes the judgment in the case of judgment of the apex court in the case of Uma Devi. The petitioner thus continued as a Paura Karmika on daily wage basis, but on equal pay for equal work, but bringing him under equal pay for equal work. On 4/3/2012, the father of the petitioner dies. He dies in harness. Next paragraph. After the death of the father of the petitioner, an application comes to be made by the petitioner on 29/4/2012, seeking appointment on compassionate grounds. For 8 years, no order is passed. The fourth respondent issues an endorsement rejecting the claim of the petitioner only on 6/10/2020 on the ground that the services of the petitioner, service of the father of the petitioner was not regularized. It is the rejection that has driven the petitioner to this court in the subject petition, which is immediately filed by the petitioner. The learned counsel Clifton Rosario, appearing for the petitioner, would vehemently contend that all the persons who were appointed along with the petitioner in different posts were all regularized in the year 2007, owing to the fact that they had all completed 10 years of service as on the date of consideration of their cases for regularization. The petitioner's case was not considered, but was continued in employment till the date of his death. On 4/3/2012, he dies in harness. By then, had completed 17 years of service in the fourth respondent Panchayat, without any break, or the appointment, the continuation was never litigious. The learned counsel would further contend that the direction should be issued to consider the case of the petitioner for regularization, and on that score, consider the application of the petitioner for appointment on compassionate grounds. He would seek to place reliance upon the judgment of the apex court in the case of State of Uttar Pradesh versus Uttam Singh, 2021, 17 SCC, page 653, to buttress his submission. Per contra, the learned counsel for the fourth respondent and the HCGP would in unison contend that the case of the petitioner cannot be considered on twin score. The first score is that the petitioner was never appointed to a sanctioned vacant post. His designation was that of a Jadumali, which post was never existing in the corporation, in the fourth respondent. But the counsel for the fourth respondent would confirm that he had joined the service in 1995. He has continued till the date of his death on 4/3/2012. The learned AGA, the other circumstance is that the service of the petitioner was never regularized. Compassionate appointment is not a right, but not a right to claim in any and every case. Unless the father of the petitioner had been regularized, the claim of the petitioner for compassionate appointment cannot even be put forth, is the submission of both the counsel for both the HCGP and the counsel for the fourth respondent. I have given my son. Therefore, narrated facts are not in dispute. The issue is whether the petitioner would be entitled for consideration of his case for appointment on compassionate grounds. The certain dates are required to be reiterated. In 1995, the petitioner is appointed as a Paura Karmika in the fourth respondent, the then Bankapur Gram Panchayat. Which circular is that? 1997.
Two one 1997.
Annexure K.
Annexure. That annexure K are marked here, but I don't know in what is that.
Okay.
ಹೌದು.
Annexure K ಅಂತ ಮಾರ್ಕ್ ಮಾಡಿದ್ದಾರೆ ನಮ್ಮ ಕೊಟ್ಟಿರೋ ಕಾಪಿಯಲ್ಲಿ.
Clifton. ಇಲ್ಲಿ ಇಲ್ವಾ? Unmute ಮಾಡಿ. ಇನ್ ಮತ್ತೆ ಕರ್ಸಿ ಮೇಡಮ್ ಅವ್ರನ್ನ.
Oh, sorry, I apologize. I was muted, my lord. At annexure B, the panchayat resolution, that refers to any joint work. At page 20, my lord.
A circular comes to be issued by the state on 2/1/1997 to consider those cases of consider those applications seeking appointment on compassionate grounds of those employees who die in harness just before the regularization order could be passed. The circular reads as follows.
My lord, it's at page 33.
ನಿಮ್ದಲ್ವಾ?
ಅಲ್ಲ ಹೌದು, ಇದರಲ್ಲಿ ಮೇಲೆ ಹೇಳಿದಂತ ದಿನಾಂಕ 1/7/84ಕ್ಕಿಂತ ಮುಂಚೆ ನೇಮಕವಾದ ದಿನಗೂಲಿ ನೌಕರರ ನೇಮಕ. In this matter, your lordship, the petitioner is appointed in the year 1995, your lordship. Second paragraph.
So and so. The said circular of the government was slightly qualified. The qualification was that the employees who die in harness should have been appointed between 1/7/1984 to 6/8/1990. 6/8/1990. The petitioner, in the teeth of the aforesaid circular, the petitioner was then continued in service. The continuance is not in dispute. The uninterrupted continuance is also a matter of record. The petitioner then dies in harness on 4/3/2012. Immediately thereafter, the petitioner submits an application seeking appointment on compassionate grounds, i.e. on 29/4/2012. All the aforesaid are a matter of record and admitted facts. On 6/10/2020, 8 years later, the application of the petitioner comes to be rejected solely on the ground that the father of the petitioner was not regularized. The petitioner then presents the subject petition. The issue now, as observed, would be whether the petitioner should be considered for appointment, application of the petitioner should be considered for appointment on compassionate grounds. In somewhat similar circumstance, the apex court in state of Uttar Pradesh versus Uttam Singh Supra has held as follows. Para 4, 3 in the neck. 2 in the neck. 2. Well, the apex court holds that employees who were designated as part-time employees and working on a regular basis and died in harness is to be construed to be a regular employee, and thereby entitling the respondent therein to be considered for appointment on compassionate grounds. If the application of the petitioner had met its consideration in the year 2012 itself, the petitioner would have known his fate or challenged the same. The fourth respondent keeps it for 8 long years and for the first time rejects the application in the year 2020. The petitioner is therefore before this court immediately. The Nande on judgment is there.
I placed it on record, my lord. It's with my memo of citation, serial number 6, Ritik N and another versus Deputy Director of Public Instructions.
1 minute. Yes.
See, page number 51. It's on the exact point, my lord. Paras 14, 15, and 17.
Yes. Therefore, by keeping the application pending for a long time, now the state cannot project that the family has survived for all these years without the earning of the sole breadwinner, and therefore the compassionate appointment cannot be considered. It would have been altogether a different circumstance if the application itself had been filed after 8 years, the application is filed within 45 days after the death, it is kept pending for 8 long years. In such circumstances, this court in so and so, Madam Flag is there, has held as follows.
Paras 14, 15 and 17, my lord, are relevant.
Para 14, 15, 17. In the light of both the issues being answered, one by the judgment elucidation of the apex court and the other by this court quoted supra, the application of the petitioner would merit reconsideration at the hands of the respondent. Therefore, reconsider hands for the aforesaid reasons the following order. The petition is allowed, so and so stands quashed. The respondent shall now reconsider the case of the petitioner for appointment on compassionate grounds, bearing in mind the observations made in the course of the order by passing necessary orders in accordance with law. Any document that is necessary from the hands of the petitioner for resolution of the list could be solicited from the hands of the petitioner. The said order shall be complied with within 3 months from the date of receipt of the copy of the order. Yes.
Grateful, my lord.
Yes.
Bill number 12, Santosh Kumar, Bhushan B. Kulkarni.
My lords have directed me to secure the records, my lords, of recruitment.
Methodology adopted 6 and 7.
Please, my lords. Those records are the same records, my lords, which are produced in the petition copy.
Very well.
Very Just now I received.
Then we'll hear it.
Please.
We'll post it in B group and hear it. List the matter on 3rd March in B group. Yes. Next.
13, without order, Shivraj P.
Merit
Mukherjee.
list is annexed to the petition. Merit list is annexed to the petition. Merit list is annexed to the petition. The respond number 4 and 5, by misusing their position and power, induct their kit and kin to the present posts.
That is why this has to be heard. We'll see. Yes. Fresh matter have dispose ಮಾಡಬಹುದು ಅದು ಮಾತ್ರ.
Date may.
Appear for the respond.
Elected to compulsory retirement. So other
compulsory retirement.
Please,
But charges are grave. 34 lakhs have been misappropriated while you was not
You
serving.
should have dismissed. Why compulsory retirement? Taking a lenient view.
Totally against 5 persons charge. Against 5% charge has been proved, my lord. Against the 4 persons, only one increment has been deducted, my lord. Again, this person they have directed to compulsory retirement.
Are they of the same transaction?
No, please, madam. Please.
Same charge sheet.
Same charge sheet.
Take me to that.
Not one submission. Not this petitioner. Not he is a main person who caused misappropriation. They are the superior officer, not verified, not inspected the record. This is a charges against them. He is a main person and he repaid them. Not he admitted. He repaid the 22 lakhs rupees, admitting not the charges during the course of inquiry. Not read petition itself. He admitted that he has paid the amount.
What
He
happened,
paid-
my lord?
Vapas yaak kottri?
My lord, what happened, my lord?
Para 19.
All persons have pressurized me, my lord, to deposit the amount, my lord. I have, my lord, in respect of charges have been proved against the all persons, same charges, my lord. But,
Compulsory retirement ಗೆಲ್ಲ benefit ಸಿಗುತ್ತಲ್ಲ?
but what happened, my lord? Only when I have deposited the amount, my lord, on that basis, my lord, directed me. But charges have been proved against all 5 persons, same charges, my lord. May I take the attention, my lord?
But why did you give back the money? That's the problem.
But totally amount I have deposited, my lord.
ಎಲ್ಲರೂ ವಾಪಸ್ ಕೊಟ್ರಾ?
But
ಎಲ್ಲರೂ ವಾಪಸ್ ಕೊಟ್ರಾ?
they have given on record, they have not given, my lord, but off record they have handed over. It is fact, my lord. I am submitting fairly before this court, my lord.
ಇರ್ಬೋದು.
Please, it is fact, my lord.
What can be done?
My lord, that's why I am requesting, my lord, when charges have been proved against all 5%, same charges can be proved, my lord.
But the added circumstances you have given back the money.
But charges, my lord, when I have submitted, my lord,
Enquiry ಮಾಡಬೇಕಾಗಿರ್ಲಿಲ್ಲ. Admission of guilt by returning the money over.
my lord, what happened, my lord? At the time of enquiry itself, I have given application, my lord. I am ready to deposit the amount, my lord. So therefore, my lord, after enquiry, my lord, conducting, may I take the attention to the enquiry, my lord? Enquiry report, my lord. All charges have been proved against all
So all
5%,
right, sir, why
my
you
lord.
need to give back?
When I am fairly submitting before the court, my lord, as well as before the officials, my lord.
Sir, ನೀವು fairly submit
Yes, my lord.
ಮಾಡ್ಬಿಡ್ತೀರಾ?
Yes, my lord. Even,
Judgment ಬರಿಬೇಕಾಗಿದೆ.
even petitioner is also fairly submitted, my lord, he has deposited.
Is not tested there. Or my judgment is tested.
What happened, my
That's
lord?
the problem.
When charges has been proved against all 5 persons in same charges, my lord.
ಮತ್ತೆ ಅದನ್ನ ಹೇಳ್ತಾರೆ ಒಂದ್ಸರಿ ಹೇಳಿದ್ರೆ
I
ಗೊತ್ತಾಗ್ತದೆ.
agree, my lord. Therefore, I requesting, my lord.
Lord, appellate authority, regional authority, original authority, all are not 4 authorities have not
Increment, more increment can be cut, my lord.
You have done it,
My lord.
but for your admission.
Up to the, you know, maybe, you know, 3 to 4 lakh I have to pay, my lord. I am ready to pay. Then only they can give, my lord.
I cannot pass all.
In similar circumstances, same officials have passed.
ವಾಪಸ್ ಕೊಟ್ಟಿದ್ದಾರೆ. Please. ಅವ್ರು ಮಾಡ್ರಿ, ಅವ್ರು ಮಾಡ್ಲಿ ಬೇಕಾರೆ. ಆರ್ಡರ್ ಮಾಡಕ್ಕಾಗಲ್ಲ.
65 lakh, my lord. Operator.
Yes, ನೀವು ತಗೊಂಡು ಮಾಡಿ ಬೇಕಾರೆ.
But out of 31 lakh, 22 my lord he has
You
paid.
take, sir, you want to take the fact that money, pass some order,
Please.
I will direct.
Please.
But I will not pass an order that you should,
Can be remand, my lord. In same circumstances, my lord, they have taken the amount, my lord. They have.
ಅದು ಅವರು, sir, they can do anything.
I may kindly be permitted to file necessary application for on the
ಅದು
basis of
ಮಾಡಿ.
this.
Please.
ಅದು ಮಾಡಿ. But ನೀವು ಆ 22 lakhs ವಾಪಸ್ ಕೊಟ್ರದಿಲ್ಲ ಅಂದ್ರೆ, I would have
Fairness,
allowed
my lord, I have submitted
it
fairness.
right away. Otherwise, ಕಷ್ಟ.
Please, I may kindly be given liberty to file application on the basis of these order passed by the circumstances.
ಅಲ್ಲಿ ಅವ್ರ ಮುಂದೆ
Yes, please, please.
Your lordship disposal.
Please.
The petitioner is before this court seeking the following prayer. The petitioner, details ಹೇಳ್ಬೇಕಾ?
ಎರಡು ಕೊಟ್ಟಿದೆ. ಗಿರೀಶ್
Sadiq.
The petitioner was appointed as a junior assistant in the KPTCL and was later posted to work as junior assistant finance in the finance department at Shiggaon. On 9/10/2015, the petitioner is placed under suspension in pending initiation of a departmental inquiry. Charge sheet was issued against 5 persons on the allegation of
18 persons against.
On 18 persons on the allegation of loss of funds. It transpires that the inquiry was conducted against 5 persons by a common charge sheet.
18 persons.
18.
Please, my lord.
All the 18 persons by a common charge sheet. While the common charge sheet was issued, after the issuance of the charge sheet, during the conduct of the inquiry, it transpires that the petitioner deposited 22 lakhs.
22 lakhs.
22 lakhs from his own funds.
24 lakh, my lord.
24 lakhs from his own funds. After the deposit of the said amount, charges were held to be proved against the petitioner and 5 others.
And 4 others.
And ನೀವೇ 5 ಅಂತ ಬರ್ದಿದೆ.
1 to 5.
Petitioner and 4 others. The 4 others. To the petitioner, penalty of compulsory retirement is first ಏನ್ compulsory retirement ಮಾಡಿದ್ರೆ ಏನ್ ಮಾಡಿದ್ರು? Penalty of compulsory retirement is imposed, and to all other 4 who were held guilty along with the petitioner, penalty of stoppage of or withholding of increment was passed. Therefore, the petitioner is before this court on this score.
Appeal filed. He filed an appeal.
Solid. All the departmental remedy that was available to the petitioner have been exhausted.
Yes.
Therefore, the petitioner is before this court in the subject petition. The learned counsel appearing for the petitioner submits that the act of the respondent is discriminatory in as much as to all the 5 persons who were held guilty, charges were the same. The penalty differs. Penalty to other 4 is stoppage of increment. To the petitioner is compulsory retirement. He would submit that the same penalty should be imposed against the petitioner as well. Per contra, the learned counsel appearing for the respondent Shivraj Mudol submits that the petitioner was chosen to impose penalty because he had admitted the guilt. Admission of guilt is by way of deposit of the amount of 24 lakhs, which was the large chunk of the misappropriated amount. the learned counsel would submit that such person should not be shown any indulgence. Insofar as the penalty that is imposed to others, the learned counsel would justify on the score that they were all in the supervisory jurisdiction. Who was handling the cash was the petitioner. The learned counsel for the petitioner at this juncture would submit that he would submit an application or representation to the respondents to consider his claim for imposition of penalty as was imposed to others. In the light of the deposit made, he would seek to place reliance upon several orders of the KPTCL, where minor penalties are imposed upon all persons after their return of the amount. Therefore, the petitioner submits that he also be given the liberty to file an application enclosing all the penalties that the KPTCL has imposed, which are minor penalties after they have received the amount of alleged misappropriation. The submission, in the light of the said submission, without going into the merit of the matter, I deem it appropriate to permit the petitioner to file an application or / representation to the KPTCL, enclosing all the necessary documents. If an application of that kind is filed, the KPTCL shall pass necessary orders within 8 weeks thereafter, 8 weeks after filing of the application.
Much obliged.
Ordered accordingly.
Please, man. Grateful, man.
ಅಷ್ಟೇ ಇಲ್ಲ, ನಾನು
Please, man.
ಮಾಡಕ್ಕಾಗಲ್ಲ.
ಏನಿರ್ಲಿಲ್ಲ, please.
Number 14, AP Patil, P. Jagdish, Yuvraj P. Mudra.
My lord, I appear for the respondent.
This is the caste certificate matter, my lords.
Ah.
Annexure A, A1 and A2, my lords, are the school living certificates indicating, my lords,
I
that.
know that.
Please, my lords.
ಇದ್ರಲ್ಲಿ ನೀವು
Lord, earlier, ನಾವು ರಿಮೈಂಡ್ ಮಾಡ್ತೀನಿ ಅಂತ ಹೇಳಿದ್ರಿ ಸ್ವಾಮಿ.
ರಿಮೈಂಡ್ ಮಾಡ್ತೀನಿ.
Your lordship may kindly see annexure J, my lords. That is the punch dust which has been produced.
That's in your favor.
That is in my favor. And then a Tahsildar, my
Panchas,
lords.
how can they say, my lord? Panchas, whether they got a sanctity.
ಅವ್ರು ಮುಗ್ಸಕ್ಕಾರು ಬಿಡಿ. Yes.
And then the Tahsildar, my lords, has written to this Department of Social Welfare, my lords. That is also, my lords, in favor of this petitioner. And this is the third round of litigation, my lords. The caste certificate of the brother of the petitioner as well as sister, my lords, which have been produced at annexure D and E, that also indicates, my lords, that they belong to Bovi caste, my lords.
Those caste certificates are still valid?
Please, my lords.
ಆಮೇಲೆ
And, my lords, the finding, my lords, of the first respondent appellate authority, my lords, that the brother of the petitioner had received some amount as belonging to Sunagar community, my lords. Last date, my lords, it was mentioned, my lords, that the same has been, my lords, refunded, returned also, my lords, that it was wrongly.
Let's see. Heard reserved. Yes.
Please, my lords.
Next.
ಅಲ್ಲ ತಾವು ರೂಲ್ ಸಬ್ ರೂಲ್ 4 ಆಫ್ ರೂಲ್ 7 CRECL ಗೆ ಡೈರೆಕ್ಷನ್ ಕೊಟ್ಟು DCBC ಮಾಡೋ ತರ ಮಾಡಿ ಸ್ವಾಮಿ. ಇಲ್ಲ ಅಂದ್ರೆ ಏನಾಗುತ್ತೆ?
We'll see.
My lords,
Truth will come out.
ಬ್ರದರ್ ಸಿಸ್ಟರ್ ಕ್ಯಾಸ್ಟ್ ಸರ್ಟಿಫಿಕೇಟ್ ಅಲ್ಲಿ ವ್ಯಾಲಿಡ್ ಇದೆಯಲ್ಲ?
Valid.
ಅಲ್ಲ ಅದನ್ನ ವೆರಿಫಿಕೇಶನ್ ಮಾಡಿಲ್ಲ ಇನ್ನ, ಅದು ಸರ್ಟಿಫಿಕೇಟ್ ಇದೆ, ದಟ್ ಹ್ಯಾಸ್ ಟು ಬಿ ವೆರಿಫೈಡ್ ಅಲ್ಲ ಸ್ವಾಮಿ.
ಎಷ್ಟು ವರ್ಷದಿಂದ ಇದೆ ಸರ್ಟಿಫಿಕೇಟ್
My lords,
ಅವ್ರಿಗೆ?
annexure D and E, my
ಬ್ರದರ್
lords.
ಅಂಡ್ ಸಿಸ್ಟರ್.
Please, my lords.
ಇವ್ರದ್ದು ಅಪಾಯಿಂಟ್ ಆದ್ರೂ ವೆರಿಫಿಕೇಶನ್ ಬಂತು ಗೊತ್ತಾಯ್ತು, ಅದನ್ನ ವೆರಿಫೈ ಮಾಡಿದ್ರೆ ಎಕ್ಸ್ಪೋಸ್ ಆಗೋಗುತ್ತೆ ಸ್ವಾಮಿ.
21 in the 21 certificate.
2021.
And, my lords,
ಅವ್ರಿಗೆ
3 ವರ್ಷದಿಂದ ಇದೆ. ಕಾಸ್ಟ್ ಇಸ್ ಬೈ ಬರ್ತಲ್ಲ ಸ್ವಾಮಿ.
ಅವ್ರದೇ ಬ್ರದರ್
ಒಟ್ಟಿಗೆ ಕೊಟ್ಟಿರೋದಾ?
ಇಲ್ಲ, ಬೇರೆ ಬೇರೆ ಇದೆ, my lords.
Let's see. Yes.
And, my lords, may I place the decision of the coordinate?
Give.
The report of the Tahsildar, my lords, is in favor of the petitioner. In such circumstance, my lords, there is no ground, my lords, to.
ಇದರಲ್ಲಿ ತಹಸೀಲ್ದಾರ್ ರಿಪೋರ್ಟ್ ಇಸ್ ಇನ್ ಯುವರ್ ಫೇವರ್.
Please, my lords.
Yes.
ಅರ್ಲಿಯರ್ ತಹಸೀಲ್ದಾರ್ ರಿಜೆಕ್ಟ್ ಮಾಡಿದ್ದಾರೆ ಸ್ವಾಮಿ. ತಹಸೀಲ್ದಾರ್ ಹ್ಯಾಸ್ ರಿಜೆಕ್ಟೆಡ್. ಸಬ್ಸಿಕ್ವೆಂಟ್ ಆಗಿ ಫೇವರ್ ಕೊಡ್ತಾರೆ.
Why was it given, sir? ನಿಮ್ ಸರ್ಕಾರದವರೇ ತಾನೆ.
ಎಲ್ಲ ತಮಗ್ ಗೊತ್ತು ಸ್ವಾಮಿ, ರೆವಿನ್ಯೂ ಇನ್ಸ್ಪೆಕ್ಟರ್ ರೆವಿನ್ಯೂಗೆ ತಗೊಂಡು ಏನ್ ಬೇಕಾದ್ರೂ ಮಾಡ್ತಾರೆ. ತಮಗ್ ಗೊತ್ತಿದೆ, ಅದು ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ಹೇಳಿದೆ ಲೇವಟ್ಗಿರಿ ಕೇಸಲ್ಲಿ. ಇನ್ ಕೊಲಯನ್ಸ್ ವಿತ್ ದಿ ಅಫಿಷಿಯಲ್ ದೇ ಗಿವ್ ಸರ್ಟಿಫಿಕೇಟ್.
Yes, that's next.
Please,
Number 15, A. Patil, VG Bhatt.
This is the matter where only twofold submissions were made on the last occasion. One is
The inquiry officer has issued the charge sheet. And the second one is violation of the principles of B. Karunakaran case.
As in the last occasion, there was one
Stand back.
point, my lords. The inquiry officer who is appointed by the disciplinary authority, he is junior than ಅಂತ ಹೇಳಿತ್ತು. My lords, he has power.
Sorry?
He
Inquiry office, dispute authority ಗಿಂತ senior inquiry officer ಅಪಾಯಿಂಟ್ ಮಾಡ್ಬೋದಾ?
ಇಲ್ಲ ಅವ್ರ junior.
ಯಾರು junior?
Who was appointed as an inquiry officer is a ADM, my lords.
He is not senior to.
He is not
senior to the discipline authority?
Like he is
not. Inquiry officer junior has issued me the charge sheet.
Inquiry officer junior ಅಂದ್ರೆ?
ಈಗ enquiry ಸಹಾಯಕ ವಿಭಾಗ ವ್ಯವಸ್ಥಾಪಕರು ಧಾರವಾಡ.
Who is your discipline authority, sir?
That is managing director.
Who has issued the charge sheet, sir?
The person who was appointed as inquiry officer, that is ಸಹಾಯಕ assistant divisional manager, his assistant issues me the charge sheet.
ಏನೇನು ಸೌರಭ್?
ಅಲ್ಲ 40 ತಗೊಳ್ಳಿ ಸ್ವಲ್ಪ ಪೇಜ್ 40. ಪೇಜ್ 40 ಅಲ್ಲಿ
ಈಗ ಶಿಸ್ತು ಪ್ರಾಧಿಕಾರಿಗಳು,
ಶಿಸ್ತು ಪ್ರಾಧಿಕಾರ ಮತ್ತು
ಡಿಸಿಪ್ಲಿನರಿ ಅಥಾರಿಟಿ,
ಕಾರ್ಯನಿರ್ವಾಹಕ
ನಿರ್ದೇಶಕರು, ಮ್ಯಾನೇಜಿಂಗ್ ಡೈರೆಕ್ಟರ್. He is the disciplinary authority.
Yes, ಮೇಲೆ ಒಂದ್ ಸ್ವಲ್ಪ 6-12-2005 ಸಹಾಯಕ ವಿಭಾಗೀಯ ವ್ಯವಸ್ಥಾಪಕರು ಧಾರವಾಡ ವಿಭಾಗ ಇವರನ್ನು ಅರಣ್ಯ ವಿಚಾರಣಾಧಿಕಾರಿಯಾಗಿ ನೇಮಿಸಿ ವಿಚಾರಣೆ ಆಗಿದೆ.
ಶಿಸ್ತು MD has appointed
ಸಹಾಯಕ ವಿಭಾಗೀಯ ವ್ಯವಸ್ಥಾಪಕರು. ಅಲ್ಲ, 1 second. This inquiry officer himself issues the charge sheet.
ಅದು ಹೇಳಿ.
Yes.
Senior ಎಲ್ಲ ಯಾಕೆ ಬೇಕು? Where is this charge sheet issued by the inquiry officer?
Page 30, it starts page 31 typed copy. Page 30 ಅಲ್ಲಿ charge sheet is issued by ವಿಭಾಗೀಯ ವ್ಯವಸ್ಥಾಪಕರು ಕರ್ನಾಟಕ ಅರಣ್ಯ ಅಭಿವೃದ್ಧಿ ನಿಗಮ ಧಾರವಾಡ.
ಈಗ ವಿಭಾಗೀಯ ವ್ಯವಸ್ಥಾಪಕರು ಅಂದ್ರೆ ಯಾರು?
Divisional manager. He is the inquiry officer.
ಸಹಾಯಕ ವಿಭಾಗೀಯ ವ್ಯವಸ್ಥಾಪಕರು ಅಂದ್ರೆ ಯಾರು?
Assistant divisional manager.
Yes. Correct. Assistant divisional manager is appointed as inquiry officer.
Yes.
All right. Now charge sheet is issued by divisional manager.
Yes.
This disciplinary authority is somebody else.
Charge
sheet is issued by somebody, inquiry officer is
conducted by somebody.
You leave inquiry officer, parvaila, he can be anybody. Now, why did the charge sheet go from divisional officer?
My lords, he was appointed to submit a report and he received.
He was not appointed to submit the report.
Inquiry officer was.
And who was the inquiry officer?
ADM, my lords.
Additional divisional manager.
Please.
Who has issued the charge sheet? Now, there cannot be 2-3 disciplinary authorities. See, disciplinary authority is the managing director.
Disciplinary authority is managing director.
All right.
Or conservator of the forest.
He only should issue the charge sheet. Inquiry officer cannot issue the charge sheet.
The order was passed by the ED, my lords, conservator of the forest.
ಸುಮ್ಮನೆ ಅವ್ರಿಗೆ ಚಾರ್ಜ್ ಶೀಟ್ ಇಶ್ಯೂ ಮಾಡ್ರಿ ಅವ್ರಿಗೆ ಅಂತ ಹೇಳಕ್ಕಾಗಲ್ಲ. It is his job. All right, 2 things. Inquiry officer cannot issue the charge sheet, cannot recommend penalty. Prove ಆಗಿದೆಯಾ ಇಲ್ವಾ ಅಷ್ಟೇನೆ ಒಂದು. ಆಮೇಲೆ ಡಿಸಿಪ್ಲಿನರಿ ಅಥಾರಿಟಿ ಇವರು ಅಂದ್ಮೇಲೆ ಇವರೇ ಚಾರ್ಜ್ ಶೀಟ್ ಇಶ್ಯೂ ಮಾಡಬೇಕು. He cannot delegate the function of issuance of charge sheet to anybody.
Now the annexure F, where the petitioner is seeking quashing, it is issued by the assistant ಕಾರ್ಯನಿರ್ವಾಹಕ ನಿರ್ದೇಶಕರು.
What is that annexure F?
That is punishment order issued by executive engineer.
Executive director, who is the disciplinary authority? He is nothing but conservator of the forest.
Sir, ಇಲ್ಲಿ ಯಾರು ಕಾರ್ಯನಿರ್ವಾಹಕ ನಿರ್ದೇಶಕರು ಯಾರು?
ಎಕ್ಸಿಕ್ಯೂಟಿವ್ ಡೈರೆಕ್ಟರ್ ಶಿವಮೊಗ್ಗ.
ಶಿಸ್ತು ಪ್ರಾಧಿಕಾರಿಗಳು ಮತ್ತು ಕಾರ್ಯನಿರ್ವಾಹಕ ನಿರ್ದೇಶಕರು.
Under rule 46 of.
That is executive director ಶಿವಮೊಗ್ಗ.
Please.
All right. ಈಗ penalty impose ಮಾಡಿರೋದು ಯಾರು?
Same authority.
He was the disciplinary authority. He appointed a inquiry officer as a ADM. He submitted a report back to the.
Report ಅಲ್ಲ, charge sheet ಯಾರು issue ಮಾಡಿದ್ರು? Don't gloss over the issue. Who issued the charge sheet?
ಇಲ್ಲದನ್ನು annexure C.
ಏನ್ penalty ಏನ್ impose ಮಾಡಿರೋದು?
Compulsory retirement. But allegation is that in the charge sheet they say I was unauthorizedly absent for 90 days.
No.
Penalty is imposed for 1938 days.
You leave that, we'll see. Yes.
ವಿಭಾಗೀಯ ವ್ಯವಸ್ಥಾಪಕರು. And also ಕಾರ್ಯನಿರ್ವಾಹಕ. Signatures of both the, it is both signatures are there, my lords.
Both signatures, sir.
ವ್ಯವಸ್ಥಾಪಕರು and
ಏನು
ಕಾರ್ಯನಿರ್ವಾಹಕ.
ಕಮಿಟಿ ಅಪಾಯಿಂಟ್ ಮಾಡಿದ್ರೆ ಎನ್ಕ್ವೈರಿ ಕಮಿಟಿ ಸಿಕ್ಕಿದ್ ಮಾಡಿದ್ದೀರಾ? ಯು ಡೋಂಟ್ ನೋ ಹೌ ಟು ಕಂಡಕ್ಟ್ ಡಿಪಾರ್ಟ್ಮೆಂಟ್ ಎನ್ಕ್ವೈರಿ, ಐ ಗೆಸ್.
ಅಲ್ಲ ಇಲ್ಲಿ there is a signature of the
Synopsis
ED also.
ಹಾಕಿದ್ದೀರಾ ಇಲ್ವಾ?
The list of the events are in detail in synopsis.
Synopsis. Problem is you can't close the cases if you don't cooperate.
My lords, it is admit.
One ನಿಮಿಷ.
Yes.
Let's my statement of objections may be kept.
ಮಂಡೇ ಹಾಕಿ ಬಟ್ ಈಗ ಕರೆಕ್ಟ್ ಆಗಿದೆ ಈಗ ಮಾಡ್ಬಿಟ್ಟು
Statement of objections ಕೊಡಿ.
ಈಗ ಹಾಕ್ತಾ ಇದ್ದೀರಾ? ಓ 22 ದಾ? ಪರವಾಗಿಲ್ಲ, ಅರ್ಲಿ.
ಅಲ್ಲ, it was prior to other advocate was appearing.
Will pass. ಅಷ್ಟೇ.
ಅಲ್ಲ, under rule 47, my lords, rule 47
of
the rules.
Which rules?
Karnataka Forest Development Corporation Limited rules.
ಏನಿದೆ?
ಅದರಲ್ಲಿ compulsory retirement can be imposed.
Yeah, maybe compulsory retirement is a penalty, it can be imposed, no problem.
And under 46, he was the competent authority to pass an order.
No problem.
That is my submission.
Who issued the charge sheet is the issue.
ಅಲ್ಲ, ಅದರಲ್ಲಿ
There are two illegalities in this. One, charge sheet is issued by the inquiry officer. The other one is that you have given him a post-decisional hearing. You have indicated the penalty and then issued a notice. What do you say about the penalty? So you are not supposed to indicate penalty, which shows you have made up your mind already. Subtle technicality.
There is a signature of the disciplinary authorities also on the charge sheet. Page number 34, Annexure C.
That is a received copy seal.
ಎಲ್ಲಿದೆ?
ಅಲ್ಲಿ ಕೆಳಗಡೆ
34, my lords.
ಏನು ಪ್ರೈವೇಟ್ ಕಾಪಿ ಇದೆ ಏನು?
ಅಲ್ಲಲ್ಲ, ಪೇಜ್ 28 ನಲ್ಲೇ ವಿಭಾಗೀಯ ಅಧಿಕಾರಿ ಕೆಳಗಡೆ ಆ ಕಾರ್ಯನಿರ್ವಾಹಕ ಅಧಿಕಾರಿ ರಿಸೀವ್ಡ್ ಕಾಪಿ ಹಾಕೋ ಸೀಲ್ ಅದು.
Yes. The petitioner is before this court calling in question an order dated
6/6/2006.
Order dated 6/6/2006 passed by the disciplinary authority imposing penalty of
Compulsory retirement.
And the order of the appellate authority dated 29/10/2021 affirming the order passed by the disciplinary authority imposing penalty of compulsory retirement. The petitioner heard so and so, facts in brief germane are as follows. The petitioner joins the duty, ಏನಾಗಿ ನೀವು ಇರೋದು?
Originally appointed on 16/6/1973.
Synopsis ಹಾಕಕ್ಕೋಸ್ಕರ ಹಾಕ್ತೀರಾ ನೀವು?
ಅಲ್ಲ, originally appointed on 16.
The petitioner is appointed in the Karnataka Forest Development Corporation on 16/6/1973. The petitioner was working as assistant plantation superintendent in the corporation at Sirsi. Owing to unauthorized absence of the petitioner, the penalty comes to be imposed upon him. The penalty of compulsory retirement comes to be imposed upon him on 31/5/2006. The departmental appeal so filed against the imposition of penalty results in its dismissal. Therefore, the petitioner is before this court in the subject petition. The learned counsel appearing for the petitioner, taking this court through the documents appended to the petition, would submit that the entire proceedings are marred with grave illegalities. The learned counsel submits that the petitioner was unauthorizedly absent only between 1-2005. ಎಲ್ಲಿವರೆಗೆ?
1-2005 to 29/9/2005.
ಎಷ್ಟು ದಿನ ಆಯ್ತು ಅದು?
7 months.
ಮತ್ತೆ ಎಷ್ಟು ದಿನ 7 months? 210 days.
210 days maximum.
Was unauthorizedly absent for 7 months. The imposition of penalties upon the ground that the petitioner was unauthorizedly absent for 1918 days.
1938 days.
1938 days. That is the first illegality. On the learned counsel would further submit the disciplinary authority has not issued the charge sheet, but the charge sheet is issued by the inquiry officer himself or the subordinate to the disciplinary authority without there being subordinate disciplinary authority. He would further contend that while issuing the second show cause notice, the penalty that is to be imposed upon him was also indicated. Therefore, all these would be in violation of principles of natural justice. He would seek to place reliance upon several judgments of the apex court or this court, all of which would be considered in Karnataka. All of which would be considered in the course of the order.
That is on the point that disciplinary authority cannot delegate the action of, and this is Karnataka.
Per contra, the learned counsel appearing for the respondent would submit that disciplinary authority, it is the disciplinary authority who has issued the charge sheet, but the inquiry officer appointed is subordinate to the disciplinary authority, which is in tune with law. He would contend that the petitioner has replied to the second show cause notice and has not raised this ground of it being a post-decisional hearing. Therefore, the post-decisional hearing. Insofar as the days of absence is concerned, the learned counsel would seek to justify the action by contending that the petitioner was unauthorizedly absent close to 7 years. 1918 days and the rest of
7 years, almost 7 years.
Close to 7 years and not 7 months as is contended. He would seek dismissal of the petition. I have given my answers for narrated facts. The service of the petitioner in the respondent corporation is not in dispute. It would suffice if the list would be narrated from the date of commencement, date of the petitioner remaining absent from duties. The petitioner remained absent with effect from 1-2005 to 28/9/2005. Based upon this, a charge sheet inquiry, disciplinary proceedings are sought to be initiated against the petitioner. The charge sheet so issued against the petitioner. ಬರೀ ಅಷ್ಟೇ ಅಲ್ಲ, ಎಷ್ಟೋ ದಿನ ಇದೆ ಇಲ್ಲಿ?
Page 32 ನಲ್ಲಿ
ಅನುಬಂಧ 30
ಅಲ್ಲ, page 30.
ಟೋಟಲ್ ಡೇಸ್ ಎಲ್ಲಿ ಬರ್ದಿದ್ದಾರೆ ಇಲ್ಲಿ?
ನೆಕ್ಸ್ಟ್ ಪೇಜ್ ಅನುಬಂಧ 1. ಶ್ರೀ VR ಗುನಗ ಸೋ ಅಂಡ್ ಸೋ ನಡತೋಪ ಸಹಾಯಕ ಅಧೀಕ್ಷಕರು ಕೆಲಸ ನಿರ್ವಹಿಸಿ ಯಾವುದೇ ಪೂರ್ವಾನುಮತಿ ಪಡೆಯದೆ ನಿಮ್ಮ ಮೇಲಾಧಿಕಾರ ಗಮನಕ್ಕೆ ತರದೆ ದಿನಾಂಕ 1-2-2005 ಹಾಜರಿದ್ದು ದಿನಾಂಕ 29/5/2005 ಕರ್ತವ್ಯಕ್ಕೆ ಹಾಜರಾಗಿರುತ್ತೀರಿ. ದಿಸ್ ಇಸ್ ದ ಓನ್ಲಿ ಅಲಿಗೇಷನ್.
ಅಲ್ಲ, ಡೇಸ್ ಎಲ್ಲಿದೆ? 1918 ಅಂತ. ಅದು
ಪನಿಷ್ಮೆಂಟ್ ಆರ್ಡರ್ ದಾಗ 1938.
ಎಸ್, ಏನ್ ಹೇಳ? Charge sheet so issued against the petitioner depicts unauthorized absence, but does not depict the number of days of absence. The petitioner submits his reply to the charge sheet. The reply being found unsatisfactory, inquiry officer is appointed.
Reply, yes, I was unauthorized absent antane heliddu.
The reply is submitted by the petitioner, holding that justifying the unauthorized absence for 7 months. The reply being found unsatisfactory, the petitioner, charge sheet is issued against the petitioner, reply being found unsatisfactory, the inquiry officer is appointed to hold disciplinary proceedings against the petitioner. The order appointing inquiry officer?
Adilla direct, this is the direct charge sheet issued 13/12/2025.
No problem. Can't expect anything. The inquiry officer submits his report holding the charges as proved. The disciplinary authority issues a second show cause notice to the petitioner. The second show cause notice reads as follows. Annexure E, page 40. To the second inquiry or report kodlilva?
Kotru. Charges held to be proved anta.
The second show cause notice enclosed the report of the inquiry officer. The petitioner, then you submit a reply?
I submitted a reply.
Petitioner submits his reply and the disciplinary authority imposes penalty of compulsory retirement by the following order. Annexure F. The learned counsel for the petitioner submits, as submitted by the learned counsel for the petitioner, the inquiry officer so appointed was the assistant divisional manager, Dharwad division. This can be gathered from the aforequoted second show cause notice. Charge sheet is not issued by the disciplinary authority. The charge sheet so issued is by the divisional manager, who has affixed his signature to the charge sheet. It is Vibhagiya Vyavasthapakaru. It reads as follows, page 30. Therefore, disciplinary authority appoints additional divisional officer,
Vibhagiya Vyavasthapakaru manager.
Additional divisional manager to be the inquiry officer. He does not issue the charge, the disciplinary authority does not issue the charge sheet, but charge sheet is issued by the divisional manager. It is trite law that issuance of charge sheet is a quasi-judicial function. Such quasi-judicial function cannot be delegated. Disciplinary authority alone has to issue the charge sheet and appoint the inquiry officer to conduct the disciplinary proceedings. Therefore, the first illegality in the case at hand is the charge sheet being issued by the divisional manager, who is admittedly not the disciplinary authority. The disciplinary authority is the managing director. Managing director has admittedly not issued the charge sheet. Therefore, the very act of issuance of the charge sheet would get vitiated on account of it being issued by an incompetent authority. The next submission is the second show cause notice. The second show cause notice being a post-decisional hearing or a pre-decisional hearing. The second show cause notice is extracted herein above. The second paragraph of the said notice indicates the petitioner to reply as to why penalty of compulsory retirement should not be imposed upon him. This undoubtedly would mean that it is a post-decisional hearing and not a pre-decisional hearing. This aspect of post-decisional hearing or pre-decisional hearing is considered by the apex court in the case of Kunj Bihari Mishra versus Punjab National Bank, AIR 1998 SC 1783, I'll give you, so and so, where the apex court for the first time enunciated that the notice on disagreement with the findings of the inquiry officer had to be communicated to the employee. While elucidating on the said principle, the apex court has held that second show cause notice ought to be a pre-decisional hearing and not a post-decisional hearing, which would be discernible in the language deployed in the notice itself. Therefore, on the aforesaid twin score, the proceedings are vitiated. The other circumstance is the order of imposition of penalty narrates to the fact that the petitioner is absent for close to 7 years, while the records would reveal that the petitioner was absent only for about 7 months. Therefore, where from the disciplinary authority got the figure of 7 years is ununderstandable, nor the petitioner is notified with regard to the absence of 7 years. The admitted fact is that the petitioner was absent only for 7 months. On all these factors, the entire proceedings and the resultant imposition of penalty would stand obliterated. Allowed quashed.
Arrears of salary.
Petitioner will be entitled to all consequential benefits that would flow from the quashment of the proceedings. Yes.
Including arrears of salary.
All consequential.
Clarification illa anta, that will again lead to another law. Because he was in service. I still had 7 years of service. Now
you have retired.
I've also passed away. My legal heirs are prosecuting this.
Passed away.
Howdo.
ಹೇಳಲೇ ಇಲ್ಲ ಮತ್ತೆ ನೀವು.
Legal heirs are prosecuting this.
ಸಿನಾಪ್ಸಿಸ್ ಹಾಕಿ ಅನ್ನೋದು. ಸಿನಾಪ್ಸಿಸ್ ಅಲ್ಲಿ ಏನು ಇರಲ್ಲ. Yes, anyway, then 50% back wages. Petitioner shall have all consequential benefits, including 50% of the arrears of salary.
Please oblige.
Bill number 16, VV Baldal, Nagaraj Subbamani.
Yes, is settled, the lordship. Only thing that is referred to the mediation, my lord, matter is settled. Kindly.
ಸೆಟ್ಲ್ ಆಗೈತೆ ಹೇಳಿ ಮುಗಿಸ್ಬಿಟ್ರೆ.
Matter is settled, my lord.
Settle ಆಯ್ತಾ?
Settled ಆಯ್ತು. There is a one mistakes in the DDA that has to be again, it has to be recorrected, my lord. It may be called on 27th, my lord.
ಒಂದು ವಾರ ಬೇಕಾ ಡಿ ಡಿ ರಿಕರೆಕ್ಟ್ ಮಾಡಕ್ಕೆ? Current counsel of the petitioners submit that the matter has been settled and would report the settlement on the next date. Yes.
It may be
List
called
on-
on
list on 27.
Please.
Please.
20, Prashant Vasmani.
Office, my lord, has raised the issue of mental ability. It's a writ of mandamus. Seems they have raised it erroneously. I have sought for
non-prosecution ಆಗಿತ್ತು.
Please.
Dismiss for non-prosecution ಆಗಿತ್ತಾ?
ಹೌದು.
Why representations are given?
My lord, the representation, my lord, to take action on my complaints that I had filed against my senior when I was in service. There, my lord, they did not, my lord, so go ahead and conduct any inquiry on my complaints. On the contrary, my lord, I was, my lord, issued articles of charge on the ground that I am making baseless and frivolous complaints against my seniors. I was dismissed from service. I appealed it to the KAT. KAT, my lord, because I had already reached my age of superannuation.
You want to pursue this?
Lords, let there be, my lords, let them consider.
Notice ಆಗಿದೆಯಾ?
Notice agilla.
ಆಗಿಲ್ವಾ?
Notice is not issued. Like KT, office has raised objection regarding mental ability. Government employee. Well, it's want to take action against the government employees. Allio, please.
1, 2, 3, all.
Please.
AGA is directed to accept notice.
Please.
ಸಾಕು. Check ಮಾಡಿ, still want to pursue this, leave it.
Please.
18, SB Devananavar, Srinivas Vinayak.
Promise to marry.
This matter, may I request it on Monday? Matter is settled out of court.
Monday?
I'll file a memo.
Monday in the fresh matters list. Learned counsels for the petition parties submit, the matter has been settled, list on Monday.
19, SB Dharwad.
Regularization. Total 13 petitioners, synopsis.
ಅದೇನು?
Total 3 petitions, my lord.
ಅವ್ರಿಗೆ ಬೇಡವಾ? ಕೌಂಟರ್ ಸಿನಾಪ್ಸಿಸ್ ಹಾಕ್ಬೇಕು.
2001 appointment, staff nurse, my lord. Yesterday matter, my lord.
ಹಾ ಕೊಡಿ.
Just please.
ನೋಡಿದ್ರೆ ಮೇಡಮ್?
Yesterday.
All regularization matters will follow this and close.
It is very clear, my lord.
My name will be.
Name may be deleted.
ಅಲ್ಲ ಎಲ್ಲ ಕಡೆ ನಮ್ ಗೌರ್ಮೆಂಟ್ ದವರು ಏನ್ ಮಾಡ್ತಿದಾರ
ಹಾ
ಮೇಡಮ್?
ಏನ್ ಮಾಡಕ್ಕಾಗಲ್ಲ, ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ಬರ್ದಿರೋದಕ್ಕೆ. ಇಲ್ದರೆ ಹೋಲ್ಡಿಂಗ್ ಉಮಾದೇವಿ ಟ್ರಾವೆಲ್ ಟಿಲ್ ನೌ.
Only paid 6,000 rupees from 2001 to 2022, my lord, per month.
6,000 ರೂಪಾಯಿ ಅಷ್ಟೇ?
6,000 rupees, my lord. Even in the COVID period, my lord.
ಮಿನಿಮಮ್ ವೇಜ್ ಇಲ್ವಾ?
ಇಲ್ಲ sir.
Your Lordship, may I submit here?
Exploitation of human labor. This is why I have written it is exploitation.
Kindly, Your Lordship.
It
The
has been mentioned, my lord.
petitioners are.
It has been written, exploitation is, it has been mentioned in last page.
Correct.
It is
ನಾನೇ
specifically,
ಬರ್ದಿರೋದು.
please specifically mention, my lord.
Your Lordship, these petitioners are, Your Lordship, appointed under the Indian Population Control Project, Your Lordship. And this is.
ಇವತ್ತಿಗೂ ಇದೆಯಲ್ಲ?
Please, Your Lordship.
ಪಾಪ್ಯುಲೇಷನ್ ಕಂಟ್ರೋಲ್ ಆಗಿ ಪ್ರಾಜೆಕ್ಟ್ ಇದ್ದೇ ಇದೆ ಇವತ್ತು.
Please, Your Lordship, purely under contractual basis, Your Lordship. Not.
Purely contract ಅಂತಾನೆ regularization ಕೇಳ್ತೀರಾ?
Please, Your Lordship, and they are appointed in the year 2001 onwards, Your Lordship. 1 onwards, Your Lordship.
1, 2, 3, my lord. Some of the 1, 2.
ಅಥವಾ ಇನ್ನು 13 ವರೆಗೂ ಆಗಿದ್ದೀರಾ?
ಇಲ್ಲ sir. 2001, 2002, 2003, my lord.
I will direct consideration.
Earlier one, already, my lord, in,
ಬಂದಿದೆಯಲ್ಲ already?
please, my lord, please.
ರಿಜೆಕ್ಟ್ ಮಾಡಿದಾರಾ?
Please, my lord. There is no reasons, my lord. Page number 30, my lord.
ಕನ್ಸಿಡರೇಷನ್ ಮಾಡಿ ಅಂತ
23, my lord. Page number 19 to 2 petitions, my lord. Page number 19, my lord. The reasons may kindly be looked at, my lord. At page number, my lord, 11, my lord. No reasons, my lord. 6,000 ಇದ್ದಿದ್ರೆ 15,000 ಮಾಡ್ತೇವೆ ಅಂತ ಅಷ್ಟೇ.
ಈಕ್ವಲ್ ವರ್ಕ್ ಈಕ್ವಲ್ ಪೇ that has been
Admitted
done.
fact is 6,000 ಕೊಟ್ಟಿದ್ದೀರಾ?
Please, my lord.
Please. In the contract, your lordship agreement, they themselves have agreed that they will not seek for any regularization, your lordship. May I take your lordships to page number 19, your lordship. ಸದರಿ ಗುತ್ತಿಗೆ ನೇಮಕಾತಿಯನ್ನು ಯಾವುದೇ ಕಾರಣಕ್ಕೂ
That is
ಕಾಯಂ
what-
ಎಂದು
That
ಪರಿಗಣಿಸಿ.
is what Supreme Court considers in Shripal. ನೀವು ನೋಡಿಲ್ವ ಜಡ್ಜ್ಮೆಂಟ್? ನೆನೆದು
ಫುಲ್ ಓದಕ್ಕಾಗಿಲ್ಲ
Full
ಅಲ್ಲಿ
ನೋಡಿ.
ಈ ಯಾಕಂದ್ರೆ ಇವು ತುಂಬಾ ಮ್ಯಾಟರ್ಸ್ ಇತ್ತು ನೆನ್ನೆ.
Yes. We'll close it.
I'll go through it.
Please.
That's a regularization cases wait it
Please,
ಮಾಡ್ತೀನಿ.
yesterday matter posted today is tell me. This is also yesterday matter.
Early. The petitioner is before this court seeking the following prayer. Petitioners are before this court. ಇಬ್ರಿದ್ದಾರೆ?
Please.
ಮೂರು ಸಿನಾಪ್ಸಿಸ್ ಯಾಕೆ ಕೊಟ್ಟಿದ್ದೀನಿ?
So, three cases, my lord. Independent.
ಸಪರೇಟ್ ಇದೆಯಾ?
House of house.
ಕನೆಕ್ಟೆಡ್ ಇದೆಯಾ?
Connected ಇದೆ, sir.
ಸೀರಿಯಲ್ ನಂಬರ್ ಏನಿದೆ?
19, 19.1, 19.2, my lord.
All right, yes. The petitioners.
May I submit one more thing? The regularization, your lordship, the one time, this thing, your lordship, they have not opted, your lordship, initially, your lordship. And they are not appointed under any regularized scheme, your lordship.
Regularized scheme.
ಯಾವುದು 2001 in the your lordship, as per ML Kesari also, your lordship, 86 was the cut-off date, your lordship, then.
ಯಾವುದಕ್ಕೆ? ಇದು ಕಟ್ ಆಫ್ ಡೇಟ್ ಬರಲ್ಲ ಮೇಡಮ್. 10/4/2006 ಉಮಾದೇವಿ ಅಲ್ವಾ?
Please, your lordship.
The petitioner is before the batch of these petitions claim a batch of these petitions have a grievance in common that their services are not regularized. Therefore, they are at the doors of this court seeking a direction to regularize their services by setting aside the endorsement issued rejecting the claim of the petitioners for regularization. WP 103618 of 2023. The petitioner, pursuant to a notification for calling for applications for appointment of junior health worker, applies to the said post on 4/2/2001. After the selection process on 6/10/2001, the second respondent appoints the petitioner as a junior health worker under a particular scheme of population control. ಏನ್ ಪರ್ಮನೆಂಟ್ ಪೋಸ್ಟ್ ಏನಿದೆ 2003 ಇದು?
Please.
ಅಲ್ಲಿ ಸಿನಾಪ್ಸಿಸ್ ಕಾಪಿ ಮಾಡಿದ್ದೀರಾ ಅಷ್ಟೇ ಇಲ್ಲಿ.
Please. Page number.
The petitioners then, after working about 21 years, submitted a representation to consider their cases for regularization. This was not considered and the petitioner was before this court in writ petition 104195 of 2022. This court the coordinate bench of this court disposes the petition directing consideration of their cases for regularization on 2nd November 2022. The result of the said direction is the impugned endorsement on 15/2/2023 rejecting the claim of the petitioner and only observing that 6,000 rupees that was paid for the last 22 years would be enhanced to 15,000 rupees. Barring this, there is no other reason to deny the case of the petitioner for regularization. The companion petitions are also similar, except the dates of entry into service. Same, Aduna?
Same.
Oh, the companion petitions are also similar. Therefore, The facts need not be reiterated. The learned counsel for the petitioner submits that the petitioners have put in 24 years of service today and are left nowhere without regularization of their services. They are not working under the scheme, but they are staff nurses working. Yav idralli? Hospital.
Hospital.
Which hospital?
Government hospital.
They are staff nurses
Primary health
working
center.
in the government hospitals. Coming in the government hospitals of Shumagala,
ಬೇರೆ ಬೇರೆ ಪ್ಲೇಸ್ ಅಲ್ಲಿ ಇದ್ದಾರೆ ಎಲ್ಲರೂ ಬೇರೆ ಬೇರೆ
at different places in Shumaga district, at the primary health centers or otherwise. The learned counsel further submits that the petitioners are paid 6,000 rupees for the last 24 years, 22 years, and have now agreed that the now by the impugned endorsement have agreed that the salary of the petitioners would be increased to 15,000, and the claim of regularization is rejected. He would seek to place reliance upon plethora of judgments rendered by the apex court, all of which are considered by this court in writ petition 100556 of 2024. Per contra, the learned counsel, learned HCGP would submit that the petitioners have been appointed not against sanctioned vacant posts, but were under the scheme. The petitioners have, but would admit the fact that the petitioners have continued in employment for the last 24 years. The claim for regularization was, the claim for regularization has been denied, and appropriately denied is the contention of the learned counsel for the petitioner. Therefore, the learned counsel for the respondent state, learned HCGP. Therefore, the issue now is whether the petitioners would be entitled to consideration of their cases for regularization. In somewhat similar circumstance, this court, analyzing the entire spectrum of the law laid down by the apex court in Umadevi and in the aftermath of Umadevi, has held as follows.
Para number 10.
1 minute. 10 and 11. 10 in the end order, please. Para 10, then judgment, yesterday's judgment. This court considered identical circumstance of two of the employees who had served for 39 and 33 years respectively therein. The petitioners in the case at hand have on today rendered 24 years of service. The apex court considers the very circumstance of those petitioners therein being appointed under a scheme or under work charge establishment. In that light, work charge establishment. The endorsement that is issued to the petitioners rejecting the claim is on the face of it illegal. The endorsement reads as follows. The endorsement does not whisper about the claim for regularization, but observes that salary of 6,000 that was paid for the last 22 years would now be increased to 15,000. It is not even the minimum wage that the petitioners have been paid and even now sought to be paid. Therefore, it is a clear case where the service of the petitioners, the human labor at their prime youth, is exploited by the act of the state in taking their services for 24 years now and wanting to leave them in the lurch today. This is exactly what the apex court has deprecated in Shripal, which is considered by the apex court, which is considered in the judgment quoted supra. Next para. The other circumstance is that the learned HCGP further projects another circumstance that the judgment in the case of Umadevi was regularization as a one-time measure, and those who have not been found fit to be regularized then cannot claim regularization at a later point in time. This submission is noted only to be rejected, as the apex court in a subsequent judgment in the case of ML Kesari versus State of Karnataka, reported in 2010 9 SCC page 247, has considered this aspect and directed that persons who had not been regularized then are open to be regularized later, but observes that it was again for a as a one-time measure. But the subsequent judgments that have been considered by this court supra would steer clear the controversy. Therefore, the cases of these petitioners should merit consideration, bearing in mind the observations made in the course of this order. For the aforesaid reasons, the following order: allowed, quashed, Murunu, allowed, quashed, the respondent state shall now reconsider the cases of the petitioner for regularization within an outer limit of 3 months and with an outer limit of 3 months, bearing in mind the observations made in the course of the order.
Please, much.
20 K Patil, Anupji Deshpande.
Grant of one increment for having completed LLM, which is 19.1 of UGC regulations.
Yes, sir.
University says that state government
Yes.
has to clarify. Annexure G is the order of state government itself.
I have not secured any
Annexure G is
clarification.
Yes.
That's one submission as regards serial number 15. Time bound compliance is on Barley.
Back pages, sir.
Time bound compliance.
I'll pass.
21 Saurabh Sandhu.
Career advancement. I'll have to file synopsis in this. Requires detailed consideration.
First week March.
Please.
ಯಾವ್ದು ಮುಗ್ಸಕ್ಕಾಗತ್ತೆ ಅದು ಮಾತ್ರ ಹೇಳಿ.
22 MB Hiremat RHMD.
Before the petition. Day before yesterday's matter.
ಏನಿದು?
The application for seeking approval of the levert was not considered within the stipulated time. There's a deeming clause.
First week March.
Right?
Yes.
Covered it.
Covered ಇದ್ರೆ ಕೊಡಿ ಮುಗಿಸ್ತೀನಿ.
ಅಲ್ಲಿ ಅದ್ರ I produced it.
No, on the last occasion.
It's covered, is it?
ಅಲ್ಲ ನಾ ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿದ್ದೀನಿ.
It cannot be, conversion cannot be made, because my lordship, now they are seeking for conversion of the land. That is to a godown, my lord.
First week March, yes.
Please.
That's been moved. RK Kulkarni.
Appear for the petitioner. The petitioner seeking not a regularization, but synopsis, not 30 years, not they have completed.
State will go bankrupt now.
Not municipal authority, not they have filed a statement of objection admitting the claim of the petitioner. Para 1, 2, and 3, the statement of objections, not.
Where is the judgment?
But the statement of objection filed by the.
Where is the judgment?
ML Kesri judgment.
Which one?
ML Kesri judgment.
ಅದಲ್ಲ. ನಿನ್ನೆ ಒಂದು ಜಡ್ಜ್ಮೆಂಟ್.
Yesterday's judgment.
ಇಲ್ಲ, just ಈಗ ಕೊಟ್ಟಿದ್ದಾರೆ.
ನೀವು ನೋಡಿಲ್ವಾ? ಮತ್ತೆ ಆಗಲ್ಲ ಬಿಡಿ. ನೋ ರಿಲೀಫ್. ಈ petitioner ಒಬ್ರೇನಾ ಎಷ್ಟು ಜನ ಇದ್ದೀರಾ?
There are four,
my lord, his synopsis has been.
Same date of entry, nine.
Different date.
No, your lordship. All different, your lordship. In the first case, your lordship.
But first, my lord.
Cleaner.
Yes,
please, one cleaner, my lord, sweeper and accountant assistant, not there. Para 1, 2, 3, 4, my lord. Different, my lord, date of entry and different.
They have worked in different posts.
Yes, sir.
And continuously they have not served in any of the posts for more than 10 years. Earlier he was appointed in first writ petition as a driver. Subsequently he has been
cleaner,
appointed as a cleaner, and in that post he has not served for more than 10 years.
So what?
Less than.
But their objection is
daily wages.
Daily wages.
Daily wages ಅಲ್ಲಿ 30 ವರ್ಷದಿಂದ ಇರೋದು ಹೌದಾ? Different posts.
In the first petition, your lordship, he's been appointed as cleaner in the year 1999, your lordship.
But objection statement, your lordship, kindly say. Objection statement, my lord.
Earlier he was appointed as driver, your lordship. Earlier he was appointed as driver, your lordship, in the year 1991.
ನೀವು ಡೈಲಿ ವೇಜ್ ಏನ್ ಬೇಕಾದ್ರೂ ಕೆಲಸ ಮಾಡಿಸ್ಕೊಳ್ಳಿ, ತೊಂದ್ರೆ ಇಲ್ಲ. ಒಟ್ಟಲ್ಲಿ ಕೆಲಸ ಮಾಡಿದಿರಲ್ಲ.
It is an admitted fact, they are working. They are working.
Fairly says
I fairly admit.
30 ವರ್ಷದಿಂದ ಕೆಲಸ ಮಾಡ್ತಿದ್ದಾರೆ. ಈಗ ಎಲ್ಲಿ
ಮಾಡ್ತಾ ಇದ್ದಾರೆ?
ಅಲ್ಲ, ಈಗ ಎಲ್ಲಿ ಕಳಿಸ್ಬೇಕು ಅವ್ರು?
And they are getting the equal
pay for equal.
That is correct. We are paying.
ಅದು ಏನು ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ಜಡ್ಜ್ಮೆಂಟ್ ಆದ್ಮೇಲೆ, ಅದರ್ವೈಸ್ ಅದು ಕೊಡ್ತಾ ಇರಲಿಲ್ಲ. 2000 ಜಗಜಿತ್ ಸಿಂಗ್ ಆದ್ಮೇಲೆ ಕೊಟ್ಟಿದ್ದೀರಾ.
They would have filed, your lordship, immediately after 10 years, your lordship, not waited for 20 to 30 years, your lordship.
ನೀವು ಮಾಡಬೇಕು ಮೇಡಮ್. That's why I've said look into the judgment. State should identify and close it.
Earlier writ petition ಮಾಡಿ page 80.
ನೀವೇ ಯಾವಾಗ್ಲೂ ಮಾಡಿದ್ರ, ಸುಮ್ನೆ ಕೆಲಸ ತಗೊಳ್ಳೋದು. ಟೈಮ್ ಪಾಸಸ್ ಬೈ, ಏನು ಮಾಡಕ್ಕಾಗಲ್ಲ. ಈಗ 57 ವರ್ಷ 58 ವರ್ಷ ವೇರ್ ವಿಲ್ ದೇ ಗೋ? ಸುಮ್ನೆ ಶಾಲ್ ಅದಿಸ್ಬಿಟ್ಟು ಸೆಂಡ್ ಆಫ್ ಕೊಟ್ಟು ಕಳಿಸ್ಬಿಡೋದಲ್ಲ.
But earlier, my lord, writ petition allowed direction to the deputy commissioner to consider. But
When?
page 89, my lord, 12/4/2022. Page 83, my lord, annexure M. Thereafter, my lord, we have made a representation again. But deputy commissioner rejected the claim on the ground that municipal authority has not produced the appointment order and resolution copy of the appointment. Whereas, my lord, in the statement of objection, they have admitted that the appointment, date of appointment and.
ನಾಲ್ಕು petition ಕೊಡಿ madam.
Page number 90.
ಇದು ಸೇಮ್ ಪ್ಯಾರಾ 10 ಇಂದ ಎಂಡ್ ವರೆಗೆ ಎಲ್ಲ ಕೇಸ್.
ಹಾ, ಇದ್ರಾಗೆ
ಪ್ಯಾರಾ 10 ಇಂದ ಎಂಡ್ ವರೆಗೆ ಈ ಕೇಸ್ಗಳು ರಿಪೀಟ್. ಈಗ ಹೇಳಿದ್ನಲ್ಲ, ಈಗ ಹೇಳಿದ ಅದೇನೆ ಒಂದ್ ಕೇಸಲ್ಲಿ ಅದೇ ಎಲ್ಲ ರೆಗ್ಯುಲರೈಸೇಷನ್ ಅದು ಇಟ್ಕೊಂಡ್ಬಿಡಿ. ಈಗ ಒಂದೊಂದಾಗಿ ಕೊಡ್ತಾ ಹೋಗ್ತಾರೆ.
But in all cases, not synopsis, not one synopsis I narrated in all things.
ಎಲ್ಲದರಲ್ಲೂ ಹೇಳಿದ್ದೀರಾ? ಎಲ್ಲದರದ್ದು ಅದರಲ್ಲೇ ಹೇಳಿದ್ದೀರಾ?
Yes, not ಎಲ್ಲದರಲ್ಲೂ ಒಂದರಲ್ಲಿ ಹೇಳಿದೆ. Not 1991, not.
ಆಯ್ತು, ಕರೆಕ್ಟ್. ಎಸ್.
Their date of appointments are different.
Madam, ಇಟ್ಕೊಳ್ಳಿ. The petitioners in all these cases are at the doors of this court seeking a regularization of their services for having rendered the services with the
Respondent number 4,
Number 4.
fourth respondent municipality.
TMC Nippani.
City Municipal Council. Respondent number 4, City Municipal.
Fourth respondent, City Municipal Council, Nippani. In writ petition 107774 of 2023, the petitioner was appointed on daily wages as a cleaner on 1/9/1991 and is.
He has been appointed subsequently, not 91. His date
99,
of appointment
your
is
lordship.
99.
8/12/1999.
8/12/1999.
But 91 ಏನ್ ಮಾಡಿದ್ರಿ?
ಅಲ್ಲ,
91 he was
ಅಲ್ಲಿ
the driver.
That may be noted, your lordship.
That may be noted.
All right. The petitioner was appointed on daily wages in the office of the fourth respondent, initially as a driver on 1/9/1991. Later, he was appointed as a cleaner again in the same municipality on 8/12/1999. Therefore, 8/12/1999, the petitioner continues to work as a cleaner today in the fourth respondent municipality. This is an admitted fact. In writ petition 100477 of 2023, the petitioner was appointed as a driver on 1/9/1996 and is said to be discharging his duties even today in the same post. Therefore, the petitioner therein has been working in the fourth respondent TMC for over 28 years. The petitioner in the writ petition 100471 of 2023 is appointed as a Paura Karmika in the fourth respondent on 1/6/1997 and continues to work as a Paura Karmika for more than 27 years. The fourth petition, in writ petition 100470 of 2023, the petitioner was appointed as an assistant on daily wages on 1/8/1998 and has been working in the said fourth respondent municipality as an assistant even today, now for over 26 years. Therefore, all these petitioners are in the services of the fourth respondent municipality in different capacities, right from 1991 to 1998. Their services today range from 33 years to 28 years respectively. The petitioners have all been the petitioners have all been paid equal pay for the work that they undertake in the fourth respondent municipality, like that of the permanent employees. In short, they are paid they are given equal wages for equal work. The content, the submission of the averment in the petition is that the petitioners are working against a sanctioned vacant post throughout, which is disputed by the council for the state. The petitioners did stake their claim seeking regularization of their services. The first writ petition they prefer before this court is in writ petition 81729-81749 of 2013. The writ petition comes to be disposed by directing the petitioners to submit fresh representations. Certain employees who had submitted those representations, the government accepted their claim and regularized the services. The petitioner then was regularized. After such regularization, the petitioners were bought under Daily Wage Welfare Kottidara.
Please, madam.
Daily Wage Welfare Act Kottidara.
ಇಬ್ಬರಿಗೆ ಕೊಟ್ಟಿದ್ದಾರೆ.
Ibriga.
ಇಬ್ಬರಿಗೆ.
A few of the petitioners were bought under the Daily Wage Welfare Act by granting them certain pay. The petition, these petitioners again knocked at the doors of, these petitioners then knocked at the doors of this court in writ petition 100352 of 2022, which comes to be disposed with a direction to the Deputy Commissioner to consider the case of the petitioners and pass necessary orders in accordance with law. The result of the said direction is the impugned order passed declining to accept the claim of the petitioner for regularization. The claim is rejected on the sole score that the resolutions of the respective town municipal council seeking appointment, making the resolution of the town municipal council in favor of the appointment of the petitioners was not placed along with their representations, or the TMC has not placed it before the deputy commissioner. It is therefore the petitioner is again back to the doors of this court.
Lord, that is not the only ground. As they have not-
Inter-alia.
In the order, it has been.
Inter-alia. Yes. The learned counsel, so and so. Learned counsel appearing for the petitioner Shivraj Mudhol would reiterate the averments made in the petition, seeking to contend that the claim of the petitioners are rightly rejected, as none of these petitioners have been working against sanctioned vacant posts or have not completed 10 years of service in a particular post. Either they are appointed as drivers or working as cleaners, either appointed as Paura Karmikas or working as cleaners, or appointed as cleaners or working as drivers, as the case would be. Therefore, he would submit that it is not a case where these petitioners have been working in a solitary post for the last 2 or 3 decades, but would admit that if in the fourth respondent municipality, the petitioners are working for 33 to 28 years respectively. The learned counsel would then leave the decision to the court. The learned HCGP would, however, vehemently refute the submissions of the counsel for the petitioner, contending that the orders of regularization should not be passed for the asking, because as it would be a huge burden on the state. The petitioners at no point in time have completed continuous service in one solitary post. They were appointed on daily wages and have been shifted to several posts as daily wage employees. The learned counsel would submit that they are not working in sanctioned vacant posts at the outset, and therefore their services should never be directed to be regularized. She would seek dismissal of the petition. I have given my anxious consideration, so the afore narrated facts are not in dispute. They are all a matter of record. The dates, link in the chain of events, the appointment of the petitioners are all again a matter of record and undisputed facts. The petitioners have, as on today, rendered 33 years, 33, 29, 28 and 26 years respectively in the fourth respondent municipality, be it in the cadre of cleaner, sweeper, Paura Karmika or a driver. Nonetheless, they're all working in the fourth respondent municipality from the respective dates of their appointment uninterruptedly till 2025, i.e. today. The employment of these petitioners are not litigious, as their services are never continued on the basis of any interim order granted at the hands of this court. They are in continuous employment owing to their necessity in the fourth respondent municipality, and the necessity still prevails. The fourth respondent has filed its statement of objections, where it is admitted that the petitioners are working from the dates of their respective engagements till today. The contention of the state that regularization orders should not be passed for the asking is noted only to be rejected, as these petitioners have toiled in the fourth respondent municipality at their prime youth, right from 30 years or 26, right from 33 years to 26 years, 26 years respectively. Today, they are all aged between 56 to 60 years. If today they are sent home without any benefit of regularization, they would be wandering in their retired life. In identical circumstances, the apex court in the case of Shripal versus Nagar Nigam, reported in 2025 SCC online SC page 121, has held as follows. Non-judgmental vishal. In the light of the said, the apex court was considering the cases of those persons who were appointed on work charged establishment. The petitioners are similarly situated. The apex court was considering cases where their services were terminated, reinstated pursuant to the orders of the labor code therein. Nonetheless, the apex court observes that they are in continuous employment for over 3 decades there and directs regularization. The petitioners in the case at hand are in service for more than 3 decades in certain cases and close to 3 decades in certain cases. In that light, the claim of the petitioners could not have been denied on a specious plea that the SPECIOUS, and a specious plea that there is no resolution of the panchayat appended to the requisition to the deputy commissioner. The panchayat has filed its municipal council. The town municipal council has filed its objections, accepting the fact that the petitioners are in employment throughout. If that be so, the very reason rendered by the deputy commissioner may be inter-alia, but one of the reasons rendered is unacceptable, nor the rejection of the application of the petitioners is acceptable, nor is acceptable. Therefore, the aforesaid reasons, the following order. Allowed.
One more submission, Your Lordship. One more submission, Your Lordship. They are stopped from seeking regularization, Your Lordship. They have already had the fruit of Daily Wages Act, Your Lordship, Welfare Daily Wages Act, Your Lordship.
Merely because they have been bought under Daily Wage Welfare Act, it would not deny their claim. Let me see. Yes. We'll see. Answer.
That may be not.
The learned counsel for the state submits that the petitioners are stopped from staking a claim or making a claim for regularization of their services in the light of the fact that they have already been bought under the Daily Wage Welfare Act. The submission is noted only to be rejected. The Daily Wage Welfare Act cannot be equated with regularization of services of persons who have rendered service close to 3 decades, or service rendered more than 3 decades or close to 3 decades. The other judgment is please. Lord Cost.
Number 24, Anand P. Saudi, Suresh is
Appear for a petitioner filing application, calling upon the other side to produce document.
Regularization.
Allah sir, it's a provident fund case. It's a pension case.
Serial number
24.
Oh, this pension scheme.
Yes.
Itself Akash the Vichara. Wait, come. Let's on 4th. Yes.
25, Kumar Hiremate, Venkatesham Khadi.
Vacating interim order.
Request for on Tuesday. My lords, we have only one writ petition. They have issued criminal notifications.
Kindly they will permit liberty to file objection, will course.
Sir.
Huh?
Objection ಹಾಕಿದ್ದೀರಾ?
ಅಲ್ಲಿ ನಾವೆಲ್ಲ objection ಹಾಕಿದ್ವಿ.
ಮತ್ತೆ ಪರ್ಮಿಟ್ ಏನಕ್ಕೆ?
So ಅಲ್ಲಲ್ಲ, ಒಂದರಲ್ಲಿ 5-4 writ petition ದಲ್ಲಿ only one writ petition preliminary issue notification has been issued. They have liberty to file objection before the SLO officer, my lords.
27th, list on 27th.
Cell number 26, Chair Shri Nilofer, Sunil S. Desai.
Lord,
Lord,
in the
seek
earlier
for-
round of litigation, Your Lordship.
Seek for short time for filing.
One post vacant ಇದೆಯಲ್ಲ?
Yes, Lord, by virtue of the earlier order passed by this honorable court, the respondents were directed to consider the candidature by considering the project displaced person's certificate, my lord.
Let him file his objections.
My lord,
One post is kept vacant already.
one post, okay, my lord. They preferred a writ appeal. Writ appeal is also dismissed, my lord.
ಇದ್ರ ಮೇಲ? Interim order ಮೇಲೆ?
Interim order ಅಲ್ಲ, ಇದು earlier writ order ಮೇಲೆ.
Main request.
Yes, sir.
First hearing.
First treatment.
ಇವ್ ಯಾರಿಗೆ?
ನನ್ ರೆಸ್ಪಾಂಡ್ ನಂಬರ್ 3 ಗೆ ಎಲ್ಲ ಪೋಸ್ಟ್
2 weeks to file. Fill up ಆಗೋಗಿದ್ಯಾ?
ಆಗಿದೆ ಅದು.
ಇಲ್ಲ, Lord, during the contempt proceedings, Lord, they had produced the list. In the list, it was mentioned that one post is subject to the result of writ appeal anta they had mentioned in the list.
ಇಲ್ಲ ಹೇಳಿಲ್ಲ. Don't worry. Two weeks time, 2 weeks time is granted to file statement of objections by any of the respondents. Let's after 2 weeks. Next.
27, Surabhi Kulkarni, Anant Pisawadi.
Speaker, which time file objections?
ಎಲ್ಲಿಂದ?
For the petition, my lords. The case, my lords, where
Senate counsel for the respondent seeks a week's time to file statement of objections. Rest after 1 week.
there's an interim order, my lord.
Interim order subsisting will continue to the next.
Please.
28, Rajendra R. Patil.
This is with respect to refund of tax amount collected, my lord. Lordship, the tax amount has been collected on the basis of explanation 2 to the, my lord, the Karnataka Motor Vehicles Taxation Amendment Act. That amendment has been struck down by this court, my lord, and upheld by the division bench.
Covered.
ಅಲ್ಲ ಕವರ್ಡ್ ಇದೆ ಅಲ್ಲ, as per the order passed by the honorable apex court, my lords, there are twin conditions ಅದು impose ಮಾಡಿ, they have to file affidavit. ಅದು vehicle ಮೇಲೆ lien and
ಇಂದ್ರೇಶ್ ಅವರು
page 191, my lords, for
Page 193 is the, my lord, the interim order.
ಈಗ ಇದೇ ಆರ್ಡರ್ ಪಾಸ್ ಮಾಡದಾ?
I am ready to give undertaking, my lord, subject to result of appeal pending before the, my lord, honorable apex court.
The petitioner is before this court seeking the following prayer. The learned counsel for the petitioner submits that the issue in the list stands answered, full bench either, by the judgment of the division bench dated 1st July 2016, which is taken to the apex court, and the SLP is disposed.
Pending, not civil appeal.
SLP is pending, where the apex court passes the following order, taken to the apex court passes the following order. Page 193, 194. The learned counsel for the petitioner would submit that if the benefit that is granted by the apex court in the aforesaid order is granted in the case at hand, would suffice for the present. The learned counsel would also submit that coordinate benches have passed the following order. Indresh Avarda.
No, my lord. Annexure D, my lord. Page number 23 and operative portion is page number 58. Is a single bench judgment, my lord. That was confirmed.
ಅದೇ division bench ಆಗಿದ್ದು.
Thereafter, the division bench also upheld, my lord.
In terms of the order passed by the apex, therefore the petition is disposed, granting the benefit that the apex court has granted to these petitioners of refund,
Refund, my lord.
of refund of the amount which would be subject to the aforesaid SLP ordered according.
they have to file affidavit.
With the conditions stipulated by the, along same, in terms of the judgment of the apex court and the conditions stipulated therein.
Specific direction may be issued, my lord, to refund, my lord.
You affidavit ಕೊಡಿ ಕೊಡ್ತಾರೆ.
Please, my lord.
29, Surabhi Kulkarni, Saurabh Sando.
This is, I am appearing for the, ಅಲ್ಲ, ಒಂದೇ ಒಂದು submission. I'm appearing for the bank. Bank has already executed sealed deed in favor of petitioner who is subsequent purchaser.
Auction purchaser, my lords.
Auction
Oh, is
purchaser.
that, registration.
Only this subsequent purchaser is now obstructing all the proceedings. Award has attained finality. He in fact approached this honorable court after passing of the award. That writ petition was dismissed. My IA, page 6 of my IA, your lordships will get. IA dated 30th January 2025. IA for permission which is filed by me. Page number 6, my lords, this Achyut son of J. Balasubramaniam. He is respond number 9. Lords, he approached this honorable court previously, my lords. Award was, it was brought to the notice of the court that award is.
Order, sir.
Page 6 of my IA.
6 ಅಲ್ಲಿ ಅವರ್ಮೆಂಟ್ ಇದೆ, ಆರ್ಡರ್ ಎಲ್ಲಿದೆ?
ಅಲ್ಲಲ್ಲ, ಈ IA. Page 6 of my IA for
Page
permission. IA on 30th January 2025. This coordinate bench, my lords, dismissed his writ petitions holding that he should approach the appellate tribunal against the awards passed. Till today, no appeal is filed, my lords. Appeals, these awards have attained finality. He is initiating one after another collateral proceedings. My only submission is I filed IA seeking permission from the court to deliver possession to the auction purchaser.
Yes, will direct delivery of possession subject to the result.
Yes, that can be done.
My kind permission.
No, sir.
I'm appearing, my lord, in this case, I challenge that order, my lord, the transfer of the petition to the.
ಅಪೀಲ್
some other
ಹಾಕಿದ್ದೀರಾ
court.
ಇಲ್ವಾ?
Huh?
ಅಪೀಲ್ ಹಾಕಿದ್ದೀರಾ?
Against, my lord, earlier I filed the another petition, my lord, and that case.
Sir,
this is
Justice Sachin, our observation.
That is, my lord, I'm seeking the transfer of that order. On that case, my lord, rejected that, already disposed of the matters. Earlier, I have filed another writ petition, and the writ petition rejected that, my lord, to approach the appropriate authority. I filed the.
ಈಗ 105 ಅಲ್ಲಿ ಅಪೀಲ್ ಹಾಕಿದ್ದೀರಾ ಸರ್?
You're Hakila. That has attained finality. And
That's
if
why,
they
my lord,
file
in
appeal
this
there,
case-
they'll have to deposit minimum 25%.
In this
That
case,
is
my
the
lord,
reason they avoided.
I have deposited around 40 lakhs rupees, I have paid
The
the
petitioner
bank, my lord.
is before this court
Kindly see my objection, my lord.
seeking the following prayer. The petitioner is
And
the
earlier, my
auction
lord, they have not
purchaser.
taken possession, also not taken. my lord.
No problem, sir. The petitioner is the auction purchaser. The ninth respondent is the borrower.
No, I'm
He is a
not
subsequent
borrower.
purchase. Subsequent purchase.
Ninth respondent is the purchaser from the hands of the borrower.
Borrower.
The borrower avails a loan from the fourth respondent bank. The borrower, respondent number 6, on 8/8/2009, defaults in payment. The third respondent bank initiates a dispute under section 70 of the Karnataka Cooperative Societies Act.
Fourth respondent, my lords.
Fourth respondent.
Please.
Fourth respondent, Cooperative Societies Act, seeking recovery of the amount of loan that was in default. The fourth respondent, second respondent, ಯಾಕ್ ಮತ್ತೆ?
Second
The
is
second respondent,
JRCS.
JRCS, passes an award of recovery of the amount of 17 lakhs along with interest and costs thereon from respondents 6 to 9. On 17/8/2023, the third respondent issues a proclamation of auction sale of the petition property. The property is auctioned. The present petitioner emerges as the successful auction purchaser. The ninth respondent, again, problem ಏನಾಗಿದೆ ಇದರಲ್ಲಿ?
He approaches the Minister of Cooperative Societies under the Cooperative Society Act and seeks a stay of sale proceedings there.
1 minute.
Which is stayed.
The ninth respondent, who is the subsequent purchaser from the hands of the borrower after the said default, approaches this court.
My kind permission. Not set default, my lord. They have deposited the 40 lakhs. Afterwards, I purchased the property from
Or
the
during the
courts.
proceedings, approaches this court in writ petition, this court in 105252 of 2023. The ಇನ್ನೊಂದಿದೆಯಾ? ಅದ್ಯಾವುದು ಕೊಡಿ.
In this case also, my lord, approach the appropriate authority ಅಂತ ಹೇಳಿ ಆರ್ಡರ್ ಮಾಡಿ.
Approaches this court in 2 petitions. One in writ petition 101529 of 2023, which comes to be disposed by directing the petitioner to approach the appropriate authority. Immediately, another writ petition is preferred in 105252 of 23. This comes to be disposed on 27 September 2023.
That writ petition transfer the dispute to one petition to one forum to another forum.
The coordinate bench passes the following order. Page 8. Pursuant to the order of the coordinate bench, it transpires that the petitioner has not preferred any appeal. Therefore, having not preferred any appeal pursuant to the order passed in writ petition, cannot now cause an impediment to the execution of the document pursuant to the auction sale conducted. Therefore,
Execution is complete, possession delivery is remaining.
therefore, the auction sale shall be taken to its logical conclusion, which would, however, remain subject to the result of the petition. Yes, next.
Obliged.
30, Sajid Ahmad
Let's,
I may be permitted to deliver possession. That is my prayer, my lord.
What do you mean by logical conclusion?
Please.
interim order may kindly be extended.
Yes, what, Surabhi?
This regarding my lord's recovery of my lord's 25.
You're saying something?
Reco
Interim order?
May kindly be extended in serial number 29, my lords.
Interim order in Bantiga.
Those revision proceedings are
Those
stayed.
proceedings, all right. Subject to the aforesaid, the interim order granted stands continued.
Sorry, my lordship may say 12 to order, my lords. 12 to order.
I have filed statement of objections.
No, enquiry officer exonerates.
Yes, my lord.
Correct alva? ಈಗ ನೋಟಿಸ್ ಕೊಟ್ಬಿಟ್ಟು ಮಾಡಿ ಅಷ್ಟೇ. The petitioner is before this court calling in question, seeking the following prayer. The petitioner heard so and so, facts in brief germane are as follows. The petitioner is appointed as a section officer on 3/1/2023. Owing to certain omissions and commissions, the departmental inquiry is initiated against the petitioner for non-returning of 131 failed transformers. The inquiry officer so appointed exonerates the petitioner. The exoneration exonerates the petitioner. It is an admitted fact. The disciplinary authority disagrees with the findings of the inquiry officer and imposes penalty of recovery of 25,64,550 with 550 by directing deduction from the salary at rupees 30,000 per month, and also imposes penalty of reduction of 2 increments with cumulative effect. The issue in the list revolves around a narrow compass. When the inquiry officer had admittedly exonerated the petitioner, penalty could not have been imposed without at the outset disagreeing with the findings of the inquiry officer and issuing to the petitioner notice of such disagreement. It is again an admitted fact that the disciplinary authority has not disagreed with the findings of the inquiry officer, but has gone on to impose the penalty. Therefore, there is violation of principles of natural justice as held by the apex court and plethora of judgments, that the disciplinary authority cannot impose penalty on a report which exonerates the delinquent employee delinquent employee without issuing a notice of such disagreement. Since the issue lies in the said compass at this juncture, I deem it appropriate to obliterate the order of penalty and direct the disciplinary authority to issue notice, seek the reply of the petitioner if it still wants to disagree with the findings of the inquiry officer, and pass necessary orders in accordance with law. For the aforesaid reasons, the following order. Petition is allowed in part. The so-and-so stands quashed. The matter is remitted back to the hands of the disciplinary authority to bear in mind, to pass necessary orders bearing in mind the observations made in the course of the order, ordered accordingly.
That's one request. From the year 2014, they have already recovered the amount, my lords, that we reimbursed, my lords.
No, not now. I only sent it back, sir. The orders with regard to the refund of recovered amount or otherwise shall remain subject to the result of the order that would be passed by the disciplinary authority on the subject remand. ಮತ್ತೆ ಬರ್ಬೇಕಾಗುತ್ತೆ ಇಲ್ಲ.
Time limit.
The compliance with the order will be within 3 months. Please.
31 Ravi Every Prashant Usmani.
This, my lords, brings to the disability certificate, lighter job.
Then covered
Batch of matters, my lords, are coming
covered
up.
ಆಗುತ್ತೆ ಇದರಲ್ಲಿ. Problem is this, my lord, kindly take, my lord, page 43.
43?
That is the impugned endorsement. 42 is the, my lord, the medical certificate. This is not, my lord, in form number latest form.
Batch of matters are coming up on Monday.
Therefore, my problem is, my lord, after that, they refused later job. And I have been issued with charge sheet.
You subject yourself to medical board, like what is said by the coordinate bench, they will pass necessary orders ಆಮೇಲೆ.
ಅಲ್ಲ ಅದಕ್ಕೆ ಹೋದಾಗ ಅವ್ರು ಕೊಟ್ಟಿರತಕ್ಕಂಥ ಸರ್ಟಿಫಿಕೇಟ್ ಸರಿ ಇಲ್ಲ ಅಂತ ಹೇಳಿದ್ರು ಅವರು. I could have been again referred, my lord.
ಮಾಡಿ ಅದನ್ನೇ ತಾನೇ ಹೇಳಿರೋದು ಈಗ.
ಈಗ ನನಗೆ ರೆಫ್ಯೂಸ್ ಮಾಡಿಬಿಟ್ಟಿದ್ದಾರೆ. ರೆಫ್ಯೂಸ್ ಮಾಡಿ I have been issued with an articles of charge. You remained absent ಅಂತ. He is a driver. Left leg is, my lord, foot is amputated.
My lords,
and he can't drive
the order
bus.
passed by my lords. He will be continued in the same. Regarding this, my lords, I'll get instructions. Regarding
This is correct, disability.
The disability, my lord, I have it on Monday.
ಅಲ್ಲ ಅದು correct.
I have to.
Oh, this is, my lord, the photographs where.
ಕಾಲಿಲ್ದಿರೋ person drive ಮಾಡೋದು.
I'll verify that.
Everybody's life to jeopardy.
My lords, I'll get instructions. This is, my lord, pertaining to this Kalburgi, KK, ಇಲ್ಲ ಅಂದ್ರೆ KKRTC.
27th.
By Monday, my lords, I'll get, because other matters are coming up on Monday.
Monday.
Batch matters, my lords, are date given.
Yes.
32 Ramchandra Malik.
Appear, my lord, for the petitioner. Appointment, my lord, of the petitioner in 2010 by the management was
Regularization.
pay, my lord, has not been
Yeah, Lord,
released since 2017 in spite of, my lord, appointment having been approved and admitted to granting aid.
ಯಾವಾಗ ಮೇಡಮ್?
ಅಲ್ಲ, your lordship, as per the government order, your lordship, on notification, your lordship.
Redeployment ಮಾಡ್ಬೇಕಾಗಿತ್ತು ಅಷ್ಟೇ.
Redeployment ಮಾಡಿದ್ವಿ ಅಲ್ಲಿ.
ಎಲ್ಲಿ
He has
ಮಾಡಿದ್ದೀರಾ?
not, your lordship, he has not intended.
From their pockets ಅಂತ ಹೇಳಿದೀನಿ.
ಹೌದು.
ಈಗ ಯಾವಾಗ ಮಾಡಿ?
As per 2007 notification.
ಈಗ ಸ್ಯಾಲರಿ ಕೊಡಲ್ಲ.
If ಬರಲ್ಲ ಅಂತ ಹೇಳ್ತಾ ಇದ್ದಾರೆ.
ಬರಲ್ಲ? ಎಲ್ಲಿ ಕೆಲಸ ಮಾಡ್ತಾ ಇದ್ದಾರೆ ಇವರು?
Please, your lordship.
ಎಲ್ಲಿ ಕೆಲಸ ಮಾಡ್ತಾ ಇದ್ದಾರೆ?
Petitioners, your lordship. That process is on.
ಕೆಲಸ ಮಾಡ್ತಾ ಇದ್ದಾರೆ ತಾನೆ?
ಇಲ್ಲ, ಈಗ ಇನ್ನೋರಿಗೆ ಕೊಡ್ಲಿಲ್ಲ ಯಾವ್ದನ್ನು.
ಯಾರಿದು? ಒಂದು ನಿಮಿಷ. Who is to pay salary?
Lord, salary is to be paid, released, my lord, by third respondent.
As per 2007
There are certain,
circular,
my
your
lord,
lordship.
one few fact, my lord, I shall clarify. Your lordship may kindly take my very order, my lord, approving my.
Direct the director pre-university education to be present before the court. This court on 30/9/2024 had passed the following order. Salary was denied to the petitioners for close to 7 years on the ground that they have not reported to the redeployed institutions. The learned counsel Ramchandra Mali has appended plethora of documents to the petition to demonstrate that they have reported and they are working in the redeployed institutions.
Every
Not on
month, my
that
lord, yesterday I have
ground,
submitted for
And
2015 to
they-
2024, my lord,
And the
every month.
attendance sheet of their working in the redeployed institutions are produced before the court even to the month preceding this month, i.e. December 2024. Therefore, there is no warrant for non-payment of salary to these petitioners for close to 7 years. This is what was captured in the order dated 21/1/2025. Despite this, today, the HCGP submits that they are not in a position to pay salary. Therefore, the Director, Department of Pre-University Education shall be present before the court on 27th at 2:30 PM.
Kindly, your lordship, on
Yes.
Your lordship, there is a dispute between the management, your lordship. In that regard, your lordship, this endorsement has been given.
ಆ
your lordship.
ಮ್ಯಾನೇಜ್ಮೆಂಟ್ ಸ್ಟಾಪ್ ಮಾಡಿ ಅಷ್ಟೇ. ಎಸ್.
ಅಲ್ಲ ಅದಿನ್ನೂ ಸೂಟ್ ನಡೀತಾ ಇದೆ, ಎರಡೆರಡು ಸೂಟ್ ಪೆಂಡಿಂಗ್ ಬಿಫೋರ್ ದಿ.
ಎರಡೆರಡು ಕಡೆ ಸ್ಯಾಲರಿ ಕೇಳ್ತಾ ಇಲ್ಲ ಅವರು.
ಅಲ್ಲ, when there is a dispute between the management, your
When there is
lordship,
dispute
as
between the
per-
management will
as
always
per-
be in dispute, so teachers
Your
will not be
lordship,
paid salary.
as per circular
Very
dated-
convenient to you. ಹಿಂಗೆ ಆಗೋದಲ್ಲ.
Lordship.
Yes, 230, next.
33 Sunita P. Kalso, please.
This is that MLA's order, your lordships.
ಹಾ.
Your lordships, all the.
Site order ಇದೆಯಲ್ಲ.
ಅಲ್ಲ ಇದೆ, site is not at all hand over to them.
List the matter in the first week of March, interim order.
Your lordships,
No, no, no.
my payment is held up, your lordship, 40 lakhs is held up. I have executed the work.
First week, yes.
34 ZM Hattarki.
Your Honor, I seek adjournment on Monday.
List on third, next.
Interim order may be extended, my lord.
Interim order ಇದೆಯಾ?
Yes, my lord.
With negligence of the homeopathic doctor who has given the injection, that's the case. The lordship directed the authorities to get the records.
On Monday, my lords.
Wait, sir.
What treatment he has given is more or less an injection, which is used.
Injection.
Sorry, my lord. Injection, which is used for more or less severe pain. ಒಂದೇ ದಿವಸದಲ್ಲಿ ಯೋಜನೆ ಕೊಟ್ಟಿದ್ದಾರೆ.
ಸತ್ತೋದ್ರ ಅವರು?
Sattu.
ಹೌದಾ?
That's what.
Thereafter,
That's what I made submit. I will file a implementing application.
Was issued. It was seized by virtue of lordship.
Monday.
Please.
Yes.
Much of that. Interim order may be extended.
Monday in the fresh matters list. Yes.
35 SRA.
Yes, ma'am.
Suraj M. Katigi.
For the respondent, my lords. Petitioner is seeking, challenging the compromise decree, my lords. I am for the plaintiff.
Just in the first week, yes. Next.
Kindly pass over, my lords. He is
First
ready,
week,
my lords.
sir. Yes, next. First week of March.
36 Hirapur Hanmantappa. Are Changi.
Notional fixation.
Roster fixation.
Notional fixation for pension and all.
Fixation. Objections ಹಾಕಿದ್ದೀರಾ?
ಹಾಕಿದ್ದೀನಿ. Okay.
Yes, sir, covered by judgment, sir.
No, there are no judgments on the point. Kindly turn to the prayer column. The second prayer which is sought by them is second and third.
This has to be heard. List the matter in the second week of March. Yes, next.
Please.
37 HM Dharigo.
Why is Basuraj sir waiting? ಯಾಕೆ ಕಾಯ್ತಾ ಇದ್ದೀರಾ ತಾವು?
Forest officers.
ಫಾರೆಸ್ಟ್ ರೆಗ್ಯುಲರೈಸೇಷನ್?
Forest officer. 59. I'll wait.
ಎಷ್ಟನೇದು?
59.
ಅಲ್ರಿ ಮಧ್ಯಾಹ್ನ. ರಿಕವರಿ ಮಾಡ್ತಾ ಇದ್ದಾರೆ.
Recovery.
ಯಾವಾಗ ಕೊಟ್ಟಿದ್ದು?
Same person, my lord, issues charge sheet, conducts inquiry, and he is not a competent authority, my lord, that is the ground.
ಈಗ ರಿಕವರಿ ಶುರು ಆಗಿದೆಯಾ?
ಆಗಿದೆ recovery.
Final order of penalty, how do we state? What is the penalty imposed?
My lord, recovery of the amount more than 22 lakhs.
Heard the learned counsel Ravi Hegde appearing for the petitioner. What is called in question is an order dated 3/2/2024 by which a recovery of an amount of alleged misappropriation from the hands of the petitioner is imposed. The learned counsel for the petitioner submits that the inquiry officer,
Same person, my lord, issues charge sheet, he conducts inquiry. And
learned counsel for the petitioner would project glaring illegality in the case at hand. Notwithstanding the inquiry officer not being the disciplinary authority, he issues the charge sheet, conducts inquiry and imposes penalty. In that light, there shall be an interim order of stay as prayed for.
38 NR Kopelo.
Some inconvenience, my lord, it may be taken next week. Next week, my lord.
Just in second week of March, next.
Please.
39, Vadiraj, Shivraj Balloli.
Your lordship, so please to direct me to take notice for 1 to 5. But I can take notice only for respondent number 1, my lords. 2 to 5, my lords, separate
I'll
panel is
take
there.
notice for respondent number 5. Mic ತಗೊಂಬಿಡಿ.
My lords,
Mic ಇಟ್ಕೊ.
please, sorry, my lords. Lords, I can take notice only for respondent number 1. 2 to 5, my lords.
2 to 5 ಯಾರು?
I am taking for 5, my lord.
Learned counsel so and so accepts notice for respondents 2 to 5. Shivraj Bullalli only for the first respondent. 7 and 8 yaru?
Prashant is already appearing.
You are there. Yes, madam.
The copy has been served on me. I have not yet received the copy of the.
Petitioner to serve set of papers upon
Please, ma'am.
the aforesaid counsel, all the aforesaid counsel forthwith. Bless the matter in the second week of March. Next.
Obliged.
Number 40, Gangadhar S. Puskiri, Pawan B. Dodati.
Petitioner was, plus the KDB officer sought another 10 days time.
Blessed in the second week of March.
Please, nurse.
ಇವರಲ್ಲಿ
12:30 board matter.
ವಿಶ್ವನಾಥ್
Vishwanath Bichigatti.
ಒಂದು ನಿಮಿಷ ಮೆಡಿಕಲ್ ಟರ್ಮಿನೇಷನ್
Please, please, my lord. Emanating from.
ವಿಚ್ ಹಾಸ್ಪಿಟಲ್?
My lord, Koppala, my lord.
ಕೊಪ್ಪಳ
Please.
ಅಲ್ಲೇ ಮಾಡ್ತೀರಾ? ಮೆಡಿಕಲ್ ಬೋರ್ಡ್ ಇಲ್ಲೇನಾರು ಮಾಡ್ಬೇಕಲ್ಲ?
ಇಲ್ಲ, ಅಲ್ಲಿದೆ sir, ಅಲ್ಲಿದೆ. There is a medical board at page number 17, my lord. Please.
To assess the ಕೊಡಿ ಮೇಡಮ್ ಎಂಟ್ರಿ ಮಾಡಿರ್ತಾನೆ ಎಲ್ಲ ಕೊಡಬೇಕು. The petitioner heard the learned counsel appearing for the petitioner. Petitioner is seeking a direction by issuance of a writ in the nature of mandamus to admit the petitioner and take necessary medical steps to terminate the pregnancy of the petitioner. The petitioner, who is now aged 14 years and 2 months, is the victim of rape and sexual assault. Therefore, ಮಿಕ್ಕಿದೆಲ್ಲ ಹಾಕ್ಬಿಡಿ, ಈಗಲೇ ರಿಲೀಸ್ ಮಾಡಿ. Before 1:30 it will be
Please,
released.
please.
1:30
Great.
to 2 o'clock.
Lord, may I request for hand delivery?
Yes, hand
Please,
delivery.
great.
But ಇದನ್ನ you have to communicate which hospital ಅಂತ ಹೇಳ್ಬೇಕಲ್ಲ.
ಹೇಳ್ತೇನೆ sir. Respond number 3. Respond number 3.
Urgency ಇರುತ್ತೆ, that is why
ಹೌದು.
the
Respond
child
number
should not be a problem. ಯಾವ ಹಾಸ್ಪಿಟಲ್ ಅಂತ ಹೇಳ್ತೀರಿ? ಯಾವ
Respond number 3, my lord.
Which respond number 3?
Koppala Institute of Medical Science.
Perfect. Koppala Institute of Medical Sciences. They will examine the child immediately and give a report by this evening. List the Monday morning.
Please, please. Fresh
The matter on Monday morning.
Fresh matter.
Tomorrow, let them examine the child tomorrow.
Please, please. Great.
Tomorrow by about 11 o'clock ಅಂತ ಹೇಳ್ಬಿಡಿ. Monday morning, the report should be here.
Please.
Seriously.
Please, please.
Yes.
Deeply obliged.
Yes.
Bill number 41, Vaibhavi Nanda.
Lords, I'm challenging the compromise decree, my lords. My lords, dated 4/10/2021, my lords.
Let it come immediately after.
My lords,
Page alla.
I seek for disposal, my lords. My lords, it is covered by.
Covered by what, madam?
Let's see, in the similar set of facts, my lords, coordinate bench of this honorable court has held this.
This has to be heard. I've granted an interim order.
It is there. In fact, she claims to be a daughter. She was
I am-
not as a third party, and we filed a suit.
I have,
We heard. List the
At
matter
the-
on 10th March.
The most what would be that the suit has to be, in fact, they have filed a suit, but there is no prayer.
List the matter on 10th
my
March.
lords,
Interim order
next week, any
subsisting.
date, my lords, next
10th
week,
March.
next week.
I would have considered saying that.
I'll let-
Lords, the only question is, my lords,
27th. List the matter on 27th in the fresh matters list.
obliged, my
Yes.
42, Ramchandra Mani, JB Patil.
Lord, regularization of my lord staff nurses working beyond my lord 10 to
ಎಷ್ಟು ವರ್ಷ?
10 and 10, my lord 1 to 3, my lord, they are working
ಸ್ವಲ್ಪ
for
ಕಮ್ಮಿ ಆಗೋಯ್ತಲ್ಲ?
15, and 4 and 5, my lord, they are my lord working over 10 years.
ಕಷ್ಟ.
Second
10 years
round, my
ಆದ್ರೆ
lord,
ಕಷ್ಟ.
last occasion, I brought to my lord's notice, my lord, page number 100, previous order, my lord, wherein the statement was made by the Kims, saying that they were appointed against the vacant post, and they have been issued, my lord, appointment orders, recruitment notification was issued, roster is followed, everything.
I will only direct consideration, that's all. No positive direction.
And added to that, in fact, last occasion, previous order itself shows that we had sent the proposal to the state government.
You
Let them
ಮಾಡಿದ್ದೀರಾ?
our anta submission ittu. In fact, if my lords
there
were
is
pleased to see
their
the
own
cost
statement,
statement, my lord, page number 100 may kindly be seen. Para 7. Consider ಮಾಡಿದ್ರೆ
Consider on this. Will direct consideration in the light of my judgment
Please,
yesterday. The petitioner is before this court seeking the following prayer. Heard Ramchandra Mali Sons of Arvind Kulkarni respond HCGP. ನೀವಿಲ್ವಾ ಮೇಡಮ್ ಇದರಲ್ಲಿ?
Idhar respond number 1 is the government.
ನೀವೇ ಕನ್ಸಿಡರ್ ಮಾಡ್ಬೇಕು. ನೈಟ್ ಮೇರ್ ಆಗ್ಬಿಟ್ಟಿದೆ.
Your Lordship, the endorsement has been issued in the year 2019, Your Lordship. They approached this court in the year 2024, Your Lordship.
5 ವರ್ಷ ಏನ್ ಮಾಡಿದ್ರಿ?
Allah, that was my lord to association. It was issued. That is not
10
applicable
years
to me.
ಆಗಿರ್ಲಿಲ್ಲ ಅವಾಗ.
That's what, Your Lordship.
We will wriggle out of everything, don't worry. Yes. The petitioner is before this court seeking the following prayer.
Petitioners, my lord, 5.
Petitioners,
5 jana.
petitioners 3 in number,
5 my lord.
5 in number were engaged as staff nurses on ad hoc basis in the second respondent,
KIMS.
Karnataka Institute of Medical Sciences, the KIMS for short. After rendering continuous service, the petitioners approached this court in writ petition 114665-114725 of 2015. This court disposes the writ petition, directing the respondents to consider the representations given by the association in terms of the judgment of the apex court then in the case of Kamal Prasad. The endorsement is issued to all the persons who are members of the association that regularization could not be done as a matter of course. Therefore, the petitioners are petitioners have individually presented the subject petition. The learned counsel Ramchandra Mali, appearing for the petitioner, submits that the petitioners have been in continuous employment for the last 12 or 13 years. 12 or 13 years are entitled to be considered for regularization. The earlier writ petition comes to be disposed directing consideration, and an endorsement to that effect is issued, which is erroneous. The learned counsel submits that the case of the petitioner should merit reconsideration at the hands of the respondents, owing to the law prevailing today. The learned counsel further submit that all the traits of a regular recruitment were followed. TRAITS, traits. All the traits of regular recruitment were followed at the time when the petitioners were appointed on ad hoc basis or contract basis as staff nurses, as the case would be. The submission is also placed on record. Since the cases of the petitioners have not met appropriate consideration at the hands of the respondents, despite the objection of the respondents, I deem it appropriate to direct the respondent to reconsider the case of these petitioners, bearing in mind the law laid down by the apex court in the case of Shipal versus Nagar Nigam 2025 SSC online SC page 121, and other judgments, all of which are considered by this court in 1005596 of 2020. None of disposed. We shall discuss. For the aforesaid reasons, the following order: petition is allowed, so and so stands quashed. The matter is remitted back. The cases of the petitioner shall now merit reconsideration at the hands of the respondents, bearing in mind the observations made in the course of the aforesaid order.
Obliged. Time limit, my lord.
Within 3 months from the date of 4 months from the date of receipt of the copy of this order.
Please read.
43, Shrihar Nilopan, J.K. Hiregowda.
My lords, covered by decision of this, please. Annexure S and S3, my lords.
Yeah, serve the copies, my lord. Yes.
S and S3.
Serve the copies, my evening. Request on Monday or Tuesday.
The petitioners are agitating their grievances since 1996 for allotment of sites and compensation amount, my lords.
ಎಷ್ಟೊಂದಿದೆ?
Monday, I will make my senior will make submission.
Tuesday, yes, list on Tuesday in the fresh matters list.
No, sir, I will
Please.
take notice for R1 in.
Learned AG accepts notice for the first respondent.
Number 44, Jendra Bhima Kanor.
But sir, award of Lok Adalat is challenged on the ground of fraud lots. The respondent number 1 and 2 showing wrong genealogy as the sisters of
ಯಾವತ್ತಾಗಿರೋದು?
what's it's passed on
9/9/23.
20.
Emergent notice to the respondents. Pendency, it is made clear that the pendency of this petition will not alter the rights of the respondents that are created pursuant to the decree of compromise. Yes, next.
Number 45, Satish S. Raichu.
Lord, I appear for the petitioner. This is, my lord, the forest department tender with regarding supply for polythene sheet, my lord. The notification is for the suppliers and manufacturers. Your lordship says please to hear. But now my technical bid has been rejected on the ground, your lordship says.
Third.
Lord,
Just on third
now
March.
the period is, my lord, very short.
Yes, sir.
Now,
Yes. Period in it, tender period in.
31,
now, kindly see, my lord, that is,
very shortly is going to be expired.
no, kindly see what, that is what.
March 31st.
Mars, Allah, kindly see the, my lord, what they says in the tender, page number 32 for a moment, kindly see, for 32, it says, extended till required time or the next day.
Stay ಅಂತ stay ಆಗಿಲ್ಲ.
ಅಲ್ಲ, pardon?
Entry ಮಾಡ್ರೆ ಇಲ್ವಲ್ಲ?
Interim order ಕೊಟ್ಟಿದ್ದೀರಾ, but ಇದೆ.
Status quo is there.
Status quo in respect, but they are, my lord, respond number 4 to 6 way, permitted to, my lord, supply. They are the manufacturers, my lord, they are been doing it. For all 13 circles, they are, my lord, it is nothing but a monopoly. 7/1/2025, your lordships are ordered
In
there.
this case, my
Oh,
lord.
polythene bag.
Yes, my lord, polythene
and, my lord,
bag,
seeds.
which has
Bags
been
and seeds.
seeding. And all the 9 conditions, my lord, pertains to the rejection is manufacturer.
No, sir, filed detailed
Lorships
objections.
were, in
I have
fact, about to
filed
allow.
objections. My lords, not only on the, my lords, the ground of supplier, he has not provided, my lords, the relevant
Third March.
documents.
All the relevant documents was not,
List on 3rd March, yes.
my lord, the interim order may kindly be.
Interim order subsisting with status quo ತಾನೆ ನೀವೇ ಮಾಡ್ತಾ ಇದ್ದೀರಾ?
ಅಲ್ಲಲ್ಲ, status, ಅಲ್ಲ, ಅದಕ್ಕೆ that lord, that is coming. No, your lordship says, in the light of the parties maintain status quo where the work order is already issued or to be issued till the next date of it.
ಈಗ ವರ್ಕ್ ಆರ್ಡರ್ ಇಶ್ಯೂ ಆಗಿದೆಯಲ್ಲ?
ವರ್ಕ್ ಆರ್ಡರ್ ನ ಚಾಲೆಂಜ್ ಮಾಡಿರೋದು ನೀವು, ಅದಕ್ಕೆ ಎಂಟ್ರಿ ಮಾಡಿ ಇಲ್ಲ, ಮೊನೋಪಲ್ 4 ಸರ್ಕಲ್ ನಲ್ಲಿ ಬಿಟ್ಟು 13 ಸರ್ಕಲ್ ನಲ್ಲಿ ಅವರೇ ಇದ್ದಾರೆ. ಅಂಡ್ ಮೈ ಲಾರ್ಡ್, ನೌ ದೇ ಹ್ಯಾವ್ ಇಶ್ಯೂಡ್
3rd March.
at least Monday, my lord, I will take a chance. Monday, Tuesday, my lord. Otherwise, my lord, now the other circles are also called for a tender, my lord. Now they are concentrating only on the manufacturer, though there is a, my lord, the specification of a supplier also.
Yes. Third.
My tenders will be, my lord.
Interim order ಕೊಟ್ಟಿದ್ದೀನಿ.
Allah, that lord, he is continuing, my lord. I am not being able to, the price, if you lordships kindly see the order itself, my lord, there is no collusive bid, my lord. There is no single paisa which is
Put
different.
the bench on 25th, yes. Next.
Lord, 25th, you lordship.
I am not sitting on 25th. So move Justice Suraj Saab. Yes. Next.
My lord, you lordships can have it, my lord, Monday, my lord, I will take a chance.
Monday.
Lord, other,
Ignore I was matter that where will I finish and go? Impossible.
at least on 27th, my lord. 27th, my lord. 27th, otherwise, my lord, I will be,
There,
you lordships, though,
No time to hear and dispose, sir. Sorry, please.
my lord, is a very short matter.
Ah,
You
short
lordships
point.
were but Lord, if
We'll see, post on 24th, I don't know whether.
please, my lord, 24th, my lord.
ಯಾಕಂದ್ರೆ ನೀವು ಜಲ್ದಿ ಮುಗಿಸಲ್ಲ.
ಇಲ್ಲ ತಾವು ಹಿಯರಿಂಗ್ ಮಾಡಿದಿರ,
And be over
ಎರಡೇ
at all.
ನಿಮಿಷ ಅದರಲ್ಲಿ ನಾವು ಟೆಕ್ನಿಕಲ್ ರಿಜೆಕ್ಷನ್ ಗ್ರೌಂಡ್ ನೋಡ್ಬಿಟ್ರೆ ಸಾಕು.
List on 24th. Next.
Please.
46, MB Reddy. MB Kanvi.
Lord, 6 weeks time to get the instructions. I am told that in this order.
Just in the 2nd week of March, yes.
Please.
Pushpi Rao, Sadiq and Gurdwala.
Your lordship. Posting is been given, your lordship.
Given, na?
Order copy.
Third year.
Gajendragarh Town Municipal. your lordship.
ಆಯ್ತಾ, ಕೊಟ್ಟಿದಾರಲ್ಲ. ಸಮುದಾಯ ಸಂಘಟಕರು ಅದೇ ನೀವು.
ಮಲ್ಲಾಡ ಸಮುದಾಯ ಸಂಘಟಕರಲ್ಲ ಇವರು.
ಚಾಲೆಂಜ್ ಮಾಡಿ ಇದನ್ನು.
ಪ್ಲೀಸ್.
But this will close. You file a fresh petition. Pursuant to the orders passed by this court, it transpires that the official memorandum is issued on 21/2/2025, posting the petitioner as Community Affairs Officer to Gajendragad Municipality. The learned counsel submits that the seeks leave of this court to withdraw the petition and reserve liberty to challenge the said order. Disposed as withdrawn, reserving such liberty. Yes. 135.
Plus may ಅದು MTP ಆರ್ಡರ್
ಈಗಲೇ ಅಪ್ಲೋಡ್ ಮಾಡ್ತೀನಿ. Before 2:30 ಮಾಡ್ತೀನಿ.
That's on mention.
ಮಾಡಕ್ಕೆ ಹೋದ್ರೆ because my lords, if the period weeks, my lords, if it's more weeks, then it will be again complicated.
That is why I have passed everything and that I have passed so many orders in Bangalore.
Please.
You should look into that.
My lords, on mentioning the serial number 166 is that.
Adjournment ಯಾರಿಗೆ ಬೇಕೆಲ್ಲ ತಗೊಂಡು.
Not adjournment, my lords. It was that compensation.
Urgency ಇಲ್ಲ, only adjournment.
Compensation matter which was argued by senior counsel Amit Kumar Deshpande.
What compensation?
That ek saal lavani basis or it was absolute grant.
एक साल
lavani basis or.
ಅದು slum
ಏನ್ ಬೇಕಾದ್ರೆ.
ಅಲ್ಲ ಅದರಲ್ಲಿ ತಾವು ರಿಸರ್ವ್ ಮಾಡ್ಕೊಂಡಿದ್ರಿ ದಟ್
ಬೇಡವಾ?
ಅಲ್ಲ
ಮತ್ತೆ ಇವತ್ತು ಲಿಸ್ಟ್ ಆಗಿದೆ.
ಇವತ್ತು ಫರ್ದರ್ ಹಿಯರಿಂಗ್ ಅಂತ
ಫರ್ದರ್ ಹಿಯರಿಂಗ್ ಅಂತ ಬಂದಿದೆ.
ಫರ್ದರ್ ಹಿಯರಿಂಗ್ ಅಂತ ಬಂದಿರೋದು ಯಾಕೆ ಹೇಳಿ? ನೀವು ಅದೇನಾಗಿದೆ, ನೀವು ಸಿನಾಪ್ಸಿಸ್ ಆಮೇಲೆ ಡಾಕ್ಯುಮೆಂಟ್ಸ್ ಸೈಟೇಷನ್ಸ್ ಏನೋ ಕೊಟ್ಟಿದ್ದೀರಾ, ಅವ್ರಿಗೆ ಗೊತ್ತಿಲ್ಲ ಏನು ಅದು.
ಕೊಟ್ಟಿದ್ದೀವಿ.
We have served the court.
ಆಫೀಸಲ್ ಸರ್ವ್ ಮಾಡಿ.
That's the reason I guess I don't know.
ಆಫೀಸಲ್ ಸರ್ವ್.
Why is that come? Let me see.
Milord, serial number 146, Milord.
Yes sir, after lunch.
Bill number 81.
Our adjournment ಬೇಕಲ್ಲ.
ಯಾವಾಗ ರಿಸರ್ವ್ ಆಗಿಬಿಡ ಅಲ್ಲಿ ಹೋಗಿದ್ರೆ ಡಿಸ್ಪೋಸಲ್ ಅಂತ ಹೋಗಿದ್ರು ಕೊಡೋದೇ ಇಲ್ಲ. ನಮ್ಮ ಕಡೆ ಕೊಟ್ಟಿದ್ರೆ ನಾವು ನೋಡಿ ಹೇಳ್ಬಿಡ್ತಿದ್ವಿ. ಅದು ನೋಡಿ
ಕೋರ್ಟ್ ಆಫೀಸರ್ ಮೇಡಮ್.
ಸರ್ ಹೇಳಿ ಸರ್.
ಮೇಡಮ್ ಸಾಹೇಬ್ರು 2:30ಗೆ ಸಿಟ್ಟಿಂಗ್ ಇಲ್ಲ ಅಂತ ಹೌದಾ? ಸಿಟ್ಟಿಂಗ್ ಇದ್ದಾರಾ?
ಇದ್ದಾರೆ ಸರ್.
ಓ ಓಕೆ ಮೇಡಮ್, ಥ್ಯಾಂಕ್ ಯು.
Court officer. Court officer.
ಸರ್ ಹೇಳಿ ಸರ್.
ಮೇಡಮ್ ಅದು 53 ಅಲ್ಲಿ ಟೈಮ್ ತಗೊಂಡಾರ ಯಾರು?
23.
53 ಮೇಡಮ್. ಸೀರಿಯಲ್ ನಂಬರ್ 53 ಲಿಸ್ಟ್ 1.
ಇಲ್ಲ ಸರ್ ಯಾರು ತಗೊಂಡಿಲ್ಲ.
ಓಕೆ ಮೇಡಮ್, ಓಕೆ.
ಅದರಲ್ಲಿ
Deemed
ನೋಟಿಸ್
revoked ಅಂತ ಆಗಿದೆ ನಿಮ್ ಸಸ್ಪೆನ್ಷನ್.
ಸಸ್ಪೆನ್ಷನ್ ಈಗ ರಿವೋಕ್ ಆಗಿದೆ ಆರ್ಡರ್ ಪ್ರಕಾರ ರಿವೋಕ್ ಆಗಿದೆ.
ಅಲೋನ್ಸ್ ಕೊಟ್ಟಾಯ್ತು.
ಕೊಟ್ಟಾಯ್ತು.
ಈಗ ಎನ್ಕ್ವೈರಿ ಸ್ಟಾಲ್ ಆಗಿದೆ.
ಎನ್ಕ್ವೈರಿ ಸ್ಟಾಲ್.
What is your ground now?
Yes. Now kindly see my
For
lord.
stay of the enquiry ಏನಿದೆ ground?
ಎನ್ಕ್ವೈರಿ ಸ್ಟೇ ಆಗಿದೆ. ಸ್ಟೇನು ಕೊಟ್ಟಿದ್ದಾರೆ.
ಸ್ಟೇನು ಆಗಿದೆಯಾ?
ಸ್ಟೇನು ಆಗಿದೆ.
Your Lordship,
Objection.
one more submission. The management undertakes to conclude the proceedings, department proceedings in 2 months time-bound manner. It was stayed, the government has also given permission for appointing an inquiry officer, Your Lordship. The inquiry officer has also given a show cause notice.
Enquiry.
What is wrong with it?
Yes, yes. ಆರ್ಟಿಕಲ್ ಆಫ್ ಚಾರ್ಜ್ ಇಶ್ಯೂ ಮಾಡಿಲ್ಲ, ಇಂಪ್ಯೂಟೇಷನ್ಸ್ ಕೊಟ್ಟಿಲ್ಲ.
ಯಾವ್ದ್ರ ಮೇಲೆ ಎನ್ಕ್ವೈರಿ ಮಾಡ್ತಿದ್ದಾರೆ?
ಎನ್ಕ್ವೈರಿ ಆಫೀಸರ್ ಡೈರೆಕ್ಟ್ ನೋಟಿಸ್ ಕೊಟ್ಬಿಟ್ಟಿದ್ದಾರೆ. ಸೆಕ್ಷನ್ ಎಇ
ಪೇಜ್
95 ಎನ್ಕ್ವೈರಿ ಆಫೀಸರ್ ನ ಅಪಾಯಿಂಟ್ ಮಾಡ್ಬಿಟ್ಟಿದ್ದಾರೆ. ಅವರೇ ನಮಗೆ ನೋಟಿಸ್, ನೋ ಆರ್ಟಿಕಲ್ ಆಫ್ ಚಾರ್ಜ್ ಇಂಪ್ಯೂಟೇಷನ್ಸ್.
ಪೇಜ್
95 ಮಿಲಾರ್ಡ್, ನೆಕ್ಸ್ಟ್ ಎಇ
ಕಾರಣ ಕೇಳುವ ನೋಟಿಸ್.
ದಿಸ್ ಇಸ್ ಬೈ ದಿ ಎನ್ಕ್ವೈರಿ ಆಫೀಸರ್.
ನಿಮಿಷ ತಲುಪಿದಂತೆ ಉಲ್ಲೇಖ 3ರಲ್ಲಿ ನಾನು ವಿಚಾರಣಾಧಿಕಾರಿ ನೇಮಕ ಅನುಮೋದಿಸಲಾಗಿರುತ್ತದೆ. ಯಾರು ಪಾಸ್ ಮಾಡಿರೋದು ಇದು?
ಎನ್ಕ್ವೈರಿ ಆಫೀಸರ್.
Who has permitted him to do this?
That is one absolutely.
Who is he?
The management has appointed, Your Lordship.
How did you appoint?
Permission was sought from the
Where is
government.
the charge sheet? Where is the reply to the charge sheet?
Your Lordship, the inquiry officer has just proceeded one step back.
Sorry?
Instead of issuing charges of imputation,
Who has to issue?
the inquiry officer.
Who said inquiry officer should issue the charge sheet?
He has
You
issued.
don't know the law, look into the law and then do it.
Your Lordship, the reason is he has issued a show cause notice.
Which show cause notice?
This is admittedly has issued a wrong show cause notice, Your Lordship.
ರಾಂಗ್ show cause notice ಅಲ್ಲ, ವಿಚಾರಣಾಧಿಕಾರಿಗೆ ನೇಮಕ ಮಾಡುವುದು ಅನುಮೋದಿಸಲಾಗಿರುತ್ತದೆ. ಏನ್ ಮೇಡಮ್ ನೀವೇನ್ ಮಾಡಿದ್ರಿ? ಹೆಂಗ್ ಅನುಮೋದನೆ ಕೊಟ್ರಿ ಇದಕ್ಕೆ?
Later on we have given the.
ವಾಟ್ ಲೆಟರ್? ನೀವು ನೋಡೋದಿಲ್ಲ, ಇಲ್ಲ ಸುಮ್ಮನೆ ಸೈನ್ ಮಾಡೋದು.
ಅಲ್ಲ,
The permission is given.
ಅವ್ರದ್ದು ಇಂಪಾರ್ಟೆಂಟ್. ನಾನು
how did you grant permission to appoint this inquiry officer without charge sheet? For what is he going to inquire? What is he going to
Before
inquire?
suspension, Your Lordship, they have not sought for any permission from.
That's all right. Now you have given ಅನುಮೋದನೆ to conduct inquiry.
Please.
ಯಾವ ಚಾರ್ಜ್ ಶೀಟ್? ಇದು ವಿಚಾರಣಾಧಿಕಾರಿಯಾಗಿ ನೇಮಕ ಮಾಡಿಕೊಂಡಿರ್ತಾನೆ.
Departmental inquiry officer should have been. Please, Your Lordship.
ಈ ತರ ಲಾಲೆಸ್ನೆಸ್ ನಾಟ್ ಸೀನ್. ನಿಮಗೆ ಏನ್ ಯಾರು ಅರಿತವರು ಇಲ್ಲವೇ ಇಲ್ಲ ನಿಮಗೆ ಮ್ಯಾನೇಜ್ಮೆಂಟ್ ಅಲ್ಲಿ.
Your Lordship, now.
ಸಬ್ಸಿಡೆನ್ಸ್ ಅಲೋವೆನ್ಸ್ ಕೊಡಲ್ಲ.
Your Lordship, now we have instructed the management, Your Lordship. So that is the undertaking by the management that will go in accordance with law and will.
We'll quash this whatever you want. This can't sustain at all.
But Your Lordship, liberty may be reserved for the
Liberty
management.
that is always there. And state, don't blindly give everything like this. Whatever the management asks.
And whole
ಫೋನ್ ಅಲ್ಲಿ ಕೇಳ್ತಾರೆ, ಅದೊಂದು ಲೆಟರ್ ಕಳಿಸಿ ಸೈನ್ ಮಾಡಿ ಅಂತ ಸೈನ್ ಮಾಡಿ ಕಳಿಸ್ತಾ ಇರೋದು ಅಷ್ಟೇನಾ? The petitioner is before this court calling in question an order dated 19/11/2024 and a show cause notice dated 1/12/2024. 1911 ಏನು ಸುನಿಲ್?
1911 may not be, now I will not press it. That is subsidy, rejection of subsidy allowance.
So and so. The learned counsel appearing for the petitioner submits that he would not, the prior quay 19 order dated 19/11/2024 would not survive for the present, survive for the reason that the petitioner is already paid subsistence allowance. Therefore, what remains to be considered is the show cause notice dated 1/12/2024. The petitioner is a lecturer working in the fourth respondent, working in the institution, society now.
Yes. Lordship's fifth respondent.
Working in the fifth respondent run by the fourth respondent. On 10/9/2012, the institution is admitted to grants at the hands of the state. Petitioner is also one among those teachers who is admitted to the grant and is receiving grant from the hands of the state. Owing to a dispute between the petitioner and the management, it transpires that she was removed from the post of principal and the
No, you.
No, no, she has not been given the post of, on the basis of
Owing
seniority.
to a dispute with, dispute between the petitioner and the respondent management, the claim of the petitioner to be appointed as principal is turned down and a junior of the petitioner is appointed to the post of principal. Based upon this, it transpires that that proceedings are sought to be instituted against the petitioner and the petitioner was placed under suspension. Subsistence allowance was not paid to the petitioner, therefore, subsistence allowance was not paid to the petitioner and a departmental inquiry was sought to be conducted. It is at that juncture the petitioner is at the doors of this court in the subject petition. The learned counsel Sunil Desai appearing for the petitioner would contend that the inquiry officer has issued a show cause notice directing the petitioner to appear in an inquiry that is sought to be conducted by him. He would submit there is no charge sheet issued, no reply from the hands of the petitioner. The inquiry officer has assumed the role himself and he wants to conduct an inquiry upon what is unknown. The learned counsel submits that there is no procedure or procedure known to law followed in the case at hand. The learned counsel appearing for the management submits that one HR Deshpande was appointed as an inquiry officer by the management. This was communicated to the state. The competent authority has accorded approval for the appointment of the inquiry officer. The state also has not looked into the documents as there is no charge sheet even issued against the petitioner. The learned counsel appearing for the respondent management would seek to defend the action on the ground that the inquiry will be conducted now, but the inquiry officer has issued a faulty notice to the petitioner. Therefore, they be reserved liberty to initiate proceedings in accordance with law. The state also would plead the same, contending that no permission was sought at the hands of the state to place the petitioner under suspension, nor permission is sought at the hands of the state to initiate departmental inquiry. What was communicated to the petitioner was only, to the state was only the appointment of the inquiry officer. In that light, the learned HCGP would submit that if proceedings are initiated in accordance with law, the same would be considered and necessary orders would be passed. As and when the documents are sent to the state for approval as necessary in law. In the aforesaid so and so. The issue lies in a narrow compass. What drives the petitioner to this court is a twin circumstance. One, placing the petitioner under suspension in terms of suspension and non-payment of subsistence allowance, and the other, issuance of show cause notice by the inquiry officer. The first instance, the first circumstance is no longer in subsistence as the petitioner has been paid subsistence allowance as on date. The grievance now revolves around the show cause notice. The show cause notice so issued by the inquiry officer reads as follows. Page 95-96. It transpires that the management had communicated to the state with regard to the appointment of the inquiry officer. That is approved by the management, by the state. Therefore, the inquiry officer assumes himself the role of the disciplinary authority and issues a notice directing role of the inquiry officer to conduct an inquiry notwithstanding the fact that there is no charge sheet issued, there is no reply sought from the hands of the petitioner, and the entire proceedings are taken up in blatant violation of the basic tenets of conduct of a departmental inquiry. The inquiry officer traces his power in the notice to rules.
Karnataka Departmental of School Education, Pre-University Academic Registration and Administration Granting Rules to 2024.
Said rules itself contemplates a procedure for conduct of disciplinary inquiry. Unless this is initiated, unless this is, the procedure is followed, no inquiry,
Rule 34, my lord.
no inquiry would be no inquiry can be permitted to be continued. Admittedly, in the case at hand, the procedure is not followed even to its remotest sense, as there is no charge sheet issued against the petitioner. The inquiry officer is directing the petitioners to appear before him without even issuance of the charge sheet. This cannot be permitted. This cannot be permitted as it is not in tune with law. In that light, the petition deserves to succeed. For the aforesaid reasons, the following order. The notice issued to the show cause notice issued to the petitioner by the inquiry officer stands quashed. However, liberty is always reserved to the management to initiate proceedings in accordance with law, bearing in mind the observations made in the course of the order.
Yes. Your Lordship, in the connected petition, the prayer does not survive for consideration.
Yenadu?
There's a petition preferred by the management, Your Lordship.
In the light of the order passed in this petition, the prayer sought in the companion petition would not survive for consideration at this juncture. It is disposed as having become infructuous.
Much.
Yes.
49, AD Nada.
I beg to appear through VC Lordship.
Serial number 49, I request for a 10 days time.
I beg to appear through VC Lordship. Lordship, before I take this honorable court to the fact, Lordship, I just want to make one opening submission, Lordship. Respondent number 3 was.
I will quash it right away. Oral gift alla tagondogi assistant commissioner munde ಏನು ಮಾಡ್ತೀವಿ? What is this? Written gift alle conditions illa andre Supreme Court says not to entertain. Oral gift ಅಲ್ಲಿ ನೀವು assistant commissioner ಮುಂದೆ ಹೋಗಿ ಅಲ್ಲಿ ಆಟ ಆಡಿಸ್ತಾ ಇದ್ರಿ ಇವ್ರನ್ನ.
It is not my case, it is oral gift. It is the case of the respondents, the petitioners herein. At page number, at annexure, page number 39, I could not get the annexure.
Sir, who went before the AC?
I went in before the AC.
Why did you go?
It was their contention in the civil suit. I have the present respondent number 3.
Civil suit ಅಲ್ಲಿ ಮಾಡ್ಕೊಳ್ಳಿ ಎಲ್ಲ.
If my lordship permit.
I am not going to grant 1 day's time also in this.
One submission.
These are abuse of the process of the law. Assistant commissioner cannot entertain such petitions. How can he entertain?
Mutation entry, my lords, my
He
name.
has no jurisdiction to enter into mutation entries, sir.
It is not a mutation entry. My mutation entry is based upon a gift deed. That is their contention, my lords, page number 39 for a moment.
Who goes before the AC, sir?
I went, my lords.
We will quash the AC's proceedings. Every other proceeding will.
Lords, my submission for my lords is, I am not saying anything.
OS
For a moment,
proceeding
page
is
number
initiated
39
by
for
the.
a moment. Page number 39. Page number 39, it is based
Who
on.
went before the AC?
Lords, before I.
Why did you go before the AC?
Lords, it was the, my lords, it was their contention.
Why? Direct answer. Don't beat around the bush. Mike Tawade.
Lords, it was the contention of the, my lords, the respondent herein, the petitioners herein, oral gift was executed by me. Lords, then, my lords, when they set up the oral gift, my lords, according to Muslim law, there is a certain procedure that is required to be followed.
All right.
Unless they prove, my lords. Lords, once
How does the assistant commissioner get jurisdiction in this?
Lords, if my lords, may I make a submission? Lords, here, my lords, if it is a return gift deed, my lords, if there is no condition, my lords, this court and Supreme Court has taken away, I am not.
Sir, you forget it. Please. How will they? It is their case that they have a gift in their favor.
Please.
All right.
Please.
So, according to you, you have not executed any gift deed.
Please.
Where should it be agitated?
Lords, for a moment, my lords, assistant commissioner has mutated their name based upon I have executed a gift deed.
Assistant commissioner mutated their name.
Their name, Lords, their name came to entire by on the basis of I executed a oral gift deed. It is for them to prove it. Where is the oral gift deed, and the declaration is required to be done.
No, but assistant commissioner.
They have.
What did we say? 1 minute. Why did you go before the assistant commissioner? I'm asking.
Lords, my lords, my name was deleted based upon I have executed a oral gift deed. Lords, subsequently, my lords, when the suit was filed, I came to my oral gift deed. My lords, then I.
All right. Where should you agitate that?
My lords, when there is a oral, my lords, if my lords, for a moment.
Where should you agitate that?
My lords, if the oral gift
Where
deed.
should you agitate mutation entries change on the basis of the oral gift deed?
That is before the, my lords, under Land Revenue Act. My lords, that is.
How did you go before the assistant commissioner?
Lords, under senior citizenship, I had.
No, he has no business
Lords,
to
I am not
entertain
saying-
petitions of
Lords, if my
change
lord-
of mutation entries.
Lords, if my lord should permit, I will go. For a moment, I will read my lords, page number 39. Page number 39, if my lord should permit.
Yes.
Lords, this is the mutation entry application, my lords, given by the, my lords, this is a manual, my lords. Herein I apply.
You challenge it before The appropriate authority not invoking Senior Citizens Act. He has no business to entertain the change of mutation entries, sir. As simple as that.
I'm not saying.
ಈಗ ಬೇರೆ proceeding initiate ಮಾಡಿಲ್ವಾ ನೀವು?
One submission I would not say. Once my
Two
lordship.
OAS is pending, sir, lordship. Two OAS
They have
pending.
initiated. If my lordship permit, I am
Two
reserved
OAS
or
are
liberty.
pending.
Not liberty may be reserved to challenge this mutation entry before my lord, assistant commissioner.
Wherever you want, whatever you want to, this assistant commissioner's order will not remain. That's all.
My lords, if my lords, petition, respondent number 3 is a senior citizen. My lords, I am not saying.
If just because you're a senior citizen, all and every grievance cannot be taken before the assistant commissioner. By invoking the provisions of the Senior Citizens Act.
I'm not saying.
It is for a limited scope.
May I make one submission on the behalf of my...
Mutation judgment kodi Suraj Govindra sir. ನಂದು ಒಂದು ಮನೆ ಬರ್ತೀನಿ.
Very recent one.
ಇದೆಯಲ್ಲ. Yes.
That liberty may be reserved for.
What liberty, sir?
My lords, based upon oral gift deed, my lords.
Senior citizen and takshana, everything solution is before the assistant commissioner under the act.
Even my lords, I can seek a maintenance. That is secondary point. That here, my lords.
Maintenance ನೀವು ಕೇಳಿ, ಕೊಟ್ಟಿಲ್ಲ ಅಂದ್ರೆ ಕೇಳಿ, ತೊಂದರೆ ಇಲ್ಲ.
Yes.
Not these things.
My lords, my submission, that liberty may be reserved, my lords. That
liberty is always there, sir. You can initiate proceedings in accordance with law, not this order. The
maintenance may be awarded, my lords. At least for her, my lords, she is now 70 plus.
Correct, sir. Sympathy will not confer jurisdiction, sir. That's the problem with all the assistant commissioners doing today. Yes, a senior citizen goes with all sympathy, any and every proceeding is entertained. Mutation entry is annulled, sale deeds are annulled.
Lords, I am not saying.
Lease deeds are annulled.
I am not saying, my lords. Here, my lords, it is a case, oral gift deed based upon that. Here, my lords, section 23 provides for that only, my lords. If my lords, that is my submission.
You seek maintenance, no problem at all.
Lords, I am not saying.
You seek maintenance, you have sought change of mutation entries.
Not a mutation entry, my lords. If my lords should, for a moment, page number 39, my lords may produce. That is only my submission.
No. Now, assistant commissioner, now mutation entries are changed in his favor.
Please.
In their favor, not by the assistant commissioner, based upon certain gift deed, oral gift deed or whatever it is.
Please.
That is for you to agitate before some other forum. You cannot go before the senior citizen tribunal and say, I have never executed a gift deed.
I'm not saying. For execution of oral gift, there is certain procedure. I'm not saying. It is for them to prove it. That is based upon this.
Them to prove where?
Page number 39 for moment. I'm not saying.
Where?
It is for them to prove it in the civil court. They are required to
civil
prove
court.
Please.
Not before assistant commissioner.
My lords, I'm not saying.
Before assistant
my lords may
commissioner.
pass any orders. For a moment, page number 39 may peruse, my lords, to pass
Yes,
any
sir.
orders. That I am not agreeing.
Yes.
Lords, here in the application of the above named applicant is as under my mother so and so.
Correct. All right. It is changed.
This is changed based upon the oral gift deed.
No problem. Challenge it. Challenge it where?
Again, then again I should invoke 136.
What to do? You should have invoked properly.
Already they have.
Because it is a senior citizen, we can't say that you can go and file in any forum and any forum can pass an order against you. No, sir. That can't be accepted.
Annexure G and H is there, lordship.
Please.
Annexure G and H, lordship, they have filed OAs before the trial, before the civil court, lordship. Annexure G, page number 45.
I am saying.
2 ASS.
Note, the act has a overriding effect. I'm not saying anything. Act has overriding effect.
Maybe.
I'm not saying.
That overriding effect is what is interpreted.
Yes.
By Supreme Court, by this court, in many cases. Just because an enactment has overriding effect, that does not mean all other statutes should be given a go by, and you can approach this court and take any order.
I'm not saying. I may be reserved a liberty to challenge the mutation entry.
That is what.
Even apart from this,
old man, well, mutation entry na yen beg kodta idare. Anything. The petitioner is before this court calling in question an order dated 2/12/2024 passed by the second respondent assistant commissioner directing change of the mutation entries that stood in the name of the petitioners to be mutated into the name of the third respondent. The learned counsel Mohammad Tahir appearing for the petitioners and Vittal S. Theli appearing for the third respondent, and the AGA for AGA Sharad Makdum appearing for the respondent 1 and 2. Facts in brief, Germain, are as follows. It would suffice if the narration in the issue would commence from the date on which the third respondent approaches the court, approaches the second respondent, assistant commissioner, invoking his jurisdiction under section 23 of the Senior Citizens Act. The backdrop of the petitioner approaching the assistant commissioner is that mutation entry of the property of the petition claiming to be belonging to the third respondent is made in the names of the petitioners. The reason for that is an application submitted by the petitioners before the Tahsildar seeking such change of mutation entries on the ground that the third respondent has by way of oral gift transferred the property into the names of the petitioners. This application of the petitioner on the said score is entertained by the assistant commissioner, and the assistant commissioner now passes an order directing the change of mutation entries standing in the name of the petitioners standing in the name of the petitioners to the name of the third respondent, holding that the gift on manifold reasons. The petitioners are before this court on the said order passed by the assistant commissioner. In effect, the assistant commissioner has now entertained a petition for change of mutation entries at the behest of a senior citizen, owing to the power available to him under the provisions of the Act. The learned counsel Vittal Theli would seek to defend the action. However, after arguing the matter at length, would submit that he be reserved liberty to knock at the doors of the appropriate fora challenging the mutation entries. The submission merits acceptance for the simple reason that the assistant commissioner under the Act does not get jurisdiction to entertain a petition for change of mutation entries. This is by now too well settled a principle of law, as the remedy to the petitioner, remedy to the person who claims that his mutation entries should be changed, should approach the appropriate authority. The coordinate bench in paragraph 5.2. Ravi. In the light of the settled principle of law, the order of the assistant commissioner which directs change of mutation entries is rendered unsustainable. Ideyano Urmila Dikshit? That is condition illa.
Yes, condition.
23 conditions are precedent.
Urmila Dikshit in respect to the conditions, Lordship.
Pertains to section 23 can be invoked only if conditions are mentioned here.
All right, idhan beda. Idirli. Allowed cost liberty is reserved to the third respondent to initiate proceedings in accordance.
Lordship, may I make one submission, Lordship? Considering the age of respondent number 3, Lordship, some maintenance may be granted. Even 10,000 also may be granted. We have no difficulty because she is our own grandmother.
While disposing, the learned counsel appearing for the respondent would submit that the third respondent is not granted any maintenance, and she has now to approach the assistant commissioner yet again. The learned counsel Mohammad Tahir would gracefully agree that 10,000 rupees maintenance they would pay to the mother from
grandmother.
Grandmother from
petitioner
from today.
Obliged.
The submission is placed on record, subject to the payment of, subject to the payment as aforesaid, the following order: allowed, quashed, liberty reserved. Yes.
Your Worship, the respondents may be directed to give the account details as to transfer the account.
Don't worry. Yes. The, in the light of the quashment of the proceedings, the mutation interchange agilla alla? Niminda change ಆಗಿದೆಯಾ?
It is reversed.
Reverse
The entry model is reversed.
It's back in there.
Yes.
Yes.
Number 50, Shiv Prasad Shantangoda.
Milords, appearing for the petitioner.
Deeply obliged.
Milord, this is a fresh matter. Milord, this
Yes,
is a
sir.
fresh matter. Milords, there was an order of the assistant commissioner in favor of the father-in-law petitioner evicting the respond number 4 daughter-in-law, milords. That order came to be upheld by this honorable court by the learned single judge, which was affirmed by the division bench. Thereafter, milords, the magistrate rejects the application for residence by the daughter-in-law. However, milords, in the criminal appeal, the learned sessions judge ignores the order of the learned single judge and thereby grants the residence order in favor of the daughter-in-law, which amounts to judicial indiscipline, milords. She notes
I passed an order day before yesterday. Which is this? Same petitioner? ಇದು ಇನ್ನೊಂದು petition ಇದೆಯಾ?
No, milords, there is no other writ petition, but milords, my colleague would submit an application. I have not annexed the criminal appeal order. If I may, lordship, may kindly. The sessions judge, milords, notes the order of the learned single judge in the writ petition. However, ignores the same and grants the.
ಏನು ಪ್ರಾಬ್ಲಮ್ ಆಗಿದೆ? ನೋಟಿಸ್ ಮಾಡೋಣ.
Lords, I would also like to bring to your lordship's kind attention a criminal revision petition is also preferred challenging this order.
We'll post it on 3rd March. The same person will hear it. Yes. List on 3rd March. Emergent IGA accepts notice for the first respondent. Emergent notice to the second respondent returnable by 3rd. Yes, next.
51, Girish Vibhat, Girish Fulmani.
Surface matter.
ಎಷ್ಟು ಕೊಟ್ಟಿದ್ದೀರಾ?
25 ಕೊಟ್ಟಿದ್ದೇವೆ. 15 I have to pay.
Further deposited, my lords. Thereafter, further order passed, my lords, to deposit 10 lakhs. That has not
15
been, 15 lakhs.
15 lakh.
That has not been deposited.
ಎಲ್ಲಿದೆ? ಆರ್ಡರ್ ಮಾಡಿದ್ದೀರಾ?
ಆಗಿದೆ. 15 lakh, 25 lakh we have already deposited. Further
subject to the condition 15 lakhs.
15 lakh.
ಯಾವಾಗ?
Managing director ಜೋಡಿ there are talks going on, my lords.
Talks,
1 week, my lords. 15 lakh.
Finally, time is granted up to 27th to comply with the order dated 6/2/2025. In the event it would not be complied, the interim order would stand automatically vacated.
That would.
Talks are going.
Talks are going.
ಅಲ್ಲ ಅವ್ರ MD ಭೇಟಿ ಆಗ್ಲಿಕ್ಕೆ ಮಂಗಳೂರಿಗೆ ಹೋಗಿದ್ದಾರೆ.
3rd March ಗಾಗಿ. As the talks get concluded. Next.
52, Santosh Kanal.
Please, my lords.
Annexer G, my lords. He is working in a 28 years, my lordship, until retirement. He is considered only 9 years only retirement pension.
Lord, impugned order has been passed by respondent number 6. Who has to answer?
Who is that?
Pattana Panchayat Karayal.
Town Panchayat, sir.
Town Panchayat.
Saruda.
Sir.
Saru ಆಗಿದೆ. Saruda ಆಗಿದೆ. ಯಾವತ್ತಾಗಿದೆ ಮಾಡಿ ನೋಡಿ.
My lordship. Covered. Similar.
Wait. ಇನ್ನೊಂದು ಡೇಟ್ ಕೊಡು. List on 3rd March. Awaiting the representation.
27, my lord. 27.
3rd.
27.
3rd, sir. Yes.
53, Sangram S. Kulkarni.
I'm for the petitioners, my lords.
National Highway Act. Sorry. Under National Highway Act, award has been passed. Now they are seeking, my lords.
Disbursement.
ಅಲ್ಲ ಅವ್ರದ್ದು they are not the owners ಅಂತ ನಮ್ದು ಕೇಸ್ ಇದೆ ಅಂತ ಅವರೇ ಲಾಸ್ಟ್ ಟೈಮ್ ಸಬ್ಮಿಷನ್ ಮಾಡಿದ್ರು. They have to file, my lords, if there is a disputed facts.
Anyway, seek instructions.
Please.
List on 3rd March. Yes, next.
54, Abhishek Alkale, V. Shravana Basava.
Next speaker, lordship, I will file statement of objections.
ಒಂದು ನಿಮಿಷ ಸರ್, ಏನಿದೆ ಮ್ಯಾಟ್ರ್ ಪ್ಲೀಸ್. Commuted value of pension, why not? ಕೊಟ್ಟಿಲ್ಲ.
I will file statement of objection.
HDMC ನಾ?
HDUD.
ಯಾಕೆ ಯಾರಿಗೂ ನೀವು ಟರ್ಮಿನಲ್ ಬೆನಿಫಿಟ್ಸ್ ಕರೆಕ್ಟಾಗಿ ಕೊಡೋದೇ ಇಲ್ವಾ? ಹುಬ್ಳಿ ಧಾರವಾಡ ಅರ್ಬನ್ ಡೆವಲಪ್ಮೆಂಟ್ ಅಥಾರಿಟಿ ಎಲ್ಲ ಒಂದೇ. 2 weeks to file statement of objections. Next.
55, Harsh Desai.
Moved.
55, sir.
On behalf of the legal services, I'll take out notice.
Without notice?
Allah, I'll take out notice. The second respondent, my lord, is
one Hampi.
Yes.
ಯಾರು ಅಪಿಯರ್ ಆಗ್ತಾರೆ ಅವರು? ಹಂಪಿ ಹೆರಿಟೇಜ್ ಏರಿಯಾ ಮ್ಯಾನೇಜ್ಮೆಂಟ್ ಅಥಾರಿಟಿ ಒಂದು ಇದೆಯಲ್ಲ.
I think Mr. Viresh Budiyal.
ವೀರೇಶ್ ಬುದಿಯಾಳ್. 1345 AGA to Viresh Budiyal, petitioner to serve set of papers upon the aforesaid council after vacation. After March first week, yes.
56, Archikar Gunjani. Suresh S. Gundi.
Compensated, compassionate ground, my lord.
Bank.
Please.
Financial condition.
Please.
Financial status, as well I have produced the
scheme.
Entitlement.
ಗೊತ್ತು. Where is the judgment? Financial condition should not be looked into.
The financial.
Rather, Lordship, the latest.
Canara Bank. Ajit.
Yes.
ಬುರುಕ ಜಡ್ಜ್ಮೆಂಟ್ ಈಗ ಕೊಟ್ರೆ ಬುರುಕದಲ್ಲ
ಇವೊಂದು ಮಲಾಡ್.
ಎಸ್ 1995 ಕೊಡ್ತಾ ಇದ್ರಲ್ಲ ಅಪಾಯಿಂಟ್ಮೆಂಟ್ಗೆ. ಇವರು ಅನ್ರಿಪೋರ್ಟೆಡ್ ಕೊಡ್ತಾ ಇದ್ದಾರೆ.
22 para 20.
ಅದು ಒನ್ ಆಫ್ ದಿ ಪ್ಯಾರಾಮೀಟರ್ಸ್. ಒಂದು ಡಿಲೇ, ಒಂದು ಫಿನಾನ್ಷಿಯಲ್ ಕಂಡೀಷನ್ ಅಂಡ್ ಇನ್ನೊಂದು ಹೇಳಿದೆ ಹ್ಯಾಂಡ್ ಟು ಮೌತ್ ಇದ್ರೆ ಮಾತ್ರ. Very difficult. There are other judgments which say you should not look into financial status. ಹತ್ತರ ಬೇಕು ನೀವು.
Monday.
27ಕ್ಕೆ ಹಾಕ್ತೀನಿ.
Please.
ಅದು ಸ್ವಲ್ಪ ತಗೊಂಬನ್ನಿ ನೋಡೋಣ. ಇದು ರಿಪೋರ್ಟ್ ಆಗಿದೆ.
Reportable.
ರಿಪೋರ್ಟಬಲ್ ಅಲ್ಲ, ರಿಪೋರ್ಟ್ ಆಗಿದೆ.
Please.
2025 SCC online SC page 290.
290. Please.
Yes.
Told Mr. Budiyal does not appear anymore. And Mr. Prashant Gowdar, my lord, now appears.
ಯಾರು? ಪ್ರಶಾಂತ್ ಗೌಡ್ರು.
I'll serve copy on.
ವೀರೇಶ್ ಬುದಿಯಾಳ್ ಅವರು ಬದಲು ಪ್ರಶಾಂತ್ ಗೌಡ್ರು ಹಾಕ್ಬಿಡಿ.
Serial number 55.
ಗೊತ್ತಾಯ್ತು. Yes.
57, Madhukar Deshpande.
Appealing for the petitioner, my lord. Yesterday it was listed and the statement of objection has been filed by the respondent number 3, my lord. The dispute is not between the two institutions, my lord.
Respondent number 3 has filed a statement of objection.
ಹಾಕಿದ್ದೀರಾ?
Respondent number 3, he is arrayed by name.
By name.
He has filed a statement of objection.
You are appearing for him?
No, I am not appearing. Somebody else is appearing.
Swami is appearing.
R3
and
ನೀವು
I am
appear
Swami
ಆಗ್ತೀರಾ?
now.
Yes, sir.
My lord, an order came to be passed by this honorable court, my lord, on
ಅದೆಲ್ಲ
9th
ಹಿಸ್ಟ್ರಿ ಗೊತ್ತು.
January.
ಇವ್ರದ್ದೇನ್ ಪ್ರಾಬ್ಲಮ್ ಹೇಳಿ?
Yes, my lord. Immediately on the next date, my lord, there is no direction, definite direction by this honorable court to hand over the keys. On
Why
10th,
did
my
you
lord,
ask
there is a
handing
court.
over?
No, my lord.
Yes,
Why did you ask handing over of the keys?
and that fact he admits
So
in
where
his,
is where is the communication to hand over the
Yes,
keys?
Annexure A, my lord.
Annexure?
Annexure A, my lord. A. Page number 17, my lord.
17.
Yes, my lord.
ಏನ್ ಫೋನಲ್ಲಿ ಕೇಳಿದ್ದ?
Phone ಅಲ್ಲಿ ಇದೆ.
Yes, my lord. Over the phone, my lord.
ಪ್ರಕಾರ ಹೈಕೋರ್ಟ್ ಮುಂದೆ ಯಾರು ನೀವು ಬೇಕಾದ್ರೆ ಆಮೇಲೆ ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ನೀವು ಅಪೀಲ್ ಹೋಗಿ ಆವಾಗ ನಿಮ್ಮಂತೆ ಆರ್ಡರ್ ಅಂದ್ರೆ ನಾನು ಆವಾಗ
My lord, the next above that, my lord. Last line, my lord. ಅದಕ್ಕೆ ಆಯ್ತು
This
ಅದೇನಿದೆ
ರಾಜೇಶ್
ಇದನ್ನು
CPI ಆರ್ಡರ್
Yes,
ಇದೆ,
madam.
ಅವರು
Yes.
ಬಂದಿದ್ದಾರೆ ನೋಡಿ, ಅದು ಇನ್ನೇನು ಮುಂದೆ ಮಾಡ್ತೀರಾ ಹೇಳಿ, ಕನ್ವೆ ಮಾಡಿ.
ಅವ್ರ ರೈಟಿಂಗ್ ಅಲ್ಲಿ ಬರೋದೇ ಇಲ್ಲ ಅದು.
ಅದೇನಿದೆ ಕೀ ಮಾಡಿ ತೆಗೆದುಕೊಂಡು ಬನ್ನಿ.
Why he should ask me to come to the police?
Your Lordship, after the order passed by this honorable court, the Raghavendra Swami Math, Your Lordship, has given a representation. The
Yavat kotri representation.
representation, Your Lordship, on
When was the order passed?
10/1/2025.
10/1/2025.
2025.
10/1/2020. Representation yavattu?
ಅದೇ representation ಕೊಟ್ಟಿರೋ.
Order yavattu?
Order, Your Lordship, came to be passed on
9th, my lord, 9th January.
9th.
Order direction itta to hand over anta. RSA order any direction?
There is no direction, my lord.
Yes, sir.
Judgment and decree dated 5th August so and so is regular appeal number 11 2003 on file of so and so additional civil judge is hereby set aside. And original suit numbers 15/1998 filed by the plaintiff Math on file additional civil judge and JMF Shivasweta is hereby dismissed.
So ಈಗ ನಿಮಗೆ ಆಗಿದ್ರೆ ಏನ್ ಮಾಡ್ತಾ ಇದ್ರಿ?
ನಾವು Your Lordship,
ಇಲ್ಲ,
as per
ಈ
their
order ನಿಮಗೆ ಆಗಿದ್ರೆ
yes,
ಏನ್ ಮಾಡ್ತಾ ಇದ್ರಿ?
as per their
90 days appeal period ಇದೆ.
yes,
ಅಲ್ಲಿವರೆಗೂ ಅವರಿಗೆ ಹಕ್ಕಿದೆಯೋ?
yes, exactly, my
ಮತ್ತೆ
lord.
ಏನು ನೆಕ್ಸ್ಟ್ ಡೇಗೆ ಕೊಡಕ್ಕೆ?
No, we are not precising for hand over the key, my lord.
ಮತ್ತೆ ಇಲ್ಲೇ
as per their representation, we brought to the notice of the petitioner, my lord. They come and given a representation. There is a order of this honorable court.
Order of what?
Our order dismiss ಆಗಿದೆ.
ಅಷ್ಟೇ ತಾನೆ? ಅಷ್ಟೇ ಅಲ್ವಾ? ಈಗ ಇಮಿಡಿಯೇಟ್ ಸ್ಟೇಟಸ್ ಕೋ ಆಂಟಿ ರೆಸ್ಟೋರ್ ಮಾಡಬೇಕು, ಇಲ್ಲ
ಕೇಸ್ ಡಿಸ್ಮಿಸ್ ಆಗಿದೆ. ಅವ್ರು ಈ ತರ ಆರ್ಡರ್ ತಂದಿದ್ದಾರೆ. ಇದಕ್ಕೆ ನೀವೇನ್ ಹೇಳ್ತೀರಿ? ಸಪೋಸ್ ಏನಾದ್ರು
ನೀವೇನ್ ಹೇಳ್ತೀರಿ ಅಂದಿದ್ರೆ ಓಕೆ, ಕೀ ತಗೊಂಡ್ ಬನ್ನಿ.
ನಾವು ಅಲ್ಲಿ ಮುಂದೆ ಹೇಳಿದೀವಿ, ಹೈಕೋರ್ಟ್ ಆರ್ಡರ್ ಮುಂದೆ ಯಾರು ಇದು ಅಲ್ಲ.
ಅದೇ
ನೋಡಿ, ದೇರ್ ಆಫ್ಟರ್ ಮೈ ಲಾರ್ಡ್ ವಾಟ್ ಹ್ಯಾಪನ್ಡ್, I conducted, Your Lordship, ಶಾಂತಿ ಸಭಾ.
ಅದೇನಿದೆ ಅವರಿಗೆ ಅವಕಾಶ ಮಾಡಿ ಕೊಡಬೇಕು, ಪೂಜೆಗೆ ಅದನ್ನು ಮಾಡಿ. ಆದ್ರೆ ಆಯ್ತು, ಸೋ ಅಂಡ್ ಸೋ ಸುಮ್ನೆ ಇಲ್ಲಿ ಇಶ್ಯೂ ಆಗೋದು ಬೇಡ, ಸಣ್ಣ ವಿಚಾರಣೆಗೆ ಸುಮ್ಮನೆ ಗಲಾಟೆಗಳು ಆಗೋದು ಬೇಡ. ಅದೇ
ನಾವು ಲಾ ಅಂಡ್ ಆರ್ಡರ್ ಸಮಸ್ಯೆ ಆಗಬಾರ್ದಂತ ಅಂಡ್ ಮೋರ್ ಓವರ್ ಆನ್ 11/1/2025 ನಾವು ಶಾಂತಿ ಸಭಾ ಮಾಡಿದ್ವಿ, ಇಬ್ಬರು ಕರಿಸೆ ಮಾಡಿದ್ವಿ.
ಯಾಕೆ ಮಾಡಿದ್ರಿ?
ಅದು ಲಾ ಅಂಡ್ ಆರ್ಡರ್ ಸಮಸ್ಯೆ. ಎವ್ರಿ ಡೇ
ಹೂ ಗೇವ್ ಯು ದಟ್ ರೈಟ್? ಲಾಸ್ಟ್ ಟೈಮ್ ನೋಡಿದ್ದೀನಿ ಅದನ್ನ. ಹೂ ಗೇವ್ ಯು ದಟ್ ರೈಟ್?
ಅಲ್ಲ ಅಂದ್ರೆ ಎವ್ರಿ ಇಯರ್ Your Lordship,
ಎವ್ರಿ ಇಯರ್ ಶಾಂತಿ ಸಭೆ ಮಾಡ್ತಾರೆ.
ಅಲ್ಲ, ಅದು ಆ ತರ ಅಲ್ಲಿ ಪ್ರಾಬ್ಲಮ್ಸ್ ಕ್ರಿಯೇಟ್ ಮಾಡ್ತಾ ಇದ್ರು. ಲಾ ಅಂಡ್ ಆರ್ಡರ್ಸ್
ಮಾಡ್ತಾ ಇದ್ರು. You are the creator of the problem now. Why did you want to interfere in these private affairs?
No, my lord, I am not interfere, my lord.
Okay. Why did you want to interfere in the private affairs?
And thereafter, my lord, they filed a complaint, Your Lordship. Raghavendra Swami Math, Your Lordship, have trespassed in the premises of the Math. They filed a complaint. ಇಲ್ಲಿ ಕೊಟ್ಟಿದ್ದಾರೆ, ಅವರೇ ಕೊಟ್ಟಿದ್ದಾರೆ ಕಂಪ್ಲೇಂಟ್ ಸ್ವಾಮಿ.
Yes, my lord, because when they are supported by the police, they did it. Otherwise, they would not have done it.
On 11/1/2025, my lord.
Immediately on
What
the
do you
same
want
day.
to do, sir, now?
My lord, ಈಗ ಎಲ್ಲ
Will
ಪರ್ಫಾರ್ಮೆನ್ಸ್
direct inquiry to be conducted.
ಇಲ್ಲ ಸ್ವಾಮಿ, ಅವ್ರ ಪರ್ಫಾರ್ಮೆನ್ಸ್ ಎಲ್ಲ ಪೂಜಾನು ಮುಗಿದೋಗಿದೆ.
ಎಲ್ಲ ಆಗೋಗಿದೆ.
ಅದೇ, and moreover, Your Lordship, we are the I am the
You should not take sides. Only when there is law and order problem, you should do
yes,
it.
that is the
ಅದಕ್ಕೆ ಇವ್ರು ಹೇಳಿದ್ರು ಅಂತ ಸೈಡ್ಸ್ ತಗೊಳ್ಳೋದೆಲ್ಲ ಬೇಕಾಗಿಲ್ಲ.
ಅದು ಎವ್ರಿ ಇಯರ್ ನಾನು ನೋಡ್ತಾ ಇರೋದ್ರಿಂದ ಲಾ ಅಂಡ್ ಆರ್ಡರ್ ಸಮಸ್ಯೆ ಆಗಬಾರ್ದು ಅಂತ ಎವ್ರಿ ಇಯರ್ ದ ಸೇಮ್ ಪ್ರಾಬ್ಲಮ್ ಅಲ್ಲಿ ಆ ತರ ಆಗ್ತಾ ಇದೆ. ದಿಸ್ ಇಸ್ ನಾಟ್ ಎ ಪ್ರಾಬ್ಲಮ್ ಫ್ರಮ್ ದಿಸ್ ಇಯರ್, ಮೈ ಲಾರ್ಡ್. ಎವ್ರಿ ಇಯರ್ ಇಟ್ ಹ್ಯಾಸ್ ಬಿನ್ ಹ್ಯಾಪನ್. ದಟ್ ಇಸ್ ವೈ, ಮೈ ಲಾರ್ಡ್.
ಗವರ್ನಮೆಂಟ್
ಅಲ್ಲ ಈಗನೇ
all right, we'll
But
keep this
it is
pending.
appearing in the papers.
We'll keep this pending. If there is any interference again, you move the matter.
No, I am not going to interfere, my lord. Because already matter is in the Supreme Court, my lord. Why should I interfere?
ಯಾರಿಗೆ ಗೊತ್ತು?
ಇಲ್ಲ, I am not interfere. Supreme Court order ಹಾಕಿದ್ದೀನಿ.
Madhukar will keep this pending. Yes.
My lord, my only submission is that, my lord, they did not stop there, my lord. I request my lords to kindly see, my lord, my representation which I gave on 11th, when they trespassed, when they are supported by the officer. Then, my lord, immediately on the same day they issued the NCR. What prevented them to issue the NCR to the other group, my lord? Then, my lord, immediately on 11th, my lord, 11th, they passed an order under section 107 of the IPC, that is 126 under the BNSS. And they say that it is a law and order. My lord, in the Madhu Lime's case, it is specifically at para number 37. What could be there should be a reasonable ground to do that. And they hurriedly, immediately, my lord, they have invoked section 126. And because of that, my lord, I have to face all these things. And this particular litigation has to continue.
Well, litigation is, it's there for long now.
Yes, yes, my lord. My dispute is not with the other institution, my lord. That is pending before another forum. With respect of this particular person.
We'll see. Monday we'll pass some order.
I will undertake, we will not interfere, my lord. ನಮ್ ಕೆಲಸ ನಾವು ಮಾಡಿದ್ರು ಮತ್ತೆ ಅದೇ ಪ್ರಾಬ್ಲಮ್ ಆಯ್ತು.
ಅಲ್ಲ ನಾನು ಹೇಳ್ತಿರೋದು ಅವ್ರ ಕೆಲಸ ಬಿಟ್ಟು ಬೇರೆ ಕೆಲಸ ಮಾಡ್ತಿದ್ದಾರೆ, ಅದೇ ಪ್ರಾಬ್ಲಮ್.
My lord, we will also take steps, my lord. I will instruct him. Allah, because he is our officer, we will say that not to take any sides. Only go according to law.
Yes.
We will also instruct them.
Will close it.
Yes.
Number 58, Ravi Hegde, Prashant Vasmani.
Lord, the impugned order is at annexure 189.
Annexure 189.
Page 189.
Page 189.
Annexure N, page 189. One is, my lord. 189, my lord. Annexure N.
3 increments.
And reduction in my rank. Demotion as well as this.
Under regulation 18, my lords, of the C&D, there is, my lords, power is drawn from there, my lords, to, it can be done.
And
18 for a moment may kindly be seen.
Page?
My lords, the regulation, regulation produced model.
Regulation idea?
Regulation ಇದೆ. And my lord, the order sheet, what they refer it to. My lord, except 2 occasions, it has directly routed through DTO. It was not come to my table at all.
Regulation number 18, my lords.
Withholding of?
Nature of penalties. Any one or more of the following penalties. Any one or more of any.
Then it called 4 impose ಮಾಡಬಹುದು. And that interpretation is accepted. All 4 penalties you can impose. Any one or more. No, sir.
And
penalty can ಈಗ first impose ಮಾಡಿರೋದು ಯಾವ penalty?
Sir, increment, my lords.
ಒಂದು ನಿಮಿಷ.
18A.
Why is the additional educational weight? Oh, that, okay, yes.
It's 18A clause 8, my lords, is reduction of, my lord, increment is 1. Then, my lords, 6, my lords, Roman 6, small 6 is, my lords, the demotion.
ಈಗ major penalty impose ಮಾಡಿದಿರಾ?
ಇಲ್ಲ, major, both are minor penalties. And, my lords, he has got an alternative remedy of filing an appeal before the appellate authority under regulation 31. That has been bypassed. Straight away, my lords, appeal hakilla.
My lord, there is one more judgment of this court. There is Khalil Ahmad's case. Notwithstanding, my lord,
that is there. That is only in violation of principles of natural justice.
Now, my lords, he has got an interim order in this case.
Interim order ಇದೆಯಾ?
Interim order ಇದೆ.
ಇಲ್ಲ, interim order ಕೊಟ್ಟಿಲ್ಲ. ತಾವು ಒಂದಕ್ಕೆ interim order ಕೊಡ್ತೀನಿ ಅಂತ ಹೇಳಿದ್ರು.
One punishment has been stayed. That is increment has been stayed.
ಇಲ್ಲ.
As far as
ಇಲ್ಲ. ತಾವು ಕೊಟ್ಟಿಲ್ಲ. ತಾವು ಒಂದಕ್ಕೆ ನಾನು ಪ್ರಮೋಷನ್ ಡಿಮೋಷನ್ ಸ್ಟೇ ಕೊಟ್ಟು ಸಾಕು ಅಂತ ಹೇಳಿದೆ ನಾನು.
That is because she has already joined the post where now she is demoted.
That has I have produced.
Both penalties cannot be imposed. But you file an appeal. It is
Lord,
I'll only adjourn it.
Appeal, my lord.
No.
It becomes, my lord.
Yeah, no, it becomes nothing. It becomes appeal only.
And
statutory appeal, sir. Yes. Next.
59, Srivatsa Hegde.
Demotion in one ತಾವು stay ಮಾಡಿದ್ರಿ
Seventh
my lord.
March.
This has created a situation where my lord have been
Report
posted.
ಮಾಡ್ಕೊಂಡ್ಬಿಟ್ಟಿದ್ದೀರಾ? 7th
Yes,
March.
report.
So that is also my lord, I sought for stay for that order also.
Appeal
I have
ಹಾಕಂದ್ರೆ
produced
ಕಳಿಸ್ತೀನಿ.
this.
ಈಗ no time to decide. Yes.
59, Srivatsa
In this
Report.
case, I seek my lords, finally weeks time, my lords.
No, no, sir.
ಇದರಲ್ಲಿ objections, my lords.
The state government
Only for
filed the
formality.
objections before the CAT. Now they cannot improvise. Kindly see page 48, my lord. Page 48 of the writ petition. They've already indicated the stand before the CAT. And my lord, they got brickbats by the CAT for their attitude. Kindly see paragraph 10. These are the objections filed by the state government. It is submitted that, left hand side, my lord. It is submitted that the allegations against the applicant are very grievous in nature, as the applicant has conducted himself in a rude and discourtesy manner. Further, the applicant has released the phone record conversation and made it viral on social medias. It is submitted that the conduct of the applicant was against the service rules. It is submitted that the respondent too, having pursued the material on record and there was a prima facie material, and considering the gravity of the conduct, the applicant was placed under suspension pending. This is the exact ground of annexure A. Now kindly see annexure A, my lord. Page number 17. ಮೇಲ್ಕಂಡ ವಿಷಯಕ್ಕೆ ಸಂಬಂಧಿಸಿದಂತೆ ಉಲ್ಲೇಖಿತ ಪತ್ರದಲ್ಲಿ ಶ್ರೀ ಶಿವಾನಂದ ನಾಯಕವಾಡಿ IFS ಉಪ ಅರಣ್ಯ ಸಂರಕ್ಷಣಾಧಿಕಾರಿ ಘಟಪ್ರಭಾ ವಿಭಾಗ ಗೋಕಾಕ ಇವರು ಮಾನ್ಯ ವಿಧಾನಸಭಾ ಸದಸ್ಯರಾದ ಐಹೊಳೆ ದುರ್ಯೋಧನ ಮಹಾಲಿಂಗಪ್ಪ ಇವರು ದೂರವಾಣಿ ಕರೆ ಮಾಡಿದಾಗ ಅವಾಚ್ಯ ಶಬ್ದಗಳಿಂದ ಏರುಧ್ವನಿಯಲ್ಲಿ ಏಕವಚನದಲ್ಲಿ ನಿಂದಿಸಿ ದೂರವಾಣಿ ಕರೆಯ ಬಗ್ಗೆ ರೆಕಾರ್ಡ್ ಅನ್ನು ಮಾಧ್ಯಮಗಳಿಗೆ ವೈರಲ್ ಮಾಡಿ ಹಕ್ಕುಚ್ಯುತಿ ಮಾಡಿರುವುದಾಗಿ ತಿಳಿಸಿರುವ ಪ್ರಕರಣದ ಬಗ್ಗೆ ಅಧ್ಯತ ಸಮಿತಿಯು ಸೋನ್ಸೋ. Now, I am not disputing the privilege of a member of legislative assembly. What is to be considered is, where did he exercise that power? He called an IAS, he is not the minister in charge. He calls an IFS officer to permit illegal construction in the forest area. Kindly see the next page, page number 18. Even before I took charge as the deputy conservator of forest Raibag, a FIR was registered against one Mr. Vaddara, that Raibag, that he ರಾತ್ರೋರಾತ್ರಿ ಹಸನುಗೊಳಿಸಿ ಕಟ್ಟಡ ಕಟ್ಟೋಡ ಸಲುವಾಗಿ ಗುಂಡಿ ತೆಗೆದು ಕಾಲಮನ್ನು ಇರಿಸಿರುವ ಬಗ್ಗೆ ಪತ್ತೆ ಹಚ್ಚಿ ಗುನೆ ದಾಖಲಿ. Accused is Arjun Vaddar. Now this person, he pestered continuously to permit the construction in the forest area. Now several persons called me impersonating Mr. Duryodhan Aihole. One day, that is on January 9, 2024, another call came saying that he is MLA. He said, what do you want? I said, please permit the construction of this structure. I said, it is not permissible because under Forest Conservation Act, central enactment, permission is required. The fact that he called the petitioner for an illegal purpose, kindly see page 73. Page 55. Page 55.
55.
This is the objections filed before the CAT. It is paragraph 6. It is most respectfully submitted that during the conversation, respondent 5 was requesting the applicant to permit construction of a forest building, in respect of which FIR was already lodged by an earlier officer. Now, how this is dealt by the CAT? Kindly see, my lord, page number 77. Now, this order of the CAT has become final. 77, my lord. Left hand side. Simply reading of annexure 8 shows that only fact in the case to be verified as to is already accepted fact that there was conversation between respondent 5 MLA and the applicant on the designated day, which is accepted by the applicant. He may have harshly talked to him as the circumstances were such that it was a case of enforcement of Forest Conservation Act and related provisions of the law, and people were impersonating MLA and trying to influence and interfere with the work of the public servant. In the instance case, the real MLA also talked to him, and it is not clear whether the MLA was inquiring about the facts of the case or he was trying to influence the case. Why did he have the occasion to interfere with the quasi-judicial functions of the applicant? There has to be an arm's length distance between the members of the legislature and the enforcement authorities in the field. And if at all such enforcement act were encroachment of forest land was involved and the FIR was already registered, a member of legislature has to talk to the authority. did he not require the exercise caution and restraint? In such circumstances, the rightful way would be to approach the forest minister or ask information as provided in law, as there was various provisions of the law for asking them in the assembly to call attention or through question or other means, but not directly touching the base with an enforcement authority who can be unduly intimidated and influenced by such encounters. Now kindly see page 24, sorry, para 24 at 86. This incident could have been a good case study to develop a training module for the officers as to how to deal with political interference at the field level in the difficult job of forest conservation and enforcement of forest laws relating to unauthorized encroachment of forest land. The incident could have been triggered the self-imposed conduct by the members of legislature.
What is initiated?
No, what they've done is the suspension order was quashed. Now they have initiated privilege motion against me. Now Sita Soren, my lord, the constitution bench judgment of the Supreme Court, lord, your lordships are aware. Like the famous American doctrine, what happens in Vegas stays in Vegas. What happens in assembly stays in assembly. But he comes out and shouts at somebody. If he had said inside the assembly, if I have gone inside the assembly, I can understand. He had no business to talk to an IAS officer to permit construction in a forest area. That is nothing to do with his performing anything in the assembly. Suppose somebody speaks something in the assembly, that is protected, whatever it is, even to the extent of that your lordships are considering, whether you extend to the extent of physical altercation or verbal altercation. That's an entirely different thing. But an MLA calling an IFS officer, please permit construction of illegal activities in the forest area, that is something which is beyond the scope of Article 194. Kindly, I'll only read one paragraph, my lord, in the Supreme Court judgment in Sita Soren. I think, my lord, the judgment was passed on to your lordship. Yes, my lord. There, my lord, kindly see paragraph 82. But the privilege aspect is concerned, my lord, I do not dispute. They may have privilege. For example, he has asked for the release of the food.
This is not spoken in this session.
No. But assuming for a
privilege motion.
Yes, assuming for a moment that I am a DDPI, that I have prevented distribution of the food to the children in the afternoon, like eggs, sir. He has every right to call upon me, and yes, he can ask me why he have stopped distribution of food. He is asking for illegal construction in the forest area about which FIR is already filed. Kindly see paragraph 82. The privilege exercised by the members.
MLA will get exposed now.
Pardon me?
What made, my lords, having regard to the telephonic call, my lords, he made it circular, my lords, in the social media. That is the, my lords, that's why this.
But the
call record.
Exactly
call
the
record.
allegation
Between.
Please.
No, that is exactly the allegation before the CAT. They proved.
Why did you?
No. I carry iPhone. It is
media.
Those. No. I have completely denied it. They could not prove before the CAT that I recorded. That is the very foundation.
No. Suspension was on that ground.
Only on that ground that I recorded, and I have heard the conversation. The entire conversation. The anchor attacks me.
Your suspension was based upon the circulation in the social media of certain conversation, correct?
Number one, making scurrilous attack against the MLA, and second one is recording and releasing to the media. Both, my lord, they could not.
Where is the order of suspension?
Kindly see the order of suspension. Is at page number 26. Identical grounds. But it appears they initiated the proceedings simultaneously, and thereafter the notice came.
Order of suspension.
But page number 25. Page number 25. Whereas the principal conservator of forest, while letter dated so and so, following yours.
Same grounds.
Same grounds, identical grounds. And I circulated. They could not prove it. Yeah, as a matter of fact, before the CAT, they did not.
Suspension set aside. So it's privilege motion.
Formal objection, my lord.
No,
they stand very clear before the CAT
No, the order passed matter, then appeal al wapas bar. Objection we'll post it for further hearing on 7th.
Please.
Heard the learned senior counsel S. Basavaraj appearing for the petitioner. The learned senior counsel takes this court through the documents appended to the petition to demonstrate that the abuse of power available under to demonstrate, prima facie demonstrate abuse of power under Article 194(2) of the Constitution, 194(2) of the Constitution of India. The Learned Senior Counsel submits that based upon the alleged circulation in the social media of the conversation between MLA and the petitioner, led to the passage of the order of suspension on 21st February 2024. The Central Administrative Tribunal, by a detailed order considering these aspects, holds there was no allegation against the petitioner that could have led passage of the order of suspension. The order of suspension is quashed. Immediately thereafter, the member of the Legislative Assembly appears to have moved for a privilege motion holding that it is in violation of the Constitution and the immunity that the MLA would, member of the Legislative Assembly would enjoy. The matter would require further consideration, for which the filing of the statement of objections by the state is imperative. List the matter on 13th March at 2:30 p.m. for further hearing. Interim order subsisting will continue to the next date. 3:30 matter thought. Oh my God. 3:30 matter. Officers are waiting.
3:30 matter serial number 199. Pooja Saudati.
Madam.
What's that,
It's a
madam?
list of authorities, my lord.
Authorities ಆಯ್ತು ಇದು the transcript. No, not the authorities, madam. This, I asked you for the transcript. Video ಹೇಳಿದ್ರಲ್ಲ.
Video I have filed, my lord, filed yesterday. Yesterday I have filed the filing count. Received the copy also.
ನಿಮ್ಮ ಹತ್ರ ಇದೆಯಾ?
They have received the copy also, my lord, yesterday.
The newspaper publication.
Newspaper copies along with the pen drive I have some.
ಇಲ್ಲದೆ ಇದ್ದಂಗೆ. ಅವ್ರ ಕಾಪಿ ಕೊಟ್ಟಿದ್ದೀರಲ್ಲ?
ಕೊಟ್ಟಿದ್ರು.
It's here. Yes. Yes, sir.
But the state has filed a statement of objection. Along with that, annexure A17 has.
So you said that they were the aggressors.
Yes. We have produced the.
Who was the officer in charge that day?
The Advocate General.
Advocate General? No.
He is the Commissioner of Police.
Oh, this Commissioner of Police.
He has given a permission to.
Lathi charge.
Conduct the proceedings and a prohibitory orders was been issued. Learned Advocate General
is not there.
And also filing.
Copy ಕೊಟ್ಟಿದ್ದೀರಾ ಅವ್ರಿಗೆ?
Or ಕೊಟ್ಟಿದ್ದೀವಿ. That one more pen drive.
What is your version? You said they are the aggressors.
This is a pen drive produced along with the certificate.
All right.
Earlier I produced along with the statement of objection, but was not attached with the certificate. Now the same pen drive with the certificate, all the under the new 64 attachment.
Who is the ADGP?
The ADGP was in charge of land order. I request this honorable court few videos. That videos clearly indicates the scenario is like that. They are permitted to conduct the meeting at particular place. The ADGP accompanied the four ministers for the negotiation person, and he met the Swamiji.
ADGP for negotiation?
No, it means no. The requesting the Swamiji for the government will. He is only support. He is accompanying the ministers. Ministers went to meet the Swamiji, and he is the ADGP with the Swamiji with the ministers, and in the deliberation, my lord, the ADGP has requested.
No, without any warrant in the sense without any necessity, why did you go for negotiation?
No, negotiation means, my lord, he has only initially, he has only escorted the ministers for the meeting, where he has discussed.
Which meeting?
Which
meeting? This meeting.
Meeting, where the.
It is MLA and ministers were there in the meeting.
Were there in the meeting?
All right.
They went, requested the Swamiji. The problem, the government is in the ministers requested the Swamiji. Government is in the consideration of the proposal in accordance with law. So we requested. Even the video says, but not the ADGP is supporting us. The Swamiji says, man. ADGP in clearly Swamiji says ADGP is in supporting us. ADGP has come to protect us. This is a version of the Swamiji.
Why would suddenly these people?
Please. That is the crux of the matter. Immediately, my lord, the ministers requested the Swamiji, please, representing the association, please 10 members come to the meeting, to the Suvarna Soda.
Who requested?
All the ministers and initially ministers have requested.
All right.
To negotiate solve the problem. It can't be done in the public.
All right.
Please, the government has requested the Swamiji and followers, 10 members come to the meeting.
All right.
Then for that, the followers have not agreed. They wanted we all should go to meet the chief minister at the Suvarna Soda. So therefore, the ADGP has requested, that is all in the video. ADGP said, so already prohibitory orders are there. Court said, don't leave this place. They come to place. They sat on the national highway. Barricaders was put. Thrown the barricaders on the police. My lord, videos are clearly indicating that, my lord, lathi charge was done after the thrown of the stones. Chappals are thrown.
What is your version, ma'am?
Every video, 4 to 5 videos, my lord.
My lord, senior counsel.
Tell what is it? Yes.
My lord, since the event was taken place, it was far away from the Suvarna Soda, about 5 kilometers far, and they were staying at for 2 to 3 hours. There, all policemen came there and they negotiated with Swamiji and other leaders. Whereas after the event, we started coming down from the passage, the petitioners and the other people, protesters. While they were coming down from the stage, they stopped us by the barricades, putting 3 layers of barricades unnecessarily without letting us go out from that place to go and catch our vehicles. Our vehicles were parked far from 4 to 5 kilometers. They only arranged the parking lot. Towards that, we were moving. And when there are more than 5,000 to 10,000 people coming down from that passage, how can they stop us by putting 3 layers of barricade, my lord? And then when we stopped there, again they rushed and they parked their police jeeps, buses in the middle of the highways by blocking the traffic. Produce the videos, my lord. Produce the photos.
No, ಎರಡು ನೋಡ್ಬಿಟ್ಟು ಸೋಮವಾರ ತಗೊಂತೀನಿ.
Video ನೋಡ್ಬಿಟ್ನಪ್ಪ ಅಂದ್ರೆ.
We'll direct holding of an inquiry, judicial inquiry, if it is needed.
Yes. So, only my submission is not. Videos are clearly indicating. My lord, I will demonstrate, my lord, ADGP has taken so much of care. And Swamiji has appreciated the ADGP in the video. ಅದಕ್ಕಿಂತ ಮುಂಚೆ ಹೇಳ್ತಾರೆ ಅವರು. ಅಲ್ಲ, ಕಲ್ಲು ಒಗಿತಾರೆ, ಚಪ್ಪಲಿ ಒಗಿತಾರೆ, ರೋಡಿಗೆ ಬರಬೇಡ ಅಂದ್ರೆ ರೋಡಿಗೆ ಬರೀತಾರೆ, ಬ್ಯಾರಿಕೇಡ್ ಒಗಿತಾರೆ. ADGP has taken a ಲಾಠಿ ಯಾವಾಗ ತಗೊಂತಾರನ್ನಪ್ಪ ಅಂದ್ರೆ ಅಲ್ಲಿಂದ ಒಂದು 500 meters ಇಂದ ಕಲ್ಗಳು ತೂರ್ತಾರೆ.
My lord, in the video
videos clearly demonstrate, my lord. It is a clear, there is a
Lord, in 2 minutes of video which we have produced with a pen drive, with a certificate as such. There, in the 2 minutes of video, clearly it is shown that the ADGP policeman has himself taken the lathi and started provocation towards the protesters, and without any aggression from the part of policemen, they cannot throw the stones or they cannot throw the slippers, my lord. And when the protesters were peacefully going towards the parking lot, they themselves started beating. And in respect to that beating, they revengefully thrown.
Watch the video and take it on Monday.
Please.
Both versions are here.
Please.
You have also filed.
But I request the serial numbers, the important serial numbers in that video. So there are more than 60 clippings, with certificates we have given. I will mark the some of the important videos. If my lordship was the videos, that clearly indicates the entire actions.
Let's see
whether who are the aggregators.
My lord, in the video coverage, even we have included the national TV channels which covered every footages. And even, my lord,
we admit that lathi charge has been done. At what instance? What is the purpose of lathi
When
charge?
do you, when do you indulge in lathi charge?
The situation is really required for the lathi charge. Really required for.
What is the procedure for?
All the procedure has followed, my announcement has done. Against that, they have brought the.
The announcement also is found in the video?
Yes, well, that can't be done. Because of that, they brought a big, sound systems with musics.
Musics?
Both of them.
And they were permitted by the district commission.
Music permission kotilla now. Music we are not given a permission. We are given a permission only to protest peacefully at the particular place. Not to carry, and tractor, this honorable court in the interim order categorically said you should not bring the tractor.
And that was stopped, my lord. We did not bring any tractors, my
in the
lord.
videos, it's everything there. They bring the tractors.
We
also.
obeyed the honorable court's order and we did not bring
I'm
any
sorry to
tractors,
say
my
this,
lord.
my lord.
No single tractor was allowed and we did not bring any tractors inside.
I will mark this important the video clippings, my lord.
We'll take it on Monday at 2:30.
Please.
Yes, list on Monday at 2:30.
Much pleasure.
Yes. ಎಲ್ಲಿ ಮೇಜನು ಇಲ್ಲ ಅವ್ರು ಸೀನಿಯರ್ ಕೌನ್ಸಿಲ್ ಇಲ್ಲ.
ಇಲ್ಲ ಪಾಸ್ ಅವ್ರು ಕೇಳಿದ್ರು.
ಅಲ್ಲಿ ಸಬ್ಮಿಷನ್ ಮಾಡ್ಬೇಕಾ? ಇಲ್ಲ ಮಂಡೇನೆ ಕೇಳ್ತೀನಿ.
Please.
Monday at 2:30.
Much obliged.
Sorry. Yes.
Number 60, Prashant Matpati, Viraj P. Muthod.
Lords, this I request to take connected matter, my lords, firstly, lords.
ಯಾವ್ದು connected sir?
62. Synopsis has been filed. 62.
Service matter.
61 months.
Synopsis, my lord.
Synopsis ಎಲ್ಲ ಆದ್ರಿಲ್ಲ. ಎಂಟರ್ ಮಾಡಿದ್ಯಾ?
Yes, my lord.
Monday. Monday 3rd.
Please.
3rd March.
My synopsis name, please.
List. Okay. Please file it in the list. List the matter on 3rd March. Yes.
Interim.
Shall continue. Next.
62 has this side, VS company.
Not pension benefits not released, my lord.
Hello.
She's a widow, age 77 years, my lord.
Who has to? Countess.
Yes, come.
Countess.
MB convenes.
Huh?
Number 4. I am for KPTCL. Is ESCOM issued. Number.
ಏನ್ ಮಾಡ್ಬೇಕು?
Respond number 4 months. MB convenes. Answer.
MB convenes ಬರ್ಲೇ ಇಲ್ಲ. MB convenes
The
ಇಲ್ವಾ?
first instance, Suraj Muthod was appearing.
Now, who has entered appearance?
MB Kanvi.
MB convenes. Now, R6 division. KPTCL 1.
1995 retirement, 2019 he died, your lords. Till today they could not get the family benefits. There are some department inquiries, your lords. Apart from that, if any amount is there, even for that also they have issued an endorsement. In page 86 may kindly be seen that I should execute a bond.
Pass a detailed order.
Yes, your lords.
We will direct the MD to be present. ಅವಾಗಲೇ ಆಗದೆ. Yes, sir. Who appears? Kamte avara?
Lord, I appear for KPTC.
Yes, sir. You have not settled the.
Mr. Kanvi appears for. Mr. Kanvi appears for the contesting party.
Where is MB Kanvi avara?
That order is passed.
Where? ಯಾವತ್ತು? ಯಾವತ್ತು?
13th January.
ನಮ್ಮ ಆರ್ಡರ್ ಆದ್ಮೇಲೆ.
With some deductions.
Granting family pension.
With some deductions which were pending against them. Let them.
ಎಷ್ಟು ಕೊಟ್ಟಿದ್ದೀರಾ? 6,52,000.
Yes, ma'am. 6 lakhs.
ಪಾವತಿ ಮಾಡಬೇಕಾದ ಒಟ್ಟು ಮೊತ್ತ ಬರಬೇಕಾದ ಮೊತ್ತ ಎಷ್ಟು? 16 ಲಕ್ಷ. 10 ಲಕ್ಷ ಹೆಂಗ್ ಡಿಡಕ್ಟ್ ಮಾಡಿದ್ರಿ?
ಅಲ್ಲ tabular column ಅಲ್ಲಿ mentioned, my lord. These are the deductions.
Sir, ನೋಡಿ.
Yes, sir.
Family has got 7 lakhs now.
Yes, Your Lord.
If there's anything, you
Yes, Your Lord.
let me know.
Yes, immediately they should release it, Your Lord. That's the.
Yes, my lord.
ರಿಲೀಸ್ ಆಗಿದೆ ಅಂತ
ಇನ್ನ ಇಲ್ಲ ಆಗಿಲ್ಲ ಇನ್ನು.
ಆಗಿದೆ. ಆಗಿದೆ. That is the order.
ಇಲ್ಲ ಆಗಿಲ್ಲ, only passed an order.
Learned Counsel MB Kanavi places a memo appending to it a document dated 13th January 2025, which releases the family pension to the petitioners after deducting certain amount. The amount is still with the corporation and has not reached the petitioners. Therefore, by Monday, the counsel for the fourth respondent shall see to that the amount so determined now at 6,52,559 reaches the coffers of the petitioners.
Please.
Failing which the matter would be viewed seriously. Yes, ಇದು first time seriousness ಗೆ ಇದು ಬಂತು.
Yes, otherwise they would not have released the amount.
In between councils was engaged. ಅದಕ್ಕೆ ಸ್ವಲ್ಪ there are.
ತೊಂದ್ರೆ ಇಲ್ಲ, ಯಾಕೆ ರೈಟರ್ ಆದವ್ರಿಗೆ ತೊಂದ್ರೆ ಕೊಡ್ತೀರಲ್ಲ?
Council on record was on some.
Really don't understand what satisfaction all of your government servants would get by troubling these retired people.
Please.
Huh? Yes, list on.
Lord, any short date, my lord, because appeal is also pending.
How appeal, sir?
ಇದರದಿಲ್ಲ ನಾವು
Appeal
against that.
my lord, deduction,
We have filed it, Your Lord.
that is since.
They are not at all
20 years
disposed
it
of.
is pending.
Sorry, on 3rd March ಕೊಡ್ಲಾ?
Yes, sir.
Please, on 3rd March, yes.
Number 63, Vishwanath Hegde, CV Angadi.
What Manmohan, you're again back. IOC andre will come, is it?
I am back for the other 230 matter as well.
ಇವತ್ತಾ?
198, but that's the other matter.
ಏನಾಗಲ್ಲ ಇವತ್ತು. Tax matter.
How GST matter.
No time.
But this matter, my lord, the only issue is, my lord, I have supplied, my lord, ethanol to the respondent. And my lord, they were supposed to make payments to me. They have withheld about 8 crores from me, saying that, my lord, entry tax is probably leviable, my lord, on this supply. Lord, now, my lord, they retain this money, not since several years. Now the writ petition, the CRP that is filed by them, but they have succeeded, wherein not it is held that not entry tax is not leviable. Even I had filed a writ petition where the Honorable Court has held that not entry tax is not leviable. Now, my lord, they are not refunding my money. They are saying that there's a review petition that has been filed by the revenue.
My lord's review petition has been preferred by the revenue, my lord. Not the brief facts of the case are that, my lord, the assessing authority issued a demand notice to the respondent, all the 3 respondent corporation, my lord, on the premise that ethanol attracts to be taxed under the KTEG Act. That was taken in an appeal, my lord, before the Joint Commissioner of Taxes, my lord.
What was deducted by them?
Yes, we have made
Money, my lord, which according to them was liable to be paid towards, my lord, entry tax,
No,
penalty.
the dispute is between you and the revenue.
No, my lord, dispute is between them and not the revenue.
Oh, them
And not they have succeeded. Even not, in fact, even I had not sought for.
What is Justice Hemant or order anything?
This is Hemant or order lane. I had sought for clarification whether not entry tax is leviable. They issued a clarification, that is the government issued a clarification that it is leviable. That not I had challenged, and this Honorable Court held that not it is not leviable. That is the order not in my writ petition. At page 45 it starts. The relevant portion is page 50.
we are not parties in that, my lord.
No problem.
They are not parties, no doubt about it.
Law is what is laid down. You need not.
Lord, para 9, 10 and 11, Lord.
Yes.
The court says, Lord, para 10, reading the entry indicates that denatured spirit or ethyl alcohol are 2 different products and they are not one and the same product. Hence, the clarification issued by respondent contrary to entry 86 of the first schedule of the KTEG Act. Decisions related by respondent are not taking facts of the case. Levy of tax in respect to the period 2007-08 and 0809 for the said period, that there was no notification issued under section 3(1) of the KTG Act levying entry tax on the denatured spirit. Hence, a petition not entitled.
Who preferred an appeal against this?
Lord, there is no appeal against this. Lord, the order, Lord, which Lord I am referring to, Lord, at page 52, Lord, which is filed not by the respondents themselves. Page Lord 82, Lord should get it.
What
for
was
52.
this against?
So this was against not the decision of not the department before, and which was challenged before the KAT. Where
What was that, sir?
We are not saying that not entry tax is leviable. There, my lord, this honorable court, my
So
division
the
bench of this honorable.
department holds that entry tax is
Yes,
leviable.
leviable. That, my lord, finally, my lord, the order of this honorable court in the division bench at page 62, if not, please turn to para 14. At page 62. So this is a division bench order, my lord.
So question of law is answered in favor of the revenue.
Yes, my lord.
So
No, not in favor of the, in
SSC.
favor of not the
Against
SSC.
the revenue, sorry.
That is not
So
the,
entry tax is not leviable.
not leviable. Now, my lord, I make a representation to the respondent saying that please give me back my money.
ಎಷ್ಟು ತಗೊಂಡಿದ್ದಾರೆ?
But about more than 8 odd crores, my lord. They say not only, my lord, for the assessment, they also say for penalty.
Preferred review against which order?
But SSC has, the revenue has preferred the review as against the order passed in this CRP, which my lord have just
That
seen.
division bench.
Division bench order.
What is the status of the
But
review?
there's only notice issued as not my learned friend has
Yes.
placed on record.
Not yesterday, I filed the status report as availed from the official website, my lord. That under memo I filed, my lord. Notices have been ordered, my lord. In fact,
To review.
But yes, no, they
Give
have
it
to,
subject-
well,
in case
they
you
can't
lose,
not
then
keep,
you'll have to give it back.
but there is no
But,
interim order granted in the review. Lords are aware, Lord, unless you file a appeal or review, there's no interim order, Lord, then I'm entitled for take the benefit.
but some
For
submissions.
several years, Lord, they're sitting on my money. Let them give it back with interest, Lord.
But
With interest, Lord, automatically.
Entry tax
some-
on what?
my lord, some submissions I have to make.
On, Lord, ethyl alcohol, the alcohol that is not this.
My lord, as the demand notices were issued by the assessing authority, my lord, the three respondents herein preferred appeal, and then pre-deposit has been made. My lord,
Entry tax collect ಮಾಡ್ಕೊಂಡಿದ್ದೀರಾ?
no, it's as per the,
ಮಾಡಿದ್ದೀರಾ ಇಲ್ವಾ?
no, as per tender terms and conditions, whatever the amount that was to be paid in that we.
In law, it is not leviable.
Now the position of law is clear, my lord.
As simple as that.
Then as the demand notice was issued, in order to prefer an appeal, the pre-deposit were made before the appellate authority, my lord. Then the order of it.
ಅದಕ್ಕೆಲ್ಲ ಹೋಗ್ಲೇಬೇಡಿ.
Yes, my lord.
Entry tax is not leviable.
Yes,
You have
that-
collected entry tax.
Yes, that amount is deposited before the appellate authority, my lord, while preferring the appeal. Then, and order of it, the respondent number 1, 2, 3, they preferred, my lord.
Before which authority?
Before the Joint Commissioner of Commercial Taxes, that's the first appeal, and there we lost. Thereafter, second appeal was preferred before the KAT, my lord, Karnataka Administrative Tribunal. There also we lost. Finally, we succeeded before the Honorable Division Bench at Bengaluru, my lord, against which now a review petition has been filed. So while preferring appeal in the first instance, the pre-deposit has been made, my lord, and order of withholding has been passed by the Commissioner of Commercial Taxes by virtue of the power vested in section 8A(1) of the Act, my lord. And then, my lord, it is for them to refund to us. Now they're saying that, in fact, despite, my lord, respondent number 2, my lord, succeeded before the KAT, my lord. Despite that, my lord, they have issued a endorsement saying that the amount has been withheld by the Commissioner of
Please give me a
Commercial
copy.
Taxes, and then refund cannot be made.
Same order.
No, this is different order. Here, my lord, respondent number 2 succeeded before the KAT itself, my lord. That order is in.
IOC, you have succeeded
Yes,
before the KAT.
there are several cases there are filed, my lord. In these batch matters, my lord, the order was in favor.
Manmohan?
Please, Lord, if that KAT order also, Lord, I have produced at page, Lord, 64.
Then, my lord.
There also they have succeeded.
No, this is different.
This is another batch, my lord. There where the orders.
August 23.
Lord, everywhere they have succeeded.
This is another batch, my lord, where the SSCs, my lord, they succeeded before KAT itself. Despite that, my lord, the endorsement has been given saying that there is an order of withholding as per section 8A(1). Therefore, refund cannot be made. And then section 8.
Objections ಹಾಕಿದಾರಾ ಇವರು?
I had to file, my lord. There are a lot of factual aspects. 2 weeks may kindly be granted, my lord. Since
Just on 7th March.
Not another week, since I represent all the 3 respondents, my lord, and the officers had to come from Chennai, my lord.
36 to 10 days time to file statement of objections. List the matter on 7th March.
Please.
64 urgent, 65.
Come back.
Sarvesh Narasimha, 14% base conflict.
Yeah, my lords are joined online.
Stay ಕೊಟ್ಟಿದ್ದೀನ. List in the second week of March 2025. Interim order subsisting will continue till the next date of year. Next.
66, Venkatesh Kharvi.
Thank you, madam.
I appear for this fund number 3 and 6. Sir. seek for 2 weeks time for.
My lords, my
Final statement
submission
of-
is regarding interim order. Because
they are-
my respond number 1 without the license, my lords,
Today they are.
they allowed them to make a construction. In that reason, my lords, alleged incident happened. And
Petitioners
there,
are the.
in the petitioners are young engineers, my lord, that they are drawn into the, my lord, that is flume funnel on the negligence of respond number 1. So I seek this honorable court direct the respond number 2, make an inquiry. Because after three months of the alleged incident, he has filed a complaint against the factory owners, my lords, without any license, without approval of the site plan, my lords. That is Annex A and J.
What have these people done?
No, they are the parents of the employees who have died in the incident, my lord. There is already a case pending with, under the IPC as well as under Factories Act.
Against them?
No.
Then,
Against
yes.
us.
What is your prayer here?
Yes,
My prayer
they
is
want
not to
stop the
renew the
factory.
license, my lords, cancel the license, because, my lords, my submission is,
parents of the
what
employees.
made the respond number 1 is,
Parents of the
after,
employees who
ಅಲ್ಲ,
died in the
ಆಯ್ತು,
incident.
ಇವ್ರ ಲೈಸೆನ್ಸ್ ಯಾಕೆ ಕ್ಯಾನ್ಸಲ್ ಮಾಡ್ತಾ ಇದ್ದೀರಿ?
ಅಲ್ಲ ಅವ್ರದಲ್ಲ, they are the parents of the
License
employees.
holders.
victim,
No, they are the parents of the workers who died in an incident.
Why are you before the
my question is, my lord, respond number 1 had knowledge that they had non-license.
ಈಗ ಯಾಕೆ ನೀವ್ ಯಾಕೆ ಬಂದಿದ್ದೀರಾ ಕೋರ್ಟಿಗೆ?
Now we are the injuries, my lord, we are victim, we are the, this is father, my lords, we have grievance against
You
that, my
tell me
lords,
against
on the
what?
negligence of, my lord.
Cancel the license ga.
ಹೌದು, my lord, ನಮ್ಗೆ ಅಲ್ಲ, ನಮ್ಗೆ
factory ಅಂತ.
ತೊಂದರೆ ಏನಂದ್ರೆ, my lords,
ಲೈಸೆನ್ಸ್ ಕ್ಯಾನ್ಸಲ್ ಮಾಡ್ಬೇಕು.
yes, that is because, my lord,
Sections.
till today, my lord, till today,
Interim order, you want me to stay the license, is it?
no,
The
take the
factory-
license,
the
manufacture the process of that company. That factory,
JSW manufacturing stop ಮಾಡ್ಬೇಕು.
ಹೌದು.
Public money.
My lord, my submission is kindly be noted, my lords, because only the assistant director of the factory had knowledge that the company has no license till today. Only issued, my lords, he has applied, that is Annex J, my lords.
So by interim order, I will say JSW from tomorrow will stop
Yes,
manufacturing.
that is, my lord, that is,
Correct.
because we have lost the 2 children, my lords, that is what, we have lost the 2
Criminal case
children.
register ಮಾಡಿಲ್ವಾ?
ಎರಡು ಇದೆ.
Please,
Criminal case register ಮಾಡಿಲ್ವಾ?
criminal case ಮಾಡಿದ್ದು,
Compensation
my lords,
ಹಾಕಿಲ್ವಾ?
that is criminal case, what happened? See, assistant director respond number has filed the criminal case on after 3 months. After 3 months, he had knowledge of the act, my lord.
Compensation ಕೊಟ್ಟಿಲ್ವಾ?
ಗೊತ್ತಾಗಿದೆ. ಅದನ್ನು ಅದಕ್ಕೆ that's what I want to place on that.
Place everything.
So that is not the way, my lords. I have made
What is the way?
not I seek what I seeking, make an inquiry, because he had a knowledge.
Will die- ಈಗ
And he-
criminal case
and-
register ಆಗಿದೆಯೋ ಇಲ್ವೋ?
Register ಆಗಿದೆ.
ಅವ್ರು ಇನ್ವೆಸ್ಟಿಗೇಟ್ ಮಾಡ್ತಾರೆ ಬಿಡಿ.
So, my lord, my lords, though he had a knowledge of that act, my lords, he had filed after 3 months.
ಈಗ ಇನ್ವೆಸ್ಟಿಗೇಷನ್ ನಡೀತಾ ಇದೆಯಲ್ಲ ಸರ್?
ನಡೀತಾ ಇದೆ.
Allah, investigation in criminal case,
March on
those,
that.
so far as, my lords, the factory acts filed by the national assistant director, that is
Factory act
respond number
ನಡೀತಾ
1.
ಇರ್ಲಿ. Where is the question of cancelling the license now?
There is no renewal of the license, not to renew the license, my lords. That is what. And even though, my lord, they are making a construction, it is number of people are dying, my lord, dangerous in position.
Number of people are dying.
Number in the factory, they have not reported. There is unreported, my lords.
Unreported deaths ಆ?
It's
ಹಾಗೆ
really-
ಮಾಡ್ತಾ ಇದ್ದಾರೆ.
in judgment ಹೇಳ್ದಂಗೆ
ಅಲ್ಲ, ಜಡ್ಜ್ಮೆಂಟ್ ಏನಲ್ಲ, ಈಗ ಗೊತ್ತಿಲ್ಲದೆ ನಮ್ಗೆ ಆಗಿದೆ, ನಾವು ಕಣ್ಣಿ ತಗೊಂಡ್ಬಂದು ಕೋರ್ಟಿಗೆ ಎದುರು ತಂದಿವಿ ನಾವು ವಿತೌಟ್ ಲೈಸೆನ್ಸ್. If that is not happened, my lords, they have continued to that factory without a license.
What license?
This is steel industry. This is only
What license?
ಲೈಸೆನ್ಸ್ ಅಂದ್ರೆ ಅವ್ರಿಗೆ
For what license?
factories.
ಲೈಸೆನ್ಸ್ ಫಾರ್ ಮ್ಯಾನುಫ್ಯಾಕ್ಚರಿಂಗ್ ದ ಸ್ಟೀಲ್, my lords.
ಅದೇ ಇಲ್ವಾ ಇವ್ರ ಹತ್ರ?
That is the no. They have applied for 3 months.
Prayer is to cancel
Did
the
not
license.
have license?
No, I have all the valid license, everything. I want to place it before the court.
Place everything.
ಅಲ್ಲ, I have shown that they have taken the
They
license
documented.
after the
Let them
incident of
place-
the
let
alleged.
them place everything.
Even
ಅಲ್ಲ,
I
ಅವ್ರು ತಗೊಂಡು
investment-
ನಮಗಿಲ್ಲ, ತಗೊಂಡದ್ದು ಯಾವಾಗ? 3 ತಿಂಗಳ ನಂತರ.
As on the date of the accident, there was no license?
No,
No
there
license.
were all the licenses.
If the license was not there as on the date of the accident, then you will have to face,
Please, I'll place it.
will have to face serious proceedings.
Please. I'll place it.
Without license, you are functioning
No,
on
no,
the,
no.
on the date of the incident.
No. All the licenses
so?
are in place. All the licenses are in place and all.
Learned
permissions.
Counsel Prashant Gowda
Respond 3 and
seeks
6.
2 weeks' time to place on record all the
no
licenses
license.
that were in place as on the date of the fateful incident. The learned counsel for the petitioner submits that the respondents were running the manufacturing units without license, and license is taken according to the records only after 3 months after the incident. It is therefore his submission that as on the date of the incident, there was admittedly no license. The counsel Prashant Gowda to place adequate documents to steer clear the controversy. as if there was no license and this incident has happened due to, still clear the controversy. By the next date, list the matter on
Quick, my lord, any
17th
date,
March.
Please.
Yes.
Please.
Next.
67 Gayatri SR, ST Kadakpatti.
Fifth respondent, my lord. Next week, my lord, in the taken up, my lord, statement of objection is not found, my
I'll
lord.
show
Ready, my
only
lord.
two. I'll show only two documents. Earlier also, Mulats, there was an order to not to precipitate the matter. During that period, Mulats, they have precipitated the matter and have proceeded further to complete the inquiry in the absence of departmental nominee and in the absence of the petitioner, Mulats.
This, you're working or not?
I'm not working, Mulats. She has two children.
2023, my lord, in the order, my lord.
She's a school teacher, Mulats.
My lord, more than 2 years, my lord, in the. Now he is, my lord, in the challenging, my lord. 23 order, my lord.
I'll show only two
Taken up
documents.
next week, my lord, any date, my lord, in the.
Which are those?
Mulats, Annexure P2, Mulats, at page 98. Relevant portion is at 106, Mulats.
90?
98 Mulats. Order of this honorable court. Relevant portion is at 101. Having taken note of the submissions made by the learned counsel appearing
Shall
for
not
the...
precipitate the matter against the petitioner.
Yes, Mulats. That was the order, Mulats. Next page, Mulats, 102. That is dated 11/3/2023. They have completed the inquiry, Mulats, and submitted a report on 11/3/2023. Your Lordship may peruse 105, Mulats. Para 8.
No, 1 minute. 20th February 2023 is the order.
Yes, by this honorable court.
Not to precipitate for how much time?
4 months. Till my revision petition wherein the very initiation of inquiry was called in question.
Within 4 months from today till such
Yes.
time, so and so.
Yes, Mulats.
Where is the completion of inquiry?
Inquiry is 11/3/2023.
Page?
Page 102. In the first page only,
Tell you
Mulats,
that
after
page
the
102.
index. 102.
Report of inquiry.
Yes.
Date in, madam?
11/3/2023.
Did I get that?
At 102, Mulats, page 102. In the first page.
11/3/20.
Yes, they have completed the inquiry report, Mulats.
In
the same report,
What happened after that?
After that, Mulats, they have passed a resolution and they have removed me from the work, Mulats.
While this order was passed, you were still in service?
Mulats, there was a direction to...
Sandesh or
Yes.
order ಮಾಡಿದಾಗ ಸರ್ವಿಸ್ ಅಲ್ಲಿ ಇದ್ರಾ?
ಇಂದ್ರೇಶ್ ಸಾಹೇಬ್ರದ್ದು ಮಾಡಿದಾಗ ನಾವು ಸರ್ವಿಸ್...
ಸಂದೇಶ್ ಸಾಹೇಬ್. ಸಂದೇಶ ಇಂದ್ರೇಶ್ ಅವ್ರದ್ದು.
ಇಂದ್ರೇಶ್ ಸಾಹೇಬ್ರದ್ದು.
ಯಾರ್ದು ಆರ್ಡರ್?
Justice ಇಂದ್ರೇಶ್ ಸಾಹೇಬ್ರದ್ದು ಆರ್ಡರ್.
1 minute.
Page 98.
Indresh,
Yes.
sorry. Yes.
There was a direction to me to join the service and I was working. In the revision petition, there was an interim order to reinstate.
Dispute so and so. Interim order ಏನೈತಿ ಇದರಲ್ಲಿ?
ಇದ್ರಲ್ಲ ರಿವಿಷನ್ ಪಿಟಿಷನ್ ಅಲ್ಲಿ ಇಂಟರ್ಮ್ ಆರ್ಡರ್ ಇತ್ತು, ಅದನ್ನ ಕಂಪ್ಲೈ ಮಾಡ್ಲಿಲ್ಲ ಅಂತ ರಿಟ್ ಹಾಕೊಂಡಿದ್ವಿ. ಅದನ್ನ ನಾಟ್ ಪ್ರೆಸಿಪಿಟೇಟ್ ಮಾಡಬೇಡಿ ಅಂತ ಹೇಳಿ ವರ್ಕ್ ಮಾಡಕ್ಕೆ ಹೇಳಿದ್ರು.
You had joined back service to service there?
By virtue of this order I have joined.
Where is that? Where do I get the join?
ಅವತ್ತೆ ರಿಪೋರ್ಟ್ ಮಾಡಕ್ಕೆ ಹೇಳಿದ್ರು, ರಿಪೋರ್ಟ್ ಮಾಡಿದ್ವಿ ನಾವು ಅದೇ ಆರ್ಡರ್ ಅಲ್ಲಿ. ಪೇಜ್ 101.
101.
Yes.
Permitted to approach hearing for redressal of
page 100 minutes, page 100. So and so on instructions from
will be reinstated in service tomorrow itself.
Yes, I had joined that service. They passed an order.
Removal order ಯಾವಾಗ ಆಯ್ತು?
Removal order is on 9/9/2023. That is passed after the lapse of 4 months. They concluded the inquiry wherein departmental nominee was absent, and the respondent number 4, who is BU Amulat, has also stated that the entire inquiry and the initiation is in violation of the order passed by this honorable.
Yes, sir.
This is done only to harass.
Tuesday, my lord, in the taken up, my lord, in.
No, sir.
My lord, more than 2 years, my lord, in the 2 days, my lord.
We had initiated contempt.
Only 2 days, my lord, time, my lord.
Contempt is closed, my lords, reserving the liberty to the petitioner to
detail
extend.
objection, my lord.
1 minute. You are removed now?
Yes.
My lord.
You reinstate
Detail objection, my lord.
Will you reinstate
Monday, my
her
lord, in the
now?
taken up Monday, my lord.
The petitioner.
My lord, kindly, my lord, taken up Monday, my lord. Monday is out of
take the orders of this court for a right, sir. The petitioner is before this court calling in question an order dated 9/9/2023 by which the fifth respondent removes the petitioner from service. As also dismissal of the review, the review petition.
Review petition wherein the very initiation of the disciplinary inquiry was called in question, that is also dismissed since they have removed me from service.
and the dismissal of the revision petitions, revision petition and revision petition dated 16/10/2023 in RP 35 of 2021 by the first respondent. The petitioner is a teacher working in Vidyavardhakana.
Yes, my lords.
In
Respondent number 5.
the Vinayaka Vidyavardhaka Sangha, the school run by them. The petitioner was before this court in writ petition 100613 of 2023. This court disposes the petition on, a coordinate bench of this court disposes the petition on 20th February 2023 by the following order, page 99 to 101. A direction was issued to the management that the petitioner should be reinstated the next day. It transpires the petitioner was reinstated and was working in the school as a teacher. This coordinate bench had further observed that for a period of 4 months, the respondent school or institution shall not precipitate the matter against the petitioner qua the inquiry. This order was passed on 20th February 2023. Even before the ink on the order could dry, the inquiry proceedings are concluded by the inquiry officer on 11/3/2023, and based upon the said report of the inquiry officer, the petitioner is again removed from service. This continuation of inquiry and removal, this continuation of inquiry was questioned by the petitioner in the revision petition. That also is closed on the ground that the petitioner has been removed from service. The action of the respondent institution on the face of it is contempt on the order passed by this court. This court was the coordinate bench was unequivocal that for a period of 4 months, no precipitative action shall be taken against the petitioner. There was no warrant to conclude the inquiry in a tearing hurry by submitting a report on 11/3/2023. Now that the order of removal is passed on the strength of an inquiry report, which was by itself a contempt of the order passed by this court, the petitioner is removed. In that light, this case forms an appropriate case to issue a direction by way of an interim measure to reinstate the petitioner forthwith into the services, failing which it would be putting a premium on the action of the respondent, notwithstanding it forms a contempt of the court. The reinstatement, yav martira? Monday?
Next week, my lord. First week of March, my lord.
No problem. List the matter on 7th March for further hearing.
Great. 68, Chetana S. Viraj.
Two weeks, yes. There 2 weeks ಆಗ್ಬಿಡಿ. Next.
69, Maqbool Ahmad M. Patil.
Memo ಇಲ್ಲ ಅದೇನೋ ಪೆನ್ಷನ್ ಕೊಟ್ಟಿಲ್ಲ ಅಂತ ಹೇಳಿ ಚೇತನ ಸ್ಟೆಲಿಂಗ್ ಮಾಡಿ. ರೆಸ್ಪಾಂಡೆಂಟ್ ಇಲ್ವಾ?
69 and 70, I've been instructed to file
Lords,
wakalat.
69 and 70, probation is not been cleared from 19 and 18 years.
Just today only they have given
list in the first week of
My lords, a short.
My lords,
My lords,
my lords, I appear on behalf of Sumana Naganan. The matter
Serial
has
number
been entrusted to some other advocate. Serial number 70, my lords.
ಅದೇ 69 and 70.
No problem. Yes.
my lords, what has happened here is
Registry to delete the name of BS Kamte ಇಲ್ವಾ?
Shivraj Mudhot.
KPTC.
My name will be deleted.
Registry to delete the name of Shivraj Mudhot as appearing for respondent 1 to 5 and print the name of BS Kamte.
ಅಲ್ಲ, MB
MB Kanvi, sorry. Yes. 70 ಅಲ್ಲಿ registry to delete the name of Shivraj Mudhot and Sumana Naganan as appearing for respondent 1 to 5 and print the name of MB Kanvi.
Please.
Yes.
Great for you.
Issue ಏನು?
Matter.
my lords, what has happened is my probation is not cleared on the sole reason that I have not cleared Kannada examination, my lords. But in similar set of facts, some other person, some other employees probation has been cleared, his promotion is given, increment is given, my lords. I have put forth the annexure, my lord.
Covered, sir.
I have put forth the annexure before this honorable.
ಕೊಡಿ ಕವರ್ಡ್ ಅಂದ್ರೆ ಅವರೇ ಹೇಳ್ತಾರೆ.
ಇಲ್ಲ, annexure P1 and P is there.
ನೋಡ್ಲಿ ತಾಳಿ ವಕಾಲತ್ ಹಾಕಿದ್ದಾರೆ ನಿನ್ನೆ.
Please.
List the matter on 27th.
Yes, ma'am.
Please, my lord.
Counsel learned counsel for the petitioner submits that the issue in the list stands covered by several orders passed by the coordinate benches of this court. Learned counsel MB
Not coordinate bench.
several orders passed by the corporation granting the benefit that is now denied to the petitioners.
Please.
Learned counsel MB Kanvi seeks a week's time to go through the papers and make his submissions. List the matter on 27th.
In fresh matters, my lord.
Only fresh.
Please.
71 Girish V. Bhatt.
Please, my lord. Petitioner is before this honorable court seeking a mandamus to direct the matter to be enquired by the CBI. And the synopsis of the event.
CBI.
4 days time, lords.
Death of
Objections
the
are ready.
petitioner
We will
husband.
place it. Already charge sheet is filed. They want to, my lords, they make allegation against the inquiry officers.
Even after filing of the charge sheet also, my lord, this honorable court have the power to refer the matter for investigation. CBI.
Power is unlimited, sir.
My lord, I will. So, my lord, on 13/9/2023, the husband of the petitioner, my lord, got a call and he went out of the house. And on 14/9/2023,
ಈಗೇನ್ ಬಿ ರಿಪೋರ್ಟ್ ಹಾಕಿದಾರೆ ಅವರು ಚಾರ್ಜ್ ಶೀಟ್
ಇಲ್ಲ
ಹಾಕಿದ್ದಾರೆ
ಚಾರ್ಜ್ ಶೀಟ್ ಹಾಕಿದ್ರೆ 306 ಮಾಡಿದ್ದಾರೆ. ದಿ ಕಂಪ್ಲೇಂಟ್ ಫೈಲ್ ಬೈ ದಿ petitioner
ಮಾಡಬೇಕಾಗಿತ್ತು ಅಂತ.
Complaint filed by the petitioner was taken as UDR. They didn't register the FIR, my lords. After I repeatedly approaching the police officers to protect the interest of the real culprits, the respondent number 8, the investigating officer back then, he registered the case by taking a complaint against whom I made the allegations earlier. Our wife in the she takes a complaint and register a complaint as 6 persons for 306.
Yes, comment.
Objections are ready, my lords. I will place.
ಹಾಕಿ. Objections ಹಾಕಲಿ ಬೇಡವಾ?
Before my lordships, if it was disposed of, because my lords, it was a hanging
First week.
Please.
Yes. On 20.
Objections if any by then.
28th, 27th, my lords.
ತೀರ್ಮಾನ ಮಾಡಕ್ಕಾಗುತ್ತೆ.
Allah, it's a partial hanging. Knees were touching the floor. That is what in the inquest, my lords.
Yes. List on 3rd March. Yes.
72 Umesh Sarma.
ಯಾರು ತಗೊಂತಾರೆ 3rd March ಅವ್ರ ಗತಿ.
Your lordship. Your lordship, there is a parole. 302, your lordship.
Yes, comment.
Annexure A, page 13 is the police report, your
Wait,
lordship.
madam. Wait.
Yesterday it was listed.
ನೀವು ಸುಮ್ಮನೆ ಇದ್ಬಿಡಿ, ನಾನು ಆರ್ಡರ್ ಮಾಡ್ತೀನಿ. Yes.
All the matters, my lords. ಕೆಲವೊಂದರಲ್ಲಿ ಇದ್ದಿದ್ದನ್ನು ಹೇಳ್ತೀನಿ. Files are misplaced. Yesterday ಅದು due to my lords function we cannot trace out the files also.
ಮಂಡೇ ತಗೊಳ್ಳ?
Monday ತಗೋ. Monday.
ಇಲ್ಲ ಟ್ಯೂಸ್ಡೇ ತಗೊಂತೆ. ಟ್ಯೂಸ್ಡೇ ಫ್ರೆಶ್ ಮ್ಯಾಟರ್ಸ್.
Please.
God bless you.
23 KH Bagi.
Lords, Sahadra Cooperative Society, my lords. That election has been done, my lords, and I seeking, my lords, the
ಟ್ಯೂಸ್ಡೇ ಬರಲಿ. Yes.
the
List on Tuesday. Yes.
lords, because
Agency, the lordship on 27th is the period is end lordship. Otherwise, it's not disposal.
Tuesday 25th, sir. Yes.
Monday, my lords, Monday.
Tuesday. Yes.
Lords, meanwhile, I file my lord amendment petition. my lord.
File ಮಾಡಿ. Yes.
Please.
Next. list ಎಷ್ಟೊಂದಿದೆ? 25. ಕರೆದು ಬಿಡಿ. 230 more matters.
230 more list. Till number 1, Shuraj is Baloli.
Yes, so premature transfer, my lords. Petitioner, senior health inspector, my lords, appointed with my lords, third respondent, municipal council.
ಎರಡೇ ಡೇಟ್ ಹೇಳಿ. Earlier transfer ಯಾವತ್ತಾಯ್ತು?
28/6/2023.
28/6/2023.
Minimum 4 years, my lords. She's been now transferred.
ಡೇಟ್ ಕೇಳಿ, ಎಲ್ಲಿಂದ ಎಲ್ಲಿಗೆ?
ಹಗರಿಬೊಮ್ಮನಹಳ್ಳಿಯಿಂದ ಮುಗಳಕೋಡಕ್ಕೆ ಟ್ರಾನ್ಸ್ಫರ್ ಮಾಡಿದ್ದಾರೆ ಈಗ 18/2/2024.
ಹಳ್ಳಿಯಿಂದ
ಮುಗಳಕೋಡ್.
ಮುಗಲ್ಕೋಡ್.
ಪ್ಲೀಸ್.
ಆಲ್ ರೈಟ್. ಈಗ ಮುಗಲ್ಕೋಡಿಂದ
ಅಲ್ಲ, ಈಗ earlier from Hospet to Hagribomanhalli. Please, ma'am. 28/6/23.
28 Hospet to Hagribomanhalli.
Please, ma'am.
As what?
A senior health inspector.
Senior health inspector.
A senior health officer.
Is not group C. It is group B. Senior health
Senior
officer is not. What's your pay scale?
Pay scale, my lords. 18,000, my lords.
No.
30,352.
If it's 45,000, 67,000, it is group B. ಎಷ್ಟಿದೆ?
30,350 and 250,250. 58,250.
Anyway, 2 years ಅಂತೂ ಆಗಿಲ್ಲ.
ಆಗಿಲ್ಲ.
We will not refer to that. Any clarifications? Yes, produce the pay scale. ಈಗ ಎಲ್ಲಿಗೆ ಹಾಕಿದ್ದಾರೆ?
ಈಗ ಮುಗಳಖೋಡ್ my lords, Belgaum district.
From Agribamnal.
From Agribam.
The petitioner is before this court calling in question an official memorandum transferring the petitioner from so and so to
Mugalkhod, Belgaum district.
Names I can't.
Please, from third respondent to fourth respondent.
From third respondent to fourth respondent. Who has been posted?
No one is posted, my lords.
And without posting anybody to the place of the petitioner. The petitioner was posted to Agribamnalli from Hospet on 28/6/2023. And in terms of the operative guidelines dated 7th, with the respondent, KSRTC na?
Illa, my lords, municipal administration.
In terms of the guidelines dated 7/6/2013, as modified by 25/6/2024, the minimum tenure of the petitioner, if it is group B, is 2 years. If it is group C, it is 4 years. Nonetheless, the petitioner has not completed the tenure either in group B or group C. Therefore, it undoubtedly becomes a transfer contrary to the guidelines and it is premature. The order of transfer does not indicate following of the conditions stipulated in clause 9 of the said guidelines. Therefore, there shall be an interim order of stay as prayed for till the next date of hearing. 1 AGA,
1 and 2 AGA, my lords.
AGA, emergent notice to remaining response.
Please, my lords, highly obliged.
Number 2, Sabil Ahmed.
Election matter, your lordship seeking
Voting
right
rights.
to serial number 2 and 7 to 16.
Ella.
And serial number 196 in regular list, your lordship.
1 ನಿಮಿಷ,
Sorry.
Serial number 2, 17 to
7 to 16.
7 to 16. ಎಲ್ಲ voting.
Well, serial
Regular
number
list ಅಲ್ಲಿ
196. I say
same voting rights.
hand delivery.
Hand delivery. Good.
Please. Grateful.
Next.
Serial number 3, Saurabh Hegde.
Lord, the petitioner is one who was serving as a director of a cooperative society. My lord, they tendered his resignation in the month of September. And then in terms of section 29B, my lord, if the resignation is not withdrawn within 15 days from the date of tendering, then the same becomes final. And yet the society pursues an action before the deputy registrar for disqualification, my lord, for some intended action. The deputy registrar is having no jurisdiction.
Tendered resignation for what? What post?
As a director from the board. Yes.
Disqualification proceedings after resignation.
Yes.
Yes. Lament. Which is 15 days alone.
29B, my lord, of cooperative society.
And now 29C is initiated against you?
29C is initiated subsequently.
Yes, Government. The petitioner heard the learned counsel Srivat Segde appearing for the petitioner. The petitioner as director of what is that? Totagars Cooperative Sales Society submits his resignation on
24/9/24.
On 24/9/2024 and by operation of law, i.e. 29B of the Cooperative Societies Act, the learned counsel submits that the resignation comes into effect the moment 15 days would expire. Long after the expiry of the said period and after the coming into force of the order of resignation, proceedings under section 29C are instituted by the second respondent seeking disqualification of the petitioner. In the light of the aforesaid submission, there shall be an interim order of stay as prayed for till the next date of hearing. 1 AGA, 2 emergent notice.
Number 4, Sunil Kale.
Petitioner, my lord, is the executive officer, my lord, appointed in 2003 in, my lord, 7th Respondent Society. My lord, Annexure B, the new command committee was formed. My lord, they have not permitted the petitioner to work and asked the petitioner to resign. And he was manhandled. My lord, Annexure C, my lord, page 25. He filed a complaint and FIR is registered, my lord, on 11/11.
Now what happens?
after my lord registration of a FIR, my lord annoyed by this, now my lord annexure G, petitioner has been my lord suspended.
ಬರೀ ಸಸ್ಪೆನ್ಷನ್
Suspension ಮಾಡಿದ್ರು.
ಅದನ್ನ ರೀಇನ್ಸ್ಟೇಟ್ಮೆಂಟ್ ಕೇಳಿದಿರಾ ಈಗ?
Yes. Now, my lord, this suspension order, my lord, I have challenged before the my lord deputy registrar. My lord, he has rejected, there is no provision under the act anta.
The petitioner is before this court calling in question an order dated 2011-2024 by which the petitioner is placed under suspension. This is challenged before the district registrar, who has declined to entertain the petition on the score that he has no jurisdiction. Therefore, the petitioner is before this court. The learned counsel Anil Kale, representing the petitioner, submits that the petitioner set the criminal law into motion against the office bearers, i.e. directors and members of the 7th respondent bank, which in crime number,
73 of my lord, page
crime
C.
numbers, crime number,
My lord, 73 of 24.
Crime number 73 of 2024 for several offences, including the one of assault. Therefore, one of assault. As a counter blast or to wreak vengeance against the petitioner setting the criminal law into motion, is now placed under suspension. If what is narrated is correct, it would amount to placing an employee under suspension with intentions which are on the face of it mala fide, which would become the ground for entertainment of the petition. Therefore, there shall be an interim order of stay as prayed for till the next date of hearing. Yes, next.
Bill number 6, Vinay Kojalgi.
Petitioner is seeking direction, my lords. She is working as accountant in TMC at Badami, and
Sorry, serial number 5.
ಏನಿದು?
5, Prashant Matpati.
605.
ಪ್ರಶಾಂತ್ ಮಠಪತಿಯಲ್ಲಿ
ಮಠಪತಿ.
ಕೊಡಿ.
5. ಅವೆಲ್ಲ ಮುಗಿದೋಗ.
Nomination.
Yes, Lord. Lord, the election proceedings have been stopped, my lord.
Stopped? Who has
Yes,
stopped?
Lord. Annexure G, my lord. The impugned endorsement issued by the registrar.
Government let the copy ಕೊಟ್ಟಿಲ್ವಾ ಇಲ್ಲಿ?
Yes, my lord.
ಇಲ್ಲಿ ಯಾರು ಕೊಟ್ಟಿಲ್ಲ.
ಅಲ್ಲ, ಇಲ್ಲಿ ಕೈ ಕೊಡ್ಬೇಕು 230 ಆದ್ರೆ, ಈಗಲ್ಲ. ಮಂಡೆ.
Copies, my lord.
ಈಗ ಕೊಟ್ಟಿದ್ದೀರಾ ಮಂಡೆ.
My lord, the nomination proceedings have been stopped.
ಕೊಟ್ಟಿಲ್ಲ, ಕೊಟ್ಬಿಡಿ, ಇಲ್ದಾರೆ ಎಂಟ್ರಿ ಮಾಡಿ ಕೊಡಲ್ಲ. Yes.
Bill number 6, Vinay Kojalgi.
this petitioner was appointed as accountant in TMC Badami, my lords.
ಅದ್ ನೋಡಿ ಪ್ರಶಾಂತ್ ಮಠಪತಿ. I'll pass it over. ಕಾಪಿ ಕೊಡ್ಬೇಕು.
ಕೊಟ್ಟಿದ್ದೀನಿ, my lords.
Not in the AG's office. 230 ಮೂವ್ ಮಾಡಿದ್ರೆ ಇಲ್ಲಿ ಕೊಡ್ಬೇಕು.
Please.
ಒಂದು ಎಕ್ಸ್ಟ್ರಾ ಕಾಪಿ ಕೊಟ್ರೆ ಏನು ಪ್ರಾಬ್ಲಮ್?
Pass over. Lord, already a writ petition is filed.
Pass over, let him see.
He was appointed as accountant in the year 2008, my lords. Then respondent 1 called for, issued a notification dated 14/11/2024 for appointing the accountants.
You are working even today?
Please, my lords.
1 AGA, 2 to 4. KPSC garu?
KPSC, KL.
Direct recruitment.
KL.
ಈಗ they are initiating process for direct recruitment?
For direct recruitment.
ಶಿವರಾಜ್ ಮುದೋಯ್ KPSC.
How can we stall direct recruitment? Which post is this?
Accountant, my lords. A similarly placed person had filed writ petition. It is at page number 75.
2008 ಇಂದ ಕೆಲಸ ಮಾಡ್ತಾ ಇದ್ದೀರಾ?
ಹೌದು, 2008 ಇಂದ ಕೆಲಸ. Annexure G, my lords, page number 75.
ಯಾವುದು? My order is here.
Tamda. ಅದು without holding enquiry, her services were terminated. That was challenged before my lords, and they were directed to reinstate.
Correct. ಏನ್
Had
ಮಾಡಿದ್ರು
been
ಆಮೇಲೆ?
reinstate.
Reinstate ಆಗಿದೆ.
Reinstate ಆಗಿದೆ.
Look into it. So and so, 1 AGA, 1, 2 AGA, 3 and Deputy Commissioner also. Deputy Commissioner ನೀವೇ ಅಲ್ವಾ?
Deputy Commissioner.
Yes. Deputy Commissioner Town Municipal Council. ಇದು ಯಾವ post?
District town, it is a branch in.
ಅದಕ್ಕೊಂದು Deputy Commissioner ಇದಾರಾ?
ಇಲ್ಲ, ಅದು Deputy Commissioner and Deputy Commissioner only, but ಅದೊಂದು section, it is a section.
1, 2 and 5 AGA, 3 Shivraj Mudol.
Mudo.
APSC.
Please.
Shivraj Mudol. Town Municipal Council Badami.
Prakash Hasmani.
Prakash Council. 4 Prakash Hasmani. List the matter on 4th March. There shall be an interim order of stay spread for till the next date of hearing. Next.
7 to 16 are done. 17 to 3 case.
Is 25 regarding guest lecturers, my lords. I have next my lordship order on.
Order. Guest lecturer. Vishal.
Please.
18 PV Gunjan.
University alla tane. Prithvi. Government.
No, the appointment of respondent number 3 as a registrar of the university has been.
How did these additional documents come now?
In fact, I sought them, my lord. The other day it was in a hurry. I had filed it.
Urgency ಏನ್ ಬೇಕಾದ್ರೆ ಮಾಡ್ಬಿಡ್ಬೋದು.
That day, I mean, very sorry. I mean, I had to file and now I've got the documents and I've filed and then moved the matter, my lord, after filing them. My lord, it can be seen that only an officer above the rank of the deputy secretary can be appointed as a registrar, my lord. Now, respondent number 3, as can be seen from Annexure A.
Who is the respondent number 3? Use the mic.
Respondent number 3 is the person who's been appointed now, my lord, by virtue of the order.
Who is he or she? What cadre?
He is a junior scale KAS officer, my lord. It can be seen from Annexure A.
Which are the rules, sir?
My lord,
Appointment of registrar ಯಾವ್ದ್ರಲ್ಲಿದೆ?
Annexure A, my lord, along with the main petition. At page 6, my lord, in serial number 10.
Which rules? Section rules.
Section is 31(7).
Where do I get that?
I said that in my synopsis. I reproduce the.
Where is the rules ilva?
But I have reproduced for easy reference. I have
Easy reference.
I have reproduced it at the.
I want the rules. Don't file haphazard petitions.
Not haphazard.
Rule idre rule ಕೈಯಲ್ಲಿ ಇಟ್ಕೊಂಡ್ ಬರಬೇಕು.
No.
What is this?
Lord, a registrar shall be an academician in the field of
Agriculture Universities Act alva?
Yes, my lord.
ಇಲ್ಲ ಇದೆಯಲ್ಲ Annexure D ಅಲ್ಲಿ. Dean Registrar 31(7). ಎಲ್ಲಿದೆ Act ಅಲ್ಲಿ?
My lord,
you have extracted the act?
Yes, my lord. I have extracted it in the synopsis.
Oh, but act is not there.
I'm not at the moment.
Why you have not produced?
I have produced the Universities Act.
ಇಲ್ಲ ಇದೆಯಲ್ಲ ಸರ್. ನೀವೇ annexure ಮಾಡಿದ್ದೀರಾ. Yes. The petitioner is before this court calling in question the appointment of the third respondent as registrar evaluation. Registrar of the University of Agricultural Sciences. It is the submission of the learned counsel that the appointment of the registrar is contrary to subsection 7 of section 31 of the Karnataka of the University Agricultural Sciences Act. Section 31(7) reads as follows. Section 31(7) mandates that a registrar should be an academician in the field of agricultural sciences, not lower than the rank of a professor, or an officer of the state government, not below the rank of a deputy secretary to government. Now, who is the third respondent?
He is a junior cadre officer of the case.
Where do I get that?
My lord, letter of appointment, my lord, at annexure,
Which?
annexure 6, annexure A, page 6, my lord. At serial number 10.
Must be rank of deputy. Last time I told you, he must be in the rank of deputy secretary.
Yes, my lord, but he is not so, because he is a junior scale officer, as seen in the.
Allah, junior IK Shreni andrunu, it is.
Yes, that's why I produced additional documents to show that a deputy secretary shall be an officer of the senior scale.
Where is that?
I have produced at annexure, annexure D, page, sorry, annexure C, my lord, at page 10 of the additional documents which I have produced today, my lord. Serial number 17. Page 16, serial number 17, my lord. Deputy Secretary to the Government of Karnataka. Here it says that, and that annexure B, my lord. Then, if your lordship come
by promotion from the cadre of secretary,
no, if your lordship come to annexure B at page 5, at page 5, my lord.
So leave it. Ayanalde Aisha. Register should be 31(7) mandates that the registrar, the appointee should be in the either a professor or a deputy rank, or in the rank of a deputy secretary in the government. The petitioner, now the appointee is a junior scale KS officer. A deputy secretary in the government is always a senior scale officer, senior scale KS officer or an IAS officer. Therefore, the petitioner, the appointee does not fit in to the qualification necessary for the post of appointment of registrar. In that light, there shall be an interim order of stay as prayed for 1 AGA, 2 emergent, 2 and 3 emergent notice.
Mr. Mali, Mr. Ramchandra Mali.
2 Ramchandra Mali, 3 emergent notice. Yes. Ashte documents ಬೇರೆ ಏನಿಲ್ಲ. ಇದು ಹಾಕಿದ್ರೆ ಅವತ್ತೇ ಕೊಡ್ತಾ ಇದ್ದೆ.
Yes, my lord.
ಇದೆಲ್ಲ ಇದ್ದಿದ್ರೆ ಅವತ್ತೇ ಕೊಡ್ತಾ ಇದ್ದೆ.
ಇಲ್ಲ, I mean, I did not have sought them now.
19, Vijay K. Nayak.
Private land is declared as far as matter is covered by the judgment of your lordship. Let the sale deed took place on 9/12/2000.
Mere declaration and judgment ಇದೆಯಲ್ಲ. Forest.
Yes, but in the first matter, it's a sale deed in my favor in 1949. In the second matter, we are in the unauthorized occupation of the land, and an application is filed in 1990.
The learned senior counsel as Basavaraj appearing for the petitioner. The learned, ಇಷ್ಟೊಂದು parties ಮಾಡಿದ, all of you, learned AGA 1, 2, 3, 4, 5, emergent notice to 6 and 7. There shall be an interim order of stay as prayed for till the next date of hearing. Yes.
20.
20 also.
Same order. Yes, Basavaraj senior counsel.
21, HM Dharwad, Anand Arpalli.
B group move ಮಾಡಿದಾರಾ? Why?
B group.
Why madam? B group export. List in the first week of March. Next.
22, Manjunath Gowda.
My lords, under the SURFACE Act, auction was issued, my lords.
ಎಷ್ಟಿದೆ sir?
10,33,000 rupees. Subject to part payment of the amount, my lord.
ಎಷ್ಟು ಕೊಡ್ತೀರಾ?
2 lakh rupees maybe.
2 lakhs. Okay. 2 lakhs, 3 weeks, 3 weeks. 1 lakh, 1 lakh each.
Yes. May kindly be stayed, my lords.
Total 2 lakhs. So 3 weeks, 1 lakh.
Auction
3
note.
weeks, another 1 lakh. Stayed. Hotala.
Annexure D, my lords. Auction notice.
Yes,
Yes. Please, my lords.
Number 23, Sridhar Prabhu.
Hand delivery, ನಿಮ್ಮ ಮೆಮೊ ಎಲ್ಲ ಕೊಟ್ಬಿಡಿ ಮೇಡಮ್.
Milord,
ಸ್ಟೇ ಬೇಡವಾ?
ಬೇಕು ಸರ್.
ಕೊಡಿ ಮತ್ತೆ ಹ್ಯಾಂಡ್ ಡೆಲಿವರಿ ಕೊಡಿ.
Identical orders are at page 5
ಏನು
and
ಹೇಳ್ಬೇಕಾಗಿಲ್ಲ, ಕೊಡಿ.
Milord, BN Prakash sir.
2:30 ಒಂದು ಮೂವ್ ಮಾಡ್ತಿರಲ್ಲ, ಏನಿಂದ? Yes.
Milord, BN Prakash sir handles matters only in Bangalore, so Kamte sir might be.
ಈಗ ಅದನ್ನು ಬಾಗೋಗಿದೆ, ಈಗ ಫಾರ್ಮ್ಯಾಟ್ ಮಾಡಿ ಇಟ್ಬಿಟ್ಟಿದ್ದೀವಿ.
Please, Milord.
ಸೇಮ್ ಆರ್ಡರ್. ಎಲ್ಲಿ ಹ್ಯಾಂಡ್ ಡೆಲಿವರಿ ಕೊಟ್ರ? ಸರಿ ಆಯ್ತು. ನಿಮ್ದು ಇನ್ನು ಯಾವ್ದಾರು ಇದ್ರೆ ಒಂದೇ ದಿನ ಹಾಕೊಂಡ್ಬೇಡ ಕೊಡಿ ಎಲ್ಲ. ಇದೆಯಾ ಇನ್ನು? ಎಲ್ಲಿ ಇವರು ಶ್ರೀಧರ್ ಪ್ರಭು ಅವರು? ನೆಕ್ಸ್ಟ್ ಇನ್ನು ಅದನ್ನು ಇನ್ಮೇಲೆ ನೀವೇ ಮಾಡ್ಬಿಡಿ. ಎಸ್ ನೆಕ್ಸ್ಟ್ 24.
Number 24, BC Gnanaya Swami.
My Lord, Honor, appearing for the petition, my Lord. Challenge the annexure E, appointment of library supervisor, my Lord.
You are claiming or challenging?
Challenging, my Lord, because my selection was withheld, my Lord, on the ground that I have not produced I have produced the caste certificate which was expired, my Lord. On that ground, subsequently I produced, my Lord.
All right. ಅದೊಂದೇನಾ? ನೀವು ಯಾರಿಗೆ?
I am for the respondent 2 and 4, Lordship. Standing counsel.
Standing counsel.
Please, Lordship.
No problem. ಕೊಡಿ.
My Lord,
ಏನದು?
in similar matter, my Lord.
Hey, it's a curable defect, sir. Don't worry.
Lordship.
The
Date of events kindly see, Lordship. Date of events, Lordship. Date of notification issued on 3/4/2023, Lordship. ಆಮೇಲೆ 31/10 ಗೆ ಇವರು ಅಪ್ಲೈ ಮಾಡ್ತಾರೆ ಸ್ವಾಮಿ. After lapse of 6 months, Lordship.
ಆಯ್ತು. That doesn't take away the caste status, sir. Certificate expiry ಆದ ತಕ್ಷಣ caste expiry ಆಗಲ್ಲ.
ಅಲ್ಲ ಇನ್ಕಮ್ ಸರ್ಟಿಫಿಕೇಟ್.
Only
ಇನ್ಕಮ್ ಸರ್ಟಿಫಿಕೇಟ್.
So what? Income and caste and income certificate.
Income and caste certificate put together.
Income certificate. ಈಗ ಆಯ್ತು ಕೊಡ್ಲಿಲ್ಲ. ಎಕ್ಸ್ಪೈರ್ ಆಗೋಗಿತ್ತು. ಈಗ ರಿನ್ಯೂ ಮಾಡಕ್ ಮುಂಚೆ ಅದು ಇದು caste vanishes ಇದೆ.
ಇಲ್ಲ ಸ್ವಾಮಿ.
ಅಲ್ಲ ಸ್ಮಾಲ್ ಥಿಂಗ್ಸ್.
ಪ್ಲೀಸ್.
ಕೆಲವು ಕಡೆ ಅಪ್ಲಿಕೇಶನ್ ಹಾಕಿಲ್ಲ, caste certificate ಕೊಟ್ಟಿಲ್ಲ. ಫ್ರಾಡ್ ಆಗಿದ್ರೆ ಹೇಳಿ.
Please.
The petitioner is before this court calling in question the rejection of her claim for the post of library supervisor on the score that the caste and income certificate produced by her had expired as on the date of the submission of the application. The learned counsel for the petitioner submits that the application, caste and income certificate is later validated and submitted to the respondent. Even then, her appointment is not,
and finally,
even then her name is not found in the select list. In that light, there shall be full select list stay ಮಾಡಲ್ಲ ಅಥವಾ ಕೊಡ್ತೀರಾ ಇವ್ರಿಗೆ? In that light, there shall be an entry. ಇಲ್ಲ ಅವ್ರನ್ನ ಕೇಳಬೇಕಲ್ಲ. In that light, there shall be an interim order of stay as prayed for till the next date of hearing.
Respect of petitioner concern only, Lordship.
Insofar it concerns the post of library supervisor.
Please, Lordship. ಅಲ್ಲ ನೋಟಿಸ್ ಮಾಡಬೇಕು ಗವರ್ನಮೆಂಟ್ ದವರಿಗೆ ನೋಟಿಸ್.
1 to 4 ಅಲ್ಲ 1 and 2 AGA.
2 and 4 ನನಗೆ
ಅಲ್ಲ 1 and 3 AGA.
Please, Lordship.
2 and 4
ವಿಜಯ್ ಕುಮಾರ್ ಬೆಳಗೇರಿ ಮಠ.
ವಿಜಯ್ ಕುಮಾರ್
ಬೆಳಗೇರಿ ಮಠ.
ಬೆಳಗೇರಿ ಮಠ. 5 emergent notice.
Please, Lordship. Please.
25, Vidya Shankar Ji Dharwad.
Please, ಯಾಕಿಲ್ಲ ಮೇಡಮ್.
Lordship.
ಏನು ಹಾಕಿ ಟೆಂಪರೇಚರ್ ಕಮ್ಮಿ ಮಾಡಿ ಎಷ್ಟು ಇಟ್ಟಿದ್ದೀರಾ? ಆದ್ರೂ ಗೊತ್ತಲ್ಲ.
In 2010, my lords, I was appointed as a record keeper, my lords. Thereafter, my lords, in 2017, my lords, I was changed into, there is a resolution that I will be a bill collector or the.
ಏನು ಮಾಡಿದ್ದಾರೆ?
My lords, now in 2021, my lords, I was regularized, my lords. After that, my lords, in 2023, there was a complaint from the bill collectors association that I have not furnished proper document and my nature of work is not mentioned. So my regularization has to be withdrawn. Based on that, my lords, 21/12/24, my lords, at annexure A, they have withdrawn the regularization, my lords. But I am working there from
AGA 2, 3, 4 emergent notice. The learned counsel taking this court through the documents appended to the petition submits that the petitioner, after working for about 14 years, was regularized into services. The regularization was questioned by the association and a bill collectors association by submission of a representation. The representation has led to withdrawal of the regularization of the petitioner. In contrary to law is the submission of the counsel for the petitioner. Therefore, there shall be an interim order of stay as prayed for till the next date of hearing.
Please.
Last or serial number 5, Prashant Matpati.
But this is the matter where, my lord.
There is a mistake, it seems, Annexure G. The
After
election
calendar of
proceedings
events, my lord, the deputy registrar has told the, my lord, the election.
of the
proceedings.
elections.
How can you do it, sir?
Cannot.
ನಾವೇ ಇಲ್ಲಿ ಕೊಡಬಾರ್ದು ನೀವೇ ಮಾಡ್ತೀರಾ ಇಲ್ಲ?
ಇಲ್ಲ. Election process start ಆದ್ಮೇಲೆ on the basis of application give away the members, my lord, say as
1 AGA 1 2 4 5 4 AGA 3 and 5 3 ಅಯ್ಯೋ ಯಾಕೆ ಇಷ್ಟೊಂದು ಪಾರ್ಟಿಗಳು ಮಾಡ್ತೀರಾ? 1 2 4
1 to 4, my lord, state.
1 to 4 and 8 AGA remaining respondents emergent notice returnable by 10th March. There shall be an interim order of stay as paid.
Hand delivery, my lord.
Yes, sir.
Please, my lord. Much obliged.
I'll ಬರ್ಕೊಡಿ ಮೇಡಮ್. The learned counsel for the petitioner submits that which respondent?
Second respondent.
Second respondent stalled the process of election after the issuance of the calendar of events, which power he ostensibly does not have. Therefore, there shall be an interim order of stay as prayed for.
Please, my lord.
No list idea? Go back to the list.
Number 74. Vitalis Teli.
24, my lord.
Char Deshpande.
I'm seeking a police protection.
I'm proposed to respondent number 7, my lordship. I have filed the objection, my lordship. Kindly be next week Monday, my lord.
Lords, may I request for a moment, my lords?
Senior is out of station, my lord.
Lords, I filed a suit for partition. Decreed. Final decree came to be allowed. Against that, RSC was filed. RSC came to be brought. Even thereafter, my lords, remand order after remand, appeal filed by them came to be dismissed. Final decree, my lords, came to be concluded. Based upon that mutation entry, I am in the possession. Now, my lords, they are not allowing to me harvest the sugarcane which has been grown.
I am not. They are not. They are disturbed.
We are not allowing a police protection.
ಅಲ್ಲ ಈಗ ಕೇಳ್ತಾ ಇದ್ದಾರೆ ಕೊಡ್ತೀವಿ.
The learned counsel for the petitioner submits that the petitioner is in possession of the property and all proceedings against the private respondent have ended against him and in favor of the petitioner. The allegation is that the petitioner is not permitted to harvest the sugarcane that he has grown despite the orders passed by the concerned courts in his favor. Therefore, the state shall consider grant of police protection if need arises, and the dispute between the two would turn violent in real time. Yes. Next.
75. Saurabh Hegde. Mbikandi.
Access recovery, my lord. 15 lakhs order recovery. Penalty order was only for 9,76,000.
That's what. Then ವಾಪಸ್ ಕೊಡ್ತೀವಿ ಅಂತ account.
The last 2 times, my lord had directed them to bring the records.
Password. ನೋಡೋಣ ಇದ್ರೆ ಕರೆಸಿ.
Great.
5 o'clock ಇದೆ. Password ನೋಡೋಣ ಯಾವಾಗ.
76 urgent. 77 Manjunath Tarwad.
My lords, I am for the petitioner, my lords. Next. My lords, I am for the petitioner, my lords.
Yes, sir.
I am for the petitioner, my lords.
ಆಮೇಲೆ
My lords, this is regarding appointment of the librarian, my lords.
ಸ್ಟೇ ಇದೆಯಾ?
Stay, my lords. This is a simple issue, my lords. One, if
Simple issue.
your lordship permits, I will
List in
within
the
2 minutes, I will.
List in the first week of March. Yes, next.
78.
My lords, kindly date may be given.
First week of March, sir. Yes.
78.
My lords, I appear for petitioner, my lords. Challenge to the order passed under section 74(9) of the GST Act, even though there is no material made out for fraud, misrepresentation, or anything, my lords. Just to avoid the limitation under section 73, the respondents herein have issued the notice under section 74.
Wait, sir. Identical matters have stayed.
ಇದರಲ್ಲಿ my lords, may I make
Kindly,
mention? In this case, my lords, 4 to 5 years he has not paid the tax.
I want to list on 25th.
Please.
In the fresh matters list. Next.
my lords, interim order may be granted.
That day.
My lords,
Yes.
my lords, first week of March, because amnesty scheme is expiring on 31/3, my lords.
Sir, I am
First week
said
of March, my lords.
25th February, sir. Tuesday.
Grateful, my lords, grateful.
79 urgent. 80. Saurabh Hegde.
List in the second week of March, interim order subsisting will continue to the next date. Next.
81, Mohammed Sultan.
My lord, in this case, my lord, interim order has been granted and PF has been paid for to serve the notice for respondent, my lord.
Counsel for the petitioner submits needful has been done. List in the second week of March. Interim order subsisting will continue till the next date of hearing.
82 ಪ್ರತಿ ಕೇಸ್.
One submission.
Interim order ಇದೆ continue ಮಾಡಿ.
ಅಲ್ಲ interim ಇಲ್ಲ, interim order ಇಲ್ಲ.
ಇದೆ ಸರ್.
ಇಲ್ಲ, this is.
ಸೌರಭ್ ಹೆಗ್ಡೆ ಕೊಡಿ ಮೇಡಮ್. ಇಲ್ವಾ?
Yes.
ನೀವು ಕೋರ್ಟ್.
Yes, there was an interim order. Yes, madam. Yes, I'm sorry.
Interim order stands vacated.
ಏನು ಇಲ್ಲ.
Yes.
82 ಪ್ರತಿ ಕೇಸ್.
Direction, my lords, to consider the approval of my lord's appointment to the post of science assistant teacher, my lords. Representation submitted before respond number 1. Pursuant to recommendation, my lords.
Yes, government. Instructions.
Please.
ಇಲ್ವಾ?
ಅಲ್ಲ. First time ಬರ್ತಾ ಇದೆ.
First time.
Second time.
ಮೊನ್ನೆ ಬಂದಿದೆ.
And similar circumstance, this honorable.
17th.
List the matter on 7th March. Yes, next.
83, MR Hirematha.
Writ of mandamus, my lord.
Threat of mandamus.
The petitioner is working as teacher.
Serial number ಯಾವುದು?
83.
83.
Management to consider the representation, your lordship.
83. Yes, madam. What is this?
The petitioner is working as a teacher, my lord. And he was promoted to the post of senior graduate assistant in the year.
To second respondent management to consider representation. Who is second respondent?
Notice
Teacher.
Notice
School.
ಆಗಿಲ್ವಲ್ಲ ಅವ್ರಿಗೆ?
ಆಗಿಲ್ಲ.
Emergent notice to respondent number 2.
And summons my lord.
ಮಾಡ್ತೀರಾ? Learned counsel for the petitioner to serve the second respondent by way of hand summons, as the second respondent is to answer the prayer. Yes, next.
84, Girish Hirematha.
For the petition.
Surface matter, they have deposited 25%. We have handed over the house key. ಹೌದು. They have put it in possession yesterday. Further 25% Melas within 4 weeks.
It's very difficult, my lord.
ಮನೆ ಕೊಟ್ಟು ಮನೆ
8 weeks.
ಅಲ್ಲ, because
this court on 13/2/2025 had passed the following order. In terms of the order so passed, it transpires that the learned counsel for the respondent bank submits that the order has been complied and the petitioner has been restored possession of the house. In that light, the interim order stands extended subject to the condition that the petitioner would deposit another 25% to the bank in the next 8 weeks.
Next week, my lord.
In the next 10
year
weeks.
end ಇದೆ.
10 weeks.
ಅಲ್ಲ, March 31st ಒಳಗೆ.
ಅದೇ ಅದಕ್ಕೆ
ಸಾಕು ತಗೊಂಡಿದ್ದಾರೆ.
10 weeks.
ಬಡವರ ಹತ್ರ ಬಿಟ್ಬಿಡಿ ಸ್ವಲ್ಪ ದಿನ.
25% March 31st.
On or before the 30th of April 2025. Yes.
Please.
85 Prashant Gowda.
Poor people ಮನೆ ಬಿಟ್ಬಿಡಿ ಸರ್ ತೊಂದ್ರೆ ನೋಡೋಣ.
This is a recovery certificate.
That would not mean that would not mean that the equal monthly installments that the petitioner has to pay can be deviated. In the event he deviates, the petitioner would deviate payment of EMI. The bank is at liberty to take action in accordance with law. ಇದು arrears ಮಾತ್ರ, default payment ಮಾತ್ರ. Yes.
Please, ma'am.
Covered by this.
Covered by? What covered by?
Interim order.
Interim order.
Interim order covered by?
No, sorry. Recovery certificate issued, ma. I am told last time this central government is not releasing and they are.
ಅದೇ farmers ಇದೆನಾ?
Yes, yes, ma.
ಎಲ್ಲಿ farmers ಕೊಡ್ತೀವಿ ಅಂತ ಹೇಳಿದ್ದೀರಾ?
ಅಲ್ಲ, ಅದು ಮಂಡೇ ಇದೆ. ಇದು only recovery certificate. 50% same.
Madam, same order ಇಲ್ಲಿದೆ. Interim plan ಕೊಡಲಿ.
Those two cases I have filed affidavit.
Like that. Same.
86 Vidyashankar Ji Dalwai.
Case, Anganwadi worker, my lord, she had applied. Her form came to be rejected only based on residential certificate was not uploaded. I filed an objection, my lords, stating that on 26th, when there was a opportunity to rectify, they didn't intimate me, my lords, to rectify. Even my residential number, my lords, is uploaded. ಇಲ್ಲ ಕೊಟ್ಟಿಲ್ಲ ಮೇಡಮ್, ಅಪಾಯಿಂಟ್ಮೆಂಟ್ ಆಗಿಲ್ಲ ಇದು.
Provisional list is challenging, Your Lordship.
Provisional
Please,
selection.
Your Lordship, provisional
Yes, yes.
selection.
Consider the objections.
Your Lordship, the residential certificate is the mandatory requirement, Your
Correctly,
Lordship.
ಕೊಟ್ಟಿದ್ದಾರಲ್ಲ, consider the objections.
Let the petitioner
Milords,
file objections to the.
Milords, in my application, Milords, the residential number is notified, Milords. Yes.
Residential certificate ಕೊಟ್ಟಿದ್ದೀರಾ ಇಲ್ವಾ?
ಇಲ್ಲ ಅಪ್ಲೋಡ್ ಆಗಿಲ್ಲ ಅಂತ.
No, Your Lordship.
We are ready to give. My number is uploaded, Milords. Residential certificate number is
You did
uploaded.
not upload it.
Milords, I oversight the computer guy, Milords, has not done it.
Guy?
Yes, Milords, where I went to get the applications.
Cyber center.
Please.
Cyber center.
Yes, Milords.
Oh.
And for that I filed objection. 26 hours time given to rectify, but they didn't intimate me, Milords. Without that, Milords, they stated that you are not produced the residential certificate. In spite in the application, Milords, the number is there. At page number NHSC, Milords, residential certificate number is there, Milords. It has been uploaded. At page number 23, Milords, NHSC.
ಎಲ್ಲ ಸ್ಟೇ ಮಾಡ್ಬಿಡ್ತೀನಿ.
ಅಲ್ಲ,
Entire selection
residential,
process.
no, Your Lordship, presidential certificate is
ಅವೆಲ್ಲ
mandatory, Your Lordship.
ಮಾಡಬಾರ್ದು.
ಅಲ್ಲ, ಅದು mandatory document, Your Lordship.
Correct.
Without that, Your Lordship, the application cannot be considered, Your Lordship.
Now the,
It's-
no,
Please, Your
you gave time to rectify the rectify the defects.
In the scrutiny only, Your Lordship, it's get rejected, Your
Fill
Lordship.
time ಅಲ್ಲಿ ಕೊಟ್ರಾ?
Illa, Milords, they state that on 26 they have given, but they have never informed me or nothing has been done,
We-
Milords.
we-
I have stated in my application regarding that.
We don't
They have not
inform
given
them,
me
Your Lordship.
opportunity.
In the scrutiny level only, Your Lordship, defected applications will get rejected, Your
The
Lordship.
information.
Please,
Monday. press
please.
Please, interim order is there, Milords, not to finalize the list.
ಇದೆಯಾ already?
The interim order, not to finalize the list antide, Milords.
ಅಂತ ಕೊಟ್ಟಿದ್ದೀನಾ?
Yes, yes, Milords.
ಕೊಟ್ಟಿದ್ದೀನಿ.
Yes.
Monday, madam. Next Monday, 3rd. Yes. Interim
This,
order ಕೊಟ್ಟಿದ್ದೀನಾ?
Milords, this Monday, Milords.
Interim order subsisting will continue to the next date of hearing.
On 3rd, Milords.
3rd? Yes.
This Monday, Milords.
3rd ಕೊಟ್ಟಿದ್ದು. Yes. Yes.
This
Interim order ಇದೆಯಲ್ಲ? ಇಲ್ಲದೆ ಇರೋ ಕೇಸ್ 80? ಸಿರಾಜುದ್ದೀನ್.
Milords, 30 years conviction, Milords. He has already
30
undergone
years
19.
conviction.
30 years ಆಗಿದೆ.
30 years ಇಲ್ಲ 19 years ಆಗಿದೆ.
No, Milords, 19 years.
Court order
ಆಗಿದೆ,
is
Milords.
30 years. 6 months
Conversion of
ಕೊಟ್ಟಿದ್ದಾರೆ.
conviction is life sentence in 30 ಗೆ?
30.
Yes, Milords. And the coordinate bench for the other co-accused has granted 90 days, Milords.
The
That
petitioner
order-
is before this court seeking. Who is the petitioner, sir?
Petitioner is the mother, Milords.
Huh?
Petitioner is the mother of the prisoner, Milords.
The petitioner, the mother of the convict, is before this court seeking release of her son on grant of parole. The learned counsel for the petitioner submits that the coordinate bench has granted parole to the co-accused, who is also undergoing imprisonment for 30 years for offense punishable under section 302 of the IPC. The coordinate bench has held as follows. Just copy paste ಮಾಡಿ. In the light of the coordinate bench granting parole to the co-accused on the same footing, and I deem it appropriate to release the petitioner on parole. Same order of condition.
Oblige,
Yes.
Milords.
Next. ಏನ್ madam ಇದು? Babji.
230 mood list, till number 1, Sachidanand Babaji.
ಏನ್ 17 ಮ್ಯಾಟರ್ ಮೂವ್ ಮಾಡಿದೀರಾ? 17 matters.
15 matters, my lords.
15?
Please.
15 why?
My lord, in this batch of matters, my lords, the petitioners, my lord, they had actually, they were part of a cheat group, my lords. Subsequently, they defaulted in payment of cheat amount. My lord, checks were issued to the second respondent. And subsequently, when they came to be dishonored, NI Act proceedings came to be instituted. Subsequently, in the NI Act proceedings, the matter came to be settled and a joint memo was filed before the open court. And the dispute was put to rest, my lords. My lord, now, after 3 years of filing of the joint memo, now petition before register of chits under section 64 is filed based exactly on the same points, seeking for relief, the same relief which is already given, my lords. Now the proceedings before the arbitrator in all these 15, my lord, when say under section 64,
64.
64, my lord.
CFA. The petitioners in all these cases are, you were running chit fund, is it?
No, my lords. We were a part of a chit group. We were successful subscribers.
Where the successful subscribers of a chit group, the group gets into default. Proceedings are instituted against the group before the consumer forum.
No, my lord. Before the NI Act court, my lord, CC.
Yes.
Before the negotiable instruments.
Proceedings were instituted against the members of the group, including the petitioners, and for dishonor of the checks that they had issued, invoking section 200 of the CRPC for offense punishable under section 138 of the Negotiable Instruments Act. Next proceeding again.
My lord, subsequently, that the joint memo was filed in those proceedings, my lords, in all the 16
Current
cases.
counsel for the petitioner submits that in the proceedings before the concerned court, where the offense under section 138 of the NI Act was tried, a joint memo was filed by the parties. And the matter was settled.
Please.
The matter was settled and entire dispute was laid to rest. After about 3 years, it transpires that on the very same cause of action that had stood settled and closed, proceedings are instituted before the
registrar
under
section 64 of the Chit Funds Act.
Under section 64 of the Chit Funds Act. Therefore, the petitioner is before this court calling in question the initiation of proceedings before the registrar under the Chit Funds Act. In the light of the aforesaid submission, there shall be an interim order of stay of all further proceedings before the registrar in all these cases.
Please, my lords.
Respondents are.
My lord, for respond number 1, AJ, my lord. Respond number 2, panel counsel, Shivraj Balloli. My lords, for respond number 3 to 5, they were the guarantors, my lords. I will file a memo for dispensation. No, my lords.
All right. Memo.
Please, I'll file a memo.
Counsel for the petitioner files a memo seeking dispensation of service of notice to
my lord, 3 to 5. Yes. Please.
Dispensed.
Grateful, my lords.
The certified copy of this order shall be released only after compliance with the office objection.
Please, my lords, I would only request if the no, my lords, my lord, the only urgency is if only the operative portion could be uploaded, my lords, because now tomorrow it is kept for
the interim order. Other operative portion,
my lord, if it is ordered to be uploaded, my lords, tomorrow the proceedings are before the arbitrator.
Comply with the office objections now.
Yes, I'll do that, my lords. Yes. Tomorrow I'll do that, my lords, please.
Office objections to be complied with by the evening of tomorrow, failing which the interim order would stand automatically vacated. Copy upload.
I will comply with the objections and I will obtain copy. If only the interim order is uploaded, my lords.
Final order la interim order.
Yes, please.
Okay, we'll permit you till Monday.
Please, my lords.
Monday sankal madde hodre office objections, interim order gets vacated.
Please. Grateful.
Signature madila papers ga.
Well, I've signed, my lords. There are 15 of them. Some
no covered matter. Yes.
Apologies.
Next. Continue.
88 Saurabh Hegde.
Lord, this is with respect to BVB College, my lord. Yesterday. Lord, this is with respect to that BVB College, my lord. Yesterday, my lord has caused the notification. That was a transfer notification, my lord. Now we were the ones who got transferred from BVB College to other.